I'll just do a very short introduction because we're already off to a couple minutes late start, but second day of conferences I think is always soon. People won't be here at 8:50 sharp, soon, especially in Hawaii, I'm sure. So we're grateful that you made it at all. Thanks for sticking around. So we hope you had a great first day, and we're able to get some questions. And then to get us started with our fourth panel. So before I do that, I just want to let you know, I mentioned the brochures yesterday, so I grabbed them and put them up here. So if you're interested in, for yourself, your students, learning more about graduate international programs, please feel free to take a couple back with you. And then also we were boiling hot water for tea, so that will be ready in the next 15 minutes. Oh, it's ready. Okay, so if you want to sneak out and grab tea, if you're not a coffee person, it's out there. Okay, so we're gonna get started. Soft apologies, we used Andrew's part for his moderating role yesterday, so if you want to remember, that's Andrew Morris. Andrew Morris is a lawyer and economist at Texas A&M, where he's on faculty at the School of Law and Bush School of Government and Public Service. And his co-author on this first project is Charlotte Koo, who's a professor of law and director of global programs at Texas A&M. So I will stop to the side because we have a packed stage, but let's go ahead and get started. I'll give you all maybe a 5-minute warning. Okay. 1 minute.
Great. Okay, so your reward for coming early is that I have a lot of graphs, a little bit of math, and international tax. So I want to run away. So we started looking at the effects of building legal infrastructure to integrate countries into the global economy, and pick Africa as the place to look at because it has a couple of nice properties. So the question we want to answer is, how does having more formal legal connectivity help or hurt countries in development? And so we're going to we have some data to test that with, but this is the basic theory. So one is that there's a U-shaped curve of integration into the global economy. So when you're a colony, you're very well integrated. You're not integrated in a way that's good for you necessarily because the rules are set in London or Paris or wherever. But if you are a business that is opening in, say, Nigeria, while Nigeria is a colony, and you have a question about the tax rules, there's someone you can ask. It's the British government, and they will answer it, and those rules will be set to benefit the Britain, not Nigeria, but there are clear rules. So there was no question what the tax and investment rules were during the colonial period. And then when you become independent, most African countries on independence said, we don't really want foreign investment. And so we have lost those formal legal ties to our former metropolitan power, but they did not yet replace them with substitute treaty networks, which they did later. So the rise of integration is after the 70s, and people say, well, actually, we would like some foreign investment. You start to get a tax treaty network developing, an investment treaty network developing that substitutes for the colonial network. In terms of sovereignty, you go from having no sovereignty while you're a colony to having full sovereignty when you become independent. So there's a second layer to this. And then the third layer is your effective sovereignty actually declines when you join the network, both because you're ceding sovereignty to the rules established by the network, but also because, can't really see it, but this is the era of OECD dominance. The tax treaties are largely written by a club, the OECD, which is a club of wealthy countries, right? So the OECD model treaty, which is itself the basis for many developed countries' treaties with developing countries, and is the basis for the US model treaty and the UK model treaty, which have some idiosyncratic things about themselves. But those are often presented to developing countries who take it or leave it. One of the most interesting things is South Africa, when it signs treaties with other developing countries, uses the OECD model. When it signs treaties with OECD members, it tries to use the UN model, which is a much more favorable to the developing country treaty. So that a clear recognition on South Africa's part, when we're the developed partner in this, we want the advantages of that. And what tax treaties do is they allocate taxing rights and provide certainty. So this is what in 1951, this is the networks. So this is the French network, right? You're a colony of France, you're connected to France. Now France did lump a number of its African colonies into sort of federations, and so we put some little dotted lines there. There's the British, the Portuguese, the Belgian, and the sort of isolates of countries that aren't. And so Africa is pretty integrated into the global economy, but it's integrated through its colonial relationships. By 1961, when we had sort of a burst of independence, there's a lot of isolates now. A lot of countries that used to be connected are now disconnected. And even the ones that are still, connected, there's starting to be some little bits of treaty connections. So Malawi has a treaty with Sweden. The Nordic countries are quite collectively and individually have signed lots of tax treaties with us. They seem to have interest in building formal connections. And then this is the early 1970s. Unfortunately, you can't see behind the panelists, but the French network is down here in blue. Right? These are countries that are only basically still connected to France. 10 years after independence. The British colonies, which are in red, are a little more connected. The gray countries are places that are not either British or French colonies. And there's a little bit of connection, but there's not much. They're still in the 70s. They're not very connected. That's so starting to climb out of the trough of the U. And then this is today. And then you can see the French down here in blue are still largely disconnected. Former French colonies do not have this formal legal infrastructure in place. The former British colonies have a little bit more. The former Portuguese and Spanish colonies, not so much. But they're not much connected to the rest of the world. The people in here, the countries in here tend to be Europe and the OECD members, but much of the rest of the world, they're just not very connected. So there's still a long way to go in terms of developing that, but they've climbed back up on that year. So there are 4 countries that we looked at that are treaty hubs: Mauritius, the UAE, the Netherlands, and Belgium. And those countries deliberately signed treaties with lots of countries. And here's the really fun part of my talk, which is where we're going to talk about the details of international tax. I'll try to talk softly so that you can go to sleep. But these treaty hubs are very unpopular with certain groups. So the Tax Justice Network, for example, has a campaign to get African countries to cancel their treaties with Mauritius. The argument, and this was running on the 2010s, and this is the 2019, but it's a highly corrosive because Mauritius's tax policies on corporations are highly corrosive to the global economy. So these are a bad thing. They're depriving African countries of tax revenue. So we'll talk about why that is. So the way a treaty hub works is you have a country of residence of a business, and it will establish a business there will establish a business in the treaty hub, which will then do business in the developing country. And so your investment will flow through this treaty hub, and the treaty between the treaty hub and the residence country, say France or Germany or the United States or wherever, will say that we're not going to tax those flows. Then, these people can always tax stuff, right? But the treaty hub says we're not imposing any taxes, and we're not imposing any taxes going this way either. And when we sign the treaty with the developing country, we agree that we get to tax things like capital gains that accrue in this. And in the case of Mauritius and Dubai, they don't tax capital gains. So they have the right to tax it, but they don't actually tax it, right? So then, and they also don't tax payments out. So the money can flow in and out with minimal levels of tax. And this is the criticism the Tax Justice Network and others is that, well, this money is not being taxed. Well, it is being taxed back here. When it eventually gets back here, if you're routing through a treaty hub from the United States will take its share when you bring it home. It just may take a while for it to get home. So it's not true that it's not taxed at all. It's just not taxed until it gets to the residence country. And if you can hold off, if you can delay taxing for about 8 years, people think that's about essentially the same as not being taxed at all because it's grown in your bank accounts here. And then really exciting, the Netherlands and Belgium have something called the participation exemption. So the Netherlands and Belgium have tax systems for Dutch and Belgian companies. So if you're operating in the Netherlands and Belgium, company will pay taxes. But if you're getting royalties or dividends, they don't tax those. And so your dividend payments can come back from the subsidiary through the Netherlands. The Netherlands will not tax them. And then they will flow on to the owner. So it's effectively a very low or zero tax regime through this detail of it. So they have formally we tax everything, but then we give this participation exemption. And final tax detail, this is all about deciding who gets to tax. And the key to that is, do you have what's called a permanent establishment in development? And so if you start off just shipping goods to people in a developing country, you haven't done anything in that country to get taxed. There might be sales tax or something like that, but that's going to be the responsibility of the customer to deal with. If you establish a warehouse, now you've got a presence. That's almost certainly a permanent establishment, and you will be taxed by the developing country on some portion of your profits that is allocated to the operation of the warehouse. And so people get into arguments about how much that is. And then if you eventually set up a subsidiary there, you've definitely got a presence now, and you're going to have to pay taxes. And so you can get into transfer pricing arrangements to try to put the profits in the places. But the point of the tax treaty is it gives you certainty about what the rules are in deciding who has a permanent establishment and where. And just as an example of how nuanced this can get, there's cases where if you have a salesman who goes to visit customers and they stay in the same hotel every time they go, they find a hotel they like and they stay in the same hotel, that can become a permanent establishment. So it's important to have clear rules. All right, so lots of people do this. So this is the guitars for U2. U2 moved their music publishing to the Netherlands to take advantage of the participation in I think a better thing than any of their lyrics. He said, of course, we're trying to be tax efficient. Who doesn't want to be tax efficient? Right. So this is a widespread thing going on. Our theory is that these places fill what are called structural holes in the network. So you've got a network. So here's my treaty with the former colonial power, which is typically the only treaty lots of African countries have. You can connect through there. So if you're trying to invest into Nigeria, Nigeria has a treaty with Britain, you can go set up a British company and do it, and you can try to work with British tax system. If there are other countries Britain doesn't have a treaty with, but Mauritius does, when you sign up with Mauritius, you get access to those. So that fills the hole. So this is an example. This is Mali. Here are Mali's actual treaties. There's 5, but if you add in Mauritius, it gets all those other places. So lots more in this circle than that circle. Here's Mali using the Netherlands. Again, adds access to lots of the world economy. Kenya using Dubai, lots of stuff there. And there's a statistic you can calculate in network analysis called effect size, and it goes from 0 to 1. 1 is big. If you sign a treaty with any of these hubs, it's almost a 1. So it's big. So do they affect economic growth? Do they boost growth, or do they starve revenue? So there's a lot of literature on the effect of tax treaties and of investment treaties. It's mostly looked at the effect of those treaties with particular partners. We looked at them with treaty hubs, and we did what's called an event study. So you take the time the treaty signed is time 0. You look at the 5 years before, the 5 years after, and compare how things are going. And here's the math. An economist, I'm required by law to show you an equation. All right, so the challenge with this kind of thing is what we'd like to see is that there's no trend before signing up and that there's a clear change in the slope of the line afterward. But there might be a pre-trend, right? Maybe you sign a treaty with people because you're already doing lots of trade with them. Or it could be both, right? You could have an increase and you could also get an effect. So that's what we're looking for. We want to see either this or this if there's an effect, and we want to see this if there's no effect. So do hub treaties improve economic outcomes? The short answer is yes. This is error bars. It's statistically significant that the slope gets more positive afterwards. This is an interesting finding. It's not a pure literature because nobody's really looked at these hub treaties the way we did before. If you just look at investment treaties, there's no effect there. That makes sense. People are not worried about expropriation as much anymore. You look at them both, the tax treaty effect dominates. Does it starve the government, so worsen poverty? No. There's no, if anything, this is you want to go negative is good, the number of people in poverty, measuring that. It's not getting worse. It may be getting better. the investment treaties don't seem to matter. Combining them doesn't seem to matter. Do they worsen social welfare? We looked at maternal mortality ratios. Again, you want to get worse. It's pretty much the same trend. It's not making things worse. It's not making them better, but it's not making them worse. So it doesn't seem that being starved of tax revenue is having an effect. And this is the bits and the maternal mortality. So there's a so I hit the time.
Yeah.
Thank you.
1 minute under. Thanks for the question. So Andrew Larkin is on the Lawrence faculty at NYU School of Law. You don't have slides, right? So I'm gonna.
No, I don't. Hopefully this will.
It's fake from a computer here. Is it? I'm gonna try it, and then maybe block it. Is it just slides? Yeah. That's if I did 5 minutes, what about we? Okay, so slide.
Sorry, everybody. Thanks for bearing with me. Beautiful. Thanks. Thanks, Rich. All right. So I'm talking about a paper called The Takings Counter-Revolution. And it's an international investment law paper, despite the fact that I used the idiosyncratic US expression for expropriations. One of the first, I feel like a lot of people here like ventured into legal arenas that they're unfamiliar with. And I'm just being parochial and American. And so unlike other people drawing on, expertise to challenge what they tried to do, I'm hoping to broaden my horizons a little bit. For those of you who don't know, the international investment regime is a network of about 2,600 treaties currently in force with broadly overlapping provisions, mostly bilateral, some multilateral, which give investors an individual right to bring claims directly against governments when governments take actions that they feel harm their investments in those countries. They can bring claims for expropriation. They can argue that they were treated unfairly and inequitably under most of these treaties. And they can bring these claims before a tribunal of 3 arbitrators who can often private lawyers, occasionally academics like you in this room. And they can win substantial damages and awards which are enforceable around the world. So it's a very controversial regime. It's generated a lot of attention because of the size of damages awards. It's generated a lot of criticism about the approaches that arbitrators are adopting, the substantive legal tests that they're using to decide whether or not a state measure, something a state did to an investment, was permissible under these investment treaties. And in context of this criticism, there's been a lot of effort to sort of get the balance right? What tests should arbitrators be applying? How should they be applying it? How can we tinker with treaty standards or institutional designs to sort of get these things right? One of the things I'm trying to do in this paper is reframe that discussion a little bit, first of all, by offering a new perspective on what triggers liability under investment treaties. And the basic claim I'm making is that the best predictor and the sort of across substantive standards, the thing that arbitrators seem to be most concerned about is the investor making less money? Did the state do something that interfered with the profits that the investor was expecting to make through the investment project? Or was it a project that failed due to market forces, in which case there's no liability or something else? That account challenges conventional understandings of the substantive law of the substantive international investment law and offers 2 new implications, I think. Offering a new way to situate investment law in terms of comparative constitutional law and making it look much more controversial as a result. And also raising new concerns about ways in which investment law might persist outside of the framework of arbitration under bilateral investment treaties through an international investment court or through domestication through domestic investment ombudspersons that can resolve investment disputes at the national level using these same disciplines. So let me talk first about what I mean by, in terms of this unified standard of liability. most people think mostly about expropriation when they think about investment treaties. They think about the obligation of a state to pay compensation when it takes a foreign investor's property. Expropriation case law has been substantially influenced by decisions by the Iran-US Claims Tribunal, which basically focus on the effect of a state measure on the investment in terms of assessing whether or not it was expropriated. Did the investor lose substantially all of the assets that it had? With reference to the sort of internationalized test for what an investment is. It's not just the domestic law rights, it's something more than that. It's the project that you were trying to build in whatever fashion you were trying to build it. So expropriation nominally applies something like a modified Penn Central test, whereas other treaty standards like fair and equitable treatment and umbrella clauses or clauses which require states to abide by obligations they entered into vis-a-vis investments supposedly look to other bodies of law. FET often draws on administrative law concepts like proportionality, due process, protection of legitimate expectations to some extent. Umbrella clause analysis often purports to look at things like a government's obligation to abide by contractual obligations it's entered into. But across a number of cases, the way that these tests are being applied basically looks at whether or not an investor's expected returns were materially impacted. So if you look at Iser v. Spain, one of something like 60 cases against Spain challenging the alteration of its tariff structure for solar energy generation, the tribunal in the original case essentially decided that a Spanish measure was disproportionate because it materially impacted the investor's expected returns. So this administrative law concept, which should turn on more contours than just whether or not an investment was impacted, seems primarily to turn on the fact that an investor is making less money. Similarly, umbrella clause claims challenging changes to regulations, to legislation, have turned on the fact that measures like Spanish tariff regulations change to the detriment of an investor's expected profits. So what you see is this full effects test that looks only at the economic impact of a measure on the investment, sort of migrating out of the expropriation context into these other substantive areas of international investment law, and leading to liability decisions against states whenever they do anything that harms an investor's expected profits, operating in more or less as a prohibition on partial regulatory expropriations. We can see this beyond the substantive standards too. Arbitrators, in deciding which test to apply, often look at whether or not an investor was harmed by state action. Investment arbitrators often apply the well-known distinction between acts Uri Imperiae and acts in a commercial capacity. And there's more deference to state acts in a commercial capacity. So when a state is party to a contract, it has some latitude to behave as any other contracting party would, including in breaching a contract, without necessarily giving rise to liability under an investment treaty. However, when it acts in its sovereign capacity, investment treaty liability is more likely to be triggered. If you contrast cases in which states terminated contracts, states are more likely to be liable, and states are more likely to be found to be acting Uri Imperiae if they did something that interfered with a viable project. So if you look at the Occidental versus Ecuador case, an oil operator assigned its economic interests in an oil exploration project, in an oil development project, to another company without required authorization from the state of Ecuador, leading to the contract being terminated. That was deemed to be an expropriation in an act Uri Imperiae. But other cases, a long body of cases recognizing that states can terminate contracts according to their terms without triggering an expropriation claim, have consistently been cases in which there was no economic value in the project in the first place. A good recent example is Lopez Goin, where, again, a hydrocarbon exploration project, a contract for hydrocarbon exploration was terminated because after years, the investor had never found anything, a requirement for the project to go to the next stage. So digging a dry well, terminating a contract for digging a dry well didn't trigger an expropriation claim, but there was nothing lost. The liability turned on essentially the fact that there was no, or arguably the choice to apply the test the arbitrators applied turned on the fact that there was no economic harm. And lastly, I think that the fact that investors themselves decide when to bring these claims, the fact that bringing these claims in the first place can arguably impact economic flows, investment flows to host states, suggests that the basic design of the investment regime empowers, basically protects against anything that investors deem to be contrary to their interests. They can deal significant harm to host states just by filing a claim, which they can do whenever their economic interests are harmed. So again, it looks like a regime that just provides an absolute level of protection to expected profits. That provides a new comparative perspective on the international investment law project. There's a lot of early scholarship talking about the US Penn Central test in context of these expropriation cases. Some of it's positive, some of it's negative, right? You don't have to exhaust local remedies as in US takings law. It's easier to go directly to arbitration. And so it's more expansive. Even though they purport to apply the US's regulatory takings test, they're being more expansive. Or they're adopting a silly test. Penn Central is a bad decision. It's strange that arbitrators are paying lip service to this weird regulatory expropriations test that the US Supreme Court developed in the 1970s. But adopting my framework for understanding liability in investment law suggests that that is the wrong point of departure. In fact, the standard for liability, looking at all of these treaty standards together, is absolute. If you interfered with the money the investor hoped to get, you're liable. To me, that looks more like a much more controversial theory of expropriation. And to provide context, I turn to Richard Epstein's 1985 monograph, Takings, where he argues that essentially any interference with property rights should be compensable, and draws the conclusion that any sort of government redistribution, any sort of government tinkering with winners and losers in the economy is constitutionally impermissible. You can't redistribute wealth because that's a taking, and you would need to pay off the people who you were taxing at a higher rate for the taking of their wealth. I argue that that logic, which has not been adopted by any welfare state, essentially by definition, offers a better account of what's actually happening in international investment, suggesting new normative challenges to the regime. And those challenges, lastly, pose a problem because the international investment law regime isn't going anywhere. There's a big backlash against the treaties themselves. The number of treaties in force has declined significantly over the past decades. But there's no automatic reason to think that these problems will go away through creating an international investment court or through domesticating these disciplines through a national investment ombudsperson whose job is to essentially draw on international investment law disciplines to resolve investment disputes as they arise. So essentially, this project looks more like the rehabilitation of a widely rejected and fairly controversial approach to takings than a reasonable global governance measure. This is a very early stage project. If anybody's looked at the draft, I think that is fairly obvious. So I'm open to suggestions, comments, criticisms. I do want to caveat that I'm not purporting to account for every single investment law decision, but I do think that this predicts trends in how the field is better than most. Thank you for your time. Thank you for bearing with me with that slides.
So, next we have Ornelli Chowdhury, a professor at Osgood Law School and director of the State Center for International Human Rights, Crime, and Security.
Just
Should make sure it's working. Go ahead, try. Yeah.
So thank you to the organizers for having me here today. So my presentation is really about this topic here on international investment law and sustainable development. And the question I ask is it friend or foe? Now, Ali's already convinced me that I did not answer this question, but I promise you it is answered in the final paragraph of my paper, if you can make it all the way through. The short answer is it's both, right? There are some friendly elements to it, but it is also foe-like. But why are we talking about sustainable development in the context of international investment law? We need to go back and talk a little bit first about economics. So we know that conventional economic theory does tell us that foreign direct investment is important to having states meet their sustainable development goals. And so according to economics, we absolutely need FDI if we're going to achieve our SDGs. And one of the tools that we can use to get our SDGs are international investment treaties, although I'll talk about whether that's true in just a moment. But our problem is that these treaties have this sort of questionable relationship with sustainable development. So I don't think I need to tell this audience, but I'm going to do it anyways. We're just a reminder that sustainable development does have three elements. So it's economic, social, and environmental. And as the UN constantly reminds us, if we lose one of these balls, as they call it, we have to keep the three balls in the air of all the three elements. And if we lose one of the balls, then the game is over. And the UN also tells us that the goals of sustainable development can't be met unless we have private sector involvement. And the costs of meeting the SDGs are estimated at between $5.4 and $6.4 trillion per year. So we absolutely need business involvement in this area. But it's important to remember that the link between FDI and sustainable development is not automatic. We heard a little bit about that yesterday. In some cases, we know that FDI can exacerbate social and environmental problems. And so we know that the FDI can actually generate some trade-offs among different sustainability objectives. We also know that there are lots of factors that enable a state to be able to attract FDI. International investment agreements, or IIAs, as I'm going to call them, they can help, but the evidence that they are the ones to be able to help a state attract FDI is equivocal. So we do have to sort of keep that in the back of our mind. But nonetheless, as we just heard from Andrew, states are loving these items, and so they keep signing international investment agreements, and there are more than 3,300 of these agreements in the world today. Now, because states are such big fans of IIAs, the potential for these agreements to have an impact on sustainable development is pretty immense. But both the substance and the process of these agreements do have the potential to thwart sustainable development. And that's because the treaties are really designed to safeguard foreign investors' property interests. And so they give more attention to property protection, and I would say very little attention to any other interests, particularly when we're talking about social and environmental issues. And we can say this in a couple of key provisions. So the first we'll look at are the definitions of investor and investment. And really these agreements extend protection to a very broadly defined definition of both investors and investments. So investors really can include a wide range of entities, natural legal persons, state-owned enterprises, trusts, partnerships, joint ventures, and the list goes on and on. And similarly, for the definition of investment, it's also defined relatively broadly, and it can often extend coverage to every kind of asset. And because the terms investor and investment are defined so broadly, there's lots of businesses that are able to seek protection under the IIAs, even when their contribution to sustainable development is pretty negligible. So I would say the most notorious example of this is Philip Morris, the tobacco giant. So it restructured its operations to gain access to an IIA with Australia because it wanted to challenge a tobacco control measure that Australia had put in place in order to protect the public health of Australian citizens. All right, so a second area in which we see sustainable development not necessarily aligning with international investment agreements is really in the standards of treatment. So Andrew's already alluded to this. I'm just going to talk about these briefly. But I would say the biggest area that is an impediment in IIAs is fair and equitable treatment. And that's because no one really knows what that means. So the standard is written in relatively vague and expansive language, and that means it leaves a lot of room for broad interpretations by investment arbitral tribunals. So the wording of the FET standard, the fact that it's defined in such broad language, has allowed tribunals to demand a very long list of extensive conduct from states, and that's really tied their hands and limited their ability to regulate on sustainable development issues. Fair and equitable treatment is also problematic because it's the most frequently invoked standard of care in ISDS disputes, with developing countries disproportionately being the respondents in these cases. Now, a second standard is expropriation. So Andrew's already talked about this in great detail. I'm just going to talk about it from a sustainable development perspective. So as he mentioned, there are two types of expropriation. So there could be a physical seizure of assets. That's what we call direct expropriation. But I'm more concerned with indirect expropriation, which is really the deprivation of investment, but without the formal transfer of title or seizure. Now, from a sustainable development standpoint, why do we care about indirect expropriation? It's because regulations that are oriented towards protecting sustainable development goals can sometimes be constituted as indirect expropriation. And that means in those scenarios, the state either has to compensate the foreign investor for regulating on a sustainable development issue, or they have to withdraw the measure altogether. Now, tribunals have taken really three different ways of looking at these kinds of indirect expropriation. So one is they focus only on the effects of the state regulation. Two is they can engage in a proportionality analysis. Or three, the best case scenario from a sustainable development standpoint is that they invoke what is known as the police powers doctrine. So this doctrine allows that if a regulation is enacted for a public purpose and with due process of requirements being met, that it will not be considered an expropriation and therefore compensation will not be due. So while that is the best approach, unfortunately, tribunals don't necessarily apply this doctrine in a rigorous or, shall we say, uniform. And another problematic aspect of these IIAs is the privilege that they grant the foreign investors to directly sue the host states for any interferences with their investment. Again, something that Andrew's already mentioned. So ISDS, which is Investor State Dispute Settlement, has been enthusiastically used by foreign investors. So just to give you some numbers here, there are more than 1,300 of these claims pending, and there's a growing proportion of them that target developing countries. There are more than 80 investors from developed countries that have sued more than 60 developing countries. The average compensation is around $385 million. And there is little room for affected stakeholders. So in particular, communities that are affected by investment arbitration often have very little role or little say in these disputes. And then the final thing I just wanted to mention here was there was a study done by a colleague of mine who looked at how is sustainable development used in these ISDS cases. So he found that there are 6 out of 600 publicly available ISDS documents. There were 91 awards that referenced the term sustainable development, but only 15 of them actually engaged with the concept. So his conclusion is that in ISDS, sustainable development is used by arbitrators only in a marginal and a problematic way. So what are the sustainable development implications of IIAs? So we have a couple of problems here. So first is that they're increasing the cost of sustainable development goals. So it makes it more expensive for states to be able to implement these types of regulations. So Andrew's already alluded to Spain, which decided to reform its renewable energy subsidy program. That has triggered 51 investment arbitrations. And so far, Spain has been ordered to pay about 1.5 billion euro in compensation. And there are still 8 arbitrations that are going on. Second is that because of the potential liability that states face under investment arbitrations, they may fail to regulate sustainability issues at all, something that we call regulatory chill. So Denmark, for example, decided to delay its fossil fuel exploration phase out to 2050 instead of 10 to 20 years earlier because it was worried about ISDS claims. States may also be taking a risk-averse stance to regulation. That is, they choose less stringent sustainability legislation because they believe it won't trigger an ISDS claim. And at the same time, we have companies that are using ISDS payouts to engage in what I call further sustainable development busting projects. So there's a British company called Rockhopper, which got a payout from Italy for 190 million euro, and it announced that it was going to use that money to fund another oil development project elsewhere. So that award has been nullified, but that's just to give you a sense as to what's going on. So mindful of these issues, right? Obviously, states have said, okay, well, look, we got to do something about this. So they tried to proactively counter some of these sustainable development issues by putting in provisions into IIAs that are really supposed to address sustainable development issues. So I'll just give you, I didn't get a chance to go through all of them, but I'll just give you a sampling of what's going on. So one of the common things that states do is they put it references to sustainable development into their preambles. So they say this is really important about why we have sustainable development, or we can have things like non-derogation provisions. So that says the state is committing not to lower its standards within its country in protecting sustainable development as a way to attract further foreign direct investment into their country. So both of these provisions are good in the sense that they, reinforce the importance of sustainable development, but they can also be useful in interpreting other provisions in these agreements. But other than that, on their own, they don't really do much. Other provisions that states are putting in are right to regulate provisions. So that confirms the ability for the state to be able to engage in regulation. So again, it's the wording of the kind of provisions which suggests whether or not this is useful. So a good example is the Cabo Verde-Hungary Treaty, which says that the states have the right to regulate, and that if they do, this will not constitute a breach of the IIA. We also have some countries that rely on exception provisions. So they're taking a page out of GATT Article 20 that we see under the WTO, and they want to insert those kinds of obligations into their treaties. So again, there's been some, I would say, limited success in this area. So Canada's always been like a big proponent of these kinds of provisions. No longer, because there's been a couple of arbitrations recently in which countries have relied on the exception provisions. And while our tribunals have recognized that the exceptions have been met, they still said that compensation was due. So you're not really getting very much under these exception provisions. Maybe a better approach is what we call a carve out. So that is where you remove a sustainable development issue from the scope of ISDS or the treaty itself altogether. So a good example is the EU, which is proposing to carve out energy, material, and products from its modernized energy charter treaty. And really the reason for doing so, if that provision would be put in, is to basically stop fossil fuel investments from being subject to ISDS claims. Another approach is to use an investor obligation. So that is actually requiring some sort of good or CSR kind of conduct from an investor or a corporation when they invest as a foreign investor. So again, it's the wording or how you word these things that suggest whether or not they're useful or not. So only if they're enforceable investor obligations is there any utility at all. And then finally, we have investment facilitation provisions. So these are provisions that really talk about the importance of getting in the kind of investment that is beneficial to the host state. So the best example of this is the ACTA protocol. I don't want to talk about it too much because Ali is going to talk about this in great detail. But this is really, in my opinion, one of the best ways forward. All right, so I have 1 minute left to go. So what do we do to fix all these kinds of problems? So first of all, I think these countries really need to think about do we really need these treaties? So it's not really clear whether or not we need these kinds of treaties in order to attract foreign investment. And they seem to be a pretty big impediment to sustainable development. So is it absolutely necessary to have these treaties in the first place? But if you are going to use this, then maybe you need to think about actually throwing out ISDS for any type of sustainable development provision, limiting it for any type of fair and equitable treatment or indirect expropriation provision as it relates to sustainable development regulations. If you're going to put in an investor obligation, make sure that it's enforceable. And finally, really maybe think about having these kinds of treaties being less for investment protection and more for investment facilitation. Make sure that you're getting the kind of investment that is necessary for your country to meet your sustainable development goals. Thanks very much.
Great. So next we're going to have Ali Karwani, who is a professor of international law at Mohammadi University in Islam. Share.
Good morning, everyone. I'm very glad to be here. First of all, I would like to say thank you to Professor Lee for his kind invitation, and also the Professor Chen and the University of Hawaii. I would like also to say thank you to my previous colleagues, because you facilitate a lot my presentation. I am here to talk about the FCFCTA and also the right to sustainable development within this area, African Continental Free Trade Agreement. It's a new project at the same time of project. To be honest, I am here as an academic, but I'm also within the project as a task force member in charge of the review of the agreement. Through the Article 28 of the agreement, we have a review process, and also within the ad hoc committee in charge of the implementation of the FCFCTA. I'm trying to provide both sides of the view as soon as possible. But I will try to be more realistic. The right to sustainable development is not recent right within the African legal framework, because it was provided by the African Charter on Human and People's Rights in 1981. Jennifer yesterday talked about little. Then if you look on the Article 22 and Article 24 of the Charter, you will find the right to sustainable development. What the FCFCTA provides now, it's very new. It's to embed the right to sustainable development in the investment law field. That is new. But the problem with this implementation is with the capability of African states to reach the objective, the sustainable development objectives. In the report of the UNICA, United Nations African Economic Commission of this year, the report underscores that inclusive development and sustainable development require renewed strategic approaches to accelerate the effective implementation to the FCFCTA also. But as an expert within the FCFCTA, I remarked that we have the tug of war now between the South African states, SADC states. It's regional economic communities. I will talk about that, because we don't have just FCFCTA agreements. But before the FCFCTA, we had a bottom-up approach of economic integration within Africa. Then we have 8 regional economic communities which they were recognized by the FCFCTA agreement also in the preamble. Then the tug of war is about the model, because we don't have a model today within FCFTA. We just import some rules from the international standards, but at the same time, we have been making or we have been drawing up some new standards. That's why the situation is so confused within the FCFCTA. But the implementation of the FCFCTA reflects the goals of a new African economic order aimed at supplanting the sub-regional normative and economic fragmentation among regional economic communities with coherent and unified continental framework. Then this new African economic order wants to create a single market through FCFCTA towards the attainment of sustainable development objectives. But the principal challenge remains that this equilibrium is so difficult, because how can we attract investments in Africa at the same time safeguard sustainable development objective within African states? We can, I think that we can use a specific concept that I explored in other research. It's the law of African market society. I will tell more about this during the exchange session. But what you need to remember is the three key ideas that I want to share with you. The first one is the emergence of binding environmental and social provision in African investment treaties concluded by regional economic committees represent the normative components of this right within FCFTA agreements and leads the crystallization of these rights. Then the step one is in the RECs, regional economic committees, and the second step is in the FCFCTA. The second point is the articulation of the right to sustainable development within the FCFCTA investment protocol to reach single markets reflects a broad trend of creeping codification of these rights across the FCFCTA agreement, conceived as a single undertaking, because within the FCFCTA we have many protocols, not just one agreement. Finally, the FCFCTA framework actively engaged investors' liability in the protection and promotion of the right to sustainable development for peoples and local communities, thereby contributing to localization of the right to sustainable development. And within the localization, we can talk about African market society also and some specific customary rules. Concerning the environmental and social provision within RECs investment treaties and the FCFTA investment protocol, I tried to compare between the different investment treaties, and I found some convergency between the investment RECs treaties and the FCFTA, but I found also the divergence between some investment RECs treaties and also the FCFCTA, and particularly concerning the free movement of workers, because the FCFCTA doesn't recognize the free movement of workers, but through the RECs you can find the free movement of person. It's very common. Also, the consistency between the African investment treaties and the right to sustainable development provided by African Charter exists, but with different approaches. But I want to tell something concerning the climate change clause. You don't find it within the investment RECs treaties, because it's the old generation of investment treaties, but the FCFCTA provides specific provision about that. It's the Article 26 concerning the special economic zone or low zone carbon or free zone carbon. That is the new standards within the FCFCTA investment treaty. What I want to add also is relating to the substantive coherence of the right to sustainable development and the REX and the FCFCTA. The regulation of the conflicts and consistency of the right to sustainable development provided by many African economic agreements represent the main issue. The clause concerning conflicts and consistency within the FCFCTA cannot impeach the confusion and the hinder due to the proliferation of the development models across Africa. I want just to tell specific thing about the African community schools, because within the REX we have also African community schools. Then we have a competition between the DSB, which is the FCFCTA dispute settlement body, and the 5 African community schools. For example, the decision that I mentioned yesterday concerning the East African economic communities, for example, suspend trade agreement between Kenya and European Union. You can have this situation concerning the FCFCTA if some African community schools decided to take a decision against the FCFCTA DSB. It will be very problematic for coherence and particularly for the sustainable development objectives. Also, the role of African Union and also FCFCTA, because it's a body of the African Union, and the REX in safeguarding the right to sustainable developments need to be clarified through the Abuja Treaty, which governs relation between the various blocks. We have at the same time this challenge. We need to overcome these challenges concerning the relationship between the REX and the African Union amid the legal framework of the FCFCTA. I think that we have Article 19, but it's not clear in terms of regulation of the conflicts and the consistency. I want to focus on 2 principal ideas now. It's the drawing of the right to sustainable development within the different FCFCTA protocols of phase 1 and phase 2. Within FCFCTA, we have 3 phases. The phase 1 concerns the protocols on trade in goods, on trade in services, the protocol on dispute settlements. And in phase 2, you can find the protocols on investments, also competition protocol, intellectual property protocol, and in phase 3, you have the digital trade protocol. Concerning the protocol of phase 1 and 2, we have many provisions which you can find some provision concerning the women and youth in trade, and we have a specific also protocol concerning women and youth in trade protocol. The right to sustainable development is considered as a corollary of affirmative action within this protocol. Also, elimination of discrimination against women and youth, promotion of equality and inclusiveness. Also, if you look on the Article 3 of the agreements of the FCFCTA, the principal objective remains the creation of unified market that harmonizes economic integration with the social welfare of all African population. This is the code of FCFCTA, no one left behind. For the issue of the progressive development of the right to sustainable development through the FCFCTA decision-making process, I want just to follow my dear colleague Barnaby, and I want to talk about replacing of fair and equitable treatments standard with judicial and administrative treatment within the investment protocol of the FCFCTA. The idea behind, or the reason behind this, the exclusion of the FED standard reflects the principled stance adopted by African states to prioritize the right to sustainable development over the unfettered freedom to invest and the property entitlements of foreign investors through this new provision. Then, furthermore, Article 17 relating to administrative and judicial treatment clause represents an Africanization of the investment standards and the new way to predict the interpretive ambiguity of fair and equitable treatment, as my colleague said before. I will say just three points. I will conclude. We can say that we have unexpected change, of course, within the FCFCTA, because you can also find a proliferation of self-judging clauses within the FCFTA investment protocol, articles 13, 15, and 20, that they affirm the primacy of states' sovereignty in the pursuit of sustainable development over the protection of investors and investments. Also, the right to regulate within FCFCTA reveals a dual dimension of regulatory sovereignty vested in host states. First, right to regulate in furtherance of development, and second, right to regulate as a remedial response to structural and development. I have a specific case here, but I think that my colleague after me, Irene, will talk about it. OGIEC people is the judgment provided by the African Court on Human Rights. I think that this judgment since 26 May 2017 and the second judgment since 23 June in 2022, the African Court contribute to genuine clarification and confirmation of the right to sustainable development. And in this case, the court analyzed the right to sustainable development through the opposition of protection of environment of Kenya governments and the safeguarding of social and economic rights of the local communities. Lastly, I think that we can observe that within FCFCTA, we have an investment collaborative protection trend through the establishing of the specific mechanism of investors' compliance obligation in accordance with the corporate social responsibility also, but in accordance at the same time of the liability, the specific liability. But the weakness of the FCFCTA exists within the agreement. Why? Because the FCFCTA provide many requirements to the African investors, and they give a special and preferential treatment to the foreign investors from outside Africa. That is, I think, the main issue in the future. How can we handle between the FCFCTA agreement and the BITs concluded between African states and foreign investors from around the world? And thank you for your attention, and sorry for it.
Next, we're going to have Irene Kariuki, who is an advocate for the High Court, or at the High Court of Kenya. I apologize. I think the slides might have gotten off there. I'm not sure if maybe the battery is weak or something, because it is working, but not well. So, I mean, if you just want to make sure it's the right side, you might have to work twice. That's the meeting set up. You have to hear it. You don't have to.
Morning, everybody. My name is Irene Kariuki. I am from Kenya, Nairobi, Kenya, and I practice law in Kenya as a commercial lawyer. Yes, I
Optional.
yeah, that's true. Yes, I especially practice in the areas of investment law, commercial law, and commercial dispute resolution. So I recently concluded my LLM, and that is perhaps to tell you that I'm work in progress, just like the paper is. And when Professor yesterday spoke about the programs here, and he said, I know most of you know people who would be interested. In my mind, I spoke to myself and I was like, yeah, I'm those people who would be interested. Yeah. But anyway, thank you very much for having me here. And I'm very happy that the people who spoke before me have touched a lot on what I'm going to talk about. But now mine is I'm looking at the challenge, the practical challenge of the conflict that exists between the dispute resolution mechanism in investment, international investment, and the people, the indigenous peoples. And to start us off, I just use this image. Just think of whichever country, wherever. This is perhaps the guy standing in the middle there is an elder of a particular indigenous community, and they're talking about some land there that has been secluded for an investment project. They probably have heard of an investor. They do not know who this investor is. But what they do know is that that land is the ancestral land, the graves of their ancestors there. That's the land known as their own land for the entire of their lives. And but they have also heard that there is in fact a global tribunal that is dealing with a dispute that is touching on that land, the land that they believe is theirs. So they have to go because I mean it's a global tribunal, so perhaps this tribunal will recognize their rights as indigenous peoples. Lo and behold, the decision will come later on, an award will be issued, and an award will be affecting their own land, but they will not have been involved through the entire process of that dispute resolution. And of course, the government or the state will also be fined actually. And we will have what one of our colleagues talked about, regulatory chill. And the people, the indigenous people, will be the ones suffer much of the blood this process. So in short, my presentation today on my paper is talking about the ISDS mechanism. And what I'm saying is that it is structurally incapable of incapable of handling indigenous people's disputes or rights, or handling or tackling indigenous people's rights because of how it is designed. Primarily, it is for private commercial rights of the investors. I think one of the presenters spoke about that in detail. And but unless the indigenous peoples are involved through the process of these ISDS proceedings, then development will continue to be sustainable as long as their participation is not taken care of. Now, I probably do not need to go through what ISDS is, but it is the arbitration. I mean, it's founded on arbitration, meaning that it's also founded on contract. And indigenous peoples are third parties that they're strangers to this contract, and that's why structurally the mechanism locks them out. They technically do not have lockers before these tribunals. So what this slide is trying to show is how, from the point of negotiation of these investment projects or development projects, the indigenous people tend to always be excluded from the point of negotiation to the point of the dispute process itself. We see a few cases where they have applied to be included. They have made submissions. Some of these submissions rarely are they considered. They are mostly dismissed. And even after the award is issued, you find the people that will again suffer the most will be, or the people who will feel the impact will be the people themselves. I am cognizant of the fact that it is not only indigenous people who suffer. We have local people as well. And I know there's also a difference between indigenous and local communities. But today, at least for this discussion, I'm going to focus on the indigenous peoples. So my paper is looking at what I would say is a conflict of two regimes, the international investment law regime and the human rights regime. Those two regimes are very much applicable to this whole discussion, but you find that it is only one of them that is applied in the tribunals. And therefore the two regimes clash, but it's only one that will be used or that will be standing in the tribunals. And therefore the ISDS jurisdiction automatically excludes the human rights regime. And because the human rights regime in this case is looking at the collective or customary land rights of these people, of the indigenous peoples. And on the other hand, the investment law regime, international investment law regime, is looking at the rights of the investors, totally different viewpoints. And this therefore leads to what we see tribunals the jurisdictional blindness of the tribunals. They are not able to see, they cannot, because of the nature of the tribunals, they are jurisdictionally blind to issues of the human rights. And you will see one of the cases later on, which the tribunal technically just said that because it's your claim of human rights, we cannot help you. And therefore, what I'm saying is it's a conflict of concepts. We have the ISDS, which is private, contractual, economic, and then we have the indigenous land rights, which is communal. And therefore, the two do not meet in arbitration. And creating what I'm referring to as the jurisdictional blindness in the ISDS tribunals. So I have, in the paper, I've looked at several other cases, and I'll be happy to accept recommendations of three other cases. I was looking at Africa and Asia cases, and especially because most of these developing countries are always after investment, foreign investment projects and developers and investors. And I think we have been given some good statistics here. It shows how much of these cases are actually in those developing countries. So in this case, you probably also are aware of it, that I'm sorry, you can't see the full case versus Zimbabwe. So I won't go into the details of the case itself, the facts and everything else, but what I'll focus on it had two indigenous communities that were applying to be included, at least in the capacity of a miscurity. And the basis of the application was simple, that their distinct cultural identity as indigenous peoples was linked to the ancestral land, the land that was in dispute in this case. And the tribunal, on the very, very claim that, on the very ground that they were asking to be included, is what ground the tribunal used to exclude them, because they were saying, the tribunal said that they actually did not have a significant interest in proceedings. And the intended submissions, because they were planning to be allowed to submit, would be outside the scope of the dispute. And this, remember, is touching on land that is actually their land. Right? The indigenous land that their ancestral lands that they are attached to them, but they have been told they actually do not have significant interest in the proceedings, so you cannot be included in the proceedings. So this case gives us a clear example of exclusion of indigenous peoples. And then the Churchill mining versus Indonesia is a different look. It's different from the first one because now it gives us a clear demonstration of invisibility of the indigenous peoples. In this case, the case was dismissed in favor of Indonesia, but it was not on the basis of the indigenous people's rights. It was instead on the basis of a pure, a legal ground, an issue about forgery of documents. So again, the indigenous land rights were not addressed at all, even though the case was dismissed. Again, demonstrating invisibility of the indigenous land rights to the arbitration tribunals. And lastly, at least for today, is the Bywater Gulf case in Tanzania versus Tanzania. It was not entirely on indigenous peoples, it was mostly on sustainable development. But it is significant in this case because we see the tribunal in this case actually considered first of all, they were allowed to submit, number one, and then number two, the tribunal in its award heavily relied on the submissions made by the amici. So and the significance of this case is it just shows that it is possible if you want to, or if you make it, if the tribunals are made to or they want to, they can actually consider the rights of the affected land parties, including the indigenous peoples. And but unfortunately, like I said, a lot of this, the PATs are there to protect the investors' interests. So again, they cannot be made to do that. So in short, all this is to show you that there is actually no participation in the decisions made by the tribunals on the rights of the affected third parties, that including the indigenous people's rights. And my proposal is that there should be participation. And participation should not be an event. It should be a process, because as it is right now, it is actually an event. You find when in the three instances they are allowed to participate, it's come and make submissions, and then after submissions you go. You don't get to respond. You don't get to see whatever evidence is filed. You don't even get to sit in the hearings. So it's treated as an event, and it should be a process as opposed to an event. So amicus submissions is not participation. One of written submissions is not participation or meaningful involvement. But real participation would be from, that if you remember, that's slide number, I think, number 3, from the point where there's the negotiation of the projects all through to the point of the award. That is now what we call participation. As it is, there isn't any participation. And my way forward proposed, I have summarized it into 3 P's: procedural inclusion. So procedurally, you will agree with me, procedurally there's a problem. So we cannot say that there is inclusion just because there's amicus only, through the amicus only model. So right of audience, you really find given that right of audience, right to access documents or evidence filed, or even right to respond to factual matters. Number 2 is the public participation principles. Now, I'm saying that participation, now if we are saying allow the indigenous peoples to participate, then how should this participation look like? I think it should be guided by the principles of public participation. And these principles of public participation have been discussed in courts all over the world, and have relied on a Supreme Court case in Kenya. It went into detail on what public participation should look like, including transparency, right for proper representation. Again, another challenge that indigenous peoples face is they do not have representation even when they are allowed to make these submissions. You find they rarely have effective representation. So public participation principles should form the basis of this participation of indigenous peoples. And then lastly, the policy reforms. And this include, the new generation BATs. We've seen some progressive, there's some evolution in the VITs now. You have seen some bold moves by countries such as South Africa, where through the Investment Protection Act of 2015, they did away with ISDS. We have, and the Morocco-Nigeria model, I do not think it is enforced, but it is presenting, it requires that there be local remedies first, that we exhaust local remedies before we go to SDS. Then you have the AFCFTA investment protocol shift. I think we are going to see how the the dispute resolution process will be like. And we have an expert here in AFCFTA, but and that obviously will affect most of the member states in Africa. So again, we're going to see that. And then the domestic exhaustion remedies, I think I've already mentioned that. And then the remove, which is, I think, in my opinion, the most ideal would be the regional multilateral investment courts to help with handling. Because in my opinion, if you ask me, I would say let's do away with ISDS and let's do the investment courts. And then, so to conclude, what I'm saying is that we cannot call development if it continues to silence the rights of the people who make it happen, because these are the people who give their land. These are the people whose land is used for development to happen. So if it continues to silence, it's not development. It's exploitation. And I know Professor Ali said I would talk about the Ogate case. I've just referenced to it, but yeah, it is significant in this case. In this presentation for me, specifically because of Article 21 of the African Charter, which was interpreted by the courts to protect indigenous customary rights to land and natural resources. And then so it would be, if the interpretation is significant because we're talking about the cultural rights and rights to land of the indigenous peoples. And again, if ISDS cannot hear the indigenous peoples, then it should also have no business handling matters that are touching on their own, matters that are very intricate to these indigenous peoples, including the indigenous land. And lastly, that there's no option. It is to either evolve or to just, be replaced by something else that is working for everyone. Yeah, that is my presentation. Thank you for listening to me.
Okay, so last we're gonna have Daniela Oliveira from the public attorney, the Attorney General's office in Brazil. You wanted to see the This is hot. Yeah. Oh, exactly, yeah, no problem.
Yeah, come on, thank you. All right.
One of these times when the mouse disappears. Is there a,
F5 usually works.
yeah, there's gotta be a keyboard shortcut, right? Oh, thank you. All right. Do that now. Yes, figures.
Oh.
Oh, you have, oh, yeah, it's working.
Yeah,
Okay.
it's working. It's fine. So good morning, everyone. It's a pleasure to be here at this conference. So I would like firstly to thank you, Professor Shen, for hosting the conference, and also Professor Lee and all the LDI team for the opportunity to present my main thoughts about my PhD research. And so I'm going to speak my personal presentation. It's because Professor Shen already said. I'm Daniela Oliveira, and I'm a federal public lawyer. I'm raised in Brasilia, and drawing my background in international law and my experience with Brazilian investment agreements, I want to explore how the role of the states has shifted in the last years, especially considering the ISDS systems that my colleagues had already presented here, with all the challenges and also the problems and so critical about it. And for this reason, I cover in my article some topics. And especially the fracture post-pandemic landscape. It's because the article is about attracting investments after the COVID, and also the paradigm shift from liberalization, the traditional liberalization for strategic attraction for states, the rise of investment screening, and the new legal economic toolkits that the nations are using right now, especially focus on Brazilian case. And so talking about firstly on post-pandemic landscape, it's possible to observe a problem because the COVID was not just a health crisis. It was an economic shock that caused more or less a 40% drop in the global FDI in 2020. And even we saw a recovery in the following years. We are witnessing a concentration of investment in developed countries to the treatment of developing markets. And for this reason, UNCTAD described that this is a fractured global investment climate because its inequality is hindering progress through the SDG goals. With the UN warning that we are far from reaching our targets of 2030 agenda. So this environment has forced a major paradigm shift. The old era of restricting investment liberalization, which prevailed since the 90s of the last century, is declining. I believe we are moving forward for a new paradigm, one of active and targeted strategies that focus on investment quality and also focus on strategic sectors. This shift to place an emphasis on industrial policy and the use of also financial incentives. And talking about the investment screening, in my opinion, is one of the most signs of the shift of the rise of the state power through investment. The crisis accelerates the movement and the trending of states actively reviewing investments to strategic assets. This has happened for some reasons. One of them is because states changed the meaning of national security. Traditionally, we think about national security, about defense or military issues, but it was expanded, especially after COVID, for technology, semiconductors, health, and so on. So states right now want to present some opportunistic acquisitions of vulnerable markets and develop prices during the crisis. And also, this is a global trend. It's not about developing countries, but also the developing one. For example, Germany cited its regime to review investments based on a likely environment of security, not just the actual risk. Canada also strengthened its review of FDI, particularly for healthcare-related companies. The European Union did the same movement and launched a cooperative framework for member states to coordinate on screening investments. And South Korea expanded screening to protect essential national technologies for linkage. And in Brazil, we have some discussions. We don't have a regulation specifically on screening, but it's a topic, especially on government. However, screening, as a thing, it's a defensive way to obtain investment and to access investment that come into our territory. And to actually attract more capital, states are also modernizing their legal economics toolkits. And there are some main pillars that states are internally adopting for it, especially. And in a microeconomic vision, especially strengthening central bank autonomy, implementing new fiscal frameworks for in its course for more transparency and stability, and also they are using for strategical industrial policies, as we will see right now. The first pillar here is the evolving role of central banks. The crisis blurred the lines between monetary and fiscal policies. In response, nations have reinforced central bank autonomy to sign to the market and to the investors more stability and credibility. And for example, Chile in 2020 authorized its central bank to buy treasury debt in exceptional situations. It was quite important during the COVID. Egypt passed laws consolidate financial autonomy. And in Brazil, we formalized the central bank autonomy in 2021. It was a previous movement, but it was quite important because our complementary law reinforcing this autonomy, and also our this law it was questioning in our Supreme Court, and Supreme Court said two main things: that economic policy is the issue of central bank. The judiciary is not allowed to talk about interest rates and macroeconomic terms and the macroeconomic policy as such. But it's and the another one is that this complementary law is constitutional regarding our systems. Well, the another pillar is the new fiscal frameworks. We have a word discourse saying that it's important to create a fiscal and a transparent fiscal environment to attract investments. But it's important to question if there is a reality or not. But I'm just presenting here. In this sense, the pandemic created a debt tsunami, forcing a reevaluation of fiscal rules to balance stability with growth. In 2022, for example, that's true. The United States enacted the Inflation Reduction Act using tax credits to clean energy investments. In Brazil, we established in 2023 a new fiscal framework to replace the another law that we already have in this area. And in 2024, the EU amended its Stability and Growth Pact to allow for more growth-friendly debt reduction plus. So this is a discussion that we are already having, not only Brazil, because in Brazil it's quite common, especially the newspapers. Oh, okay, we want to regulate our debts, but I observed that it's not an exclusive effect to Brazil, but it's the whole world. Okay, thank you. And finally, the third pillar is the return of the strategic industrial policy. It's quite a recent movement, especially consider that we are trying to show more resilience to some economic effects and to some movements of FDI flows and investments. And in this sense, we also it's possible to see also a comparative scenario here. For example, South Korea, since 2021, has developed the Korean New Deal that to lead in so many industrial sectors considered strategic for attracting more investment, especially digital and green transitions and green investments. And also, European Union adopted the European Chips Act and the Green Deal Industrial Act to ensure that technological sovereignty and competitiveness regarding not only the other developed countries, but the developing ones in this scenario. And in Brazil, in September of this year, consider the whole scenario, including the competition regarding the US tariffs. Brazilian launched the new Industry Brazil. That's a plan to attract direct investment towards especially high-tech and sustainable sectors that are important for us. Also, another standard important, and one of my colleagues has already said, it's the facilitation of investments. And so in Brazil, we adopted the initiative from WTO and the investment facilitation agreement principles. This is crucial because according to UNCTAD, it is expected implemented of a single windows can increasing FDI flows by an average of 12%. So for concluding some especially takeaways, the pandemic act catalyst shifting us from a purely liberal approach to a state-guided one. We have learned that mere liberalization is no longer sufficient. Today, success requires some sophisticated toolkits. Some states are adopting screening investments, and others have shown some internal measures to attract more investments. And for concluding, the future of FDI attraction, in my opinion, depends on building regulatory environments that could be more transparent and predictable. So thank you so much. I'm totally available for Q&A section.
Great, thank you so much. So we started a few minutes later, but I also don't want to run too long. Yeah, so I was thinking maybe a couple minutes after 11, and then we'll be, 10 minutes or so behind schedule, but that's okay. We have a nice 90-minute lunch break, so we don't have to, we can kind of do this a little bit. So I will try to moderate. So I saw Steve already, and then go ahead.
Yeah, this is really enlightening presentations. Thank you, all of you. It's very informative and I learned a lot. So I got a question for Andy, just a few questions, and also a comment. Treasury. So basically, your point is tax revenue over to developing countries that go on because of the tax scam. That's going to basically host country. And in that, some players like Mauritius take advantage of it. Would you characterize this as a colonial control transitioning to neo-colonial control of some sort? And if my sort of assessment is correct, then have you noted any multilateral response from groups in the developing countries or some money groups really developed? So much. The second, I got actually curiously concerned about your assessment. There has been no negative impact on social welfare due to this tax regime. What are the implications of this? So basically, tax revenue for developing countries are not used for social welfare, so it doesn't matter. Somehow tax revenue is gone, but it doesn't impact. Or again, I don't know if you had a chance to go into this, but money taken, tax revenue is not big enough. So that's the reason why we need to see. So I wonder if you have any insights about this. And one comment I have about Treasury is you asked this very curious question. Do we need FTAs? And I mentioned this because I encountered this question 20 years ago. And I wrote something called Foreign Direct Investment and Regional Trade Legalization. So is it viable? My assessment then was, can you name any successfully developed country, the countries that traditional developing status developed? As you know, there are not many. Look at South Korea, Taiwan, Singapore, Hong Kong, Chile. Is there any country that really developed out of legalization? And I remember saying that China, perhaps, but China is unique because of its huge market and industrial capacity. But if you actually look at other countries, is there any country that actually developed? Yeah, that was 20 years ago. So I wonder if it would count.
So I would say what happens with having a hub treaty, Mauritius in particular, but with Dubai and so forth, is you get more investment in, and that may not generate tax revenue, but it generates economic growth, which is more beneficial than when you have a choice of no growth and no tax revenue. The investment doesn't come, or you get investment and get growth, but you don't necessarily get direct tax revenue, although of course you get indirect tax revenue, people who are employed in those businesses are paying income taxes and sales tax. And I would actually say that the neo-colonial aspect is the OECD's attempt to cram down its model of taxation on developing countries. I think is very damaging to most developing countries, which are forced to invest an enormous amount of resources, of very scarce resources, not just the money, but the skilled people, in offices doing compliance work for the benefit of Germany and France and Britain, the United States, rather than investing those people in creating wealth for countries. And so the appropriate tax structure for most developing countries is not the one the EU and the US so forth have. This is and the appropriate tax structure for most developing countries when they were colonies was not the tax structure that was imposed on them. So the neo-colonialism, I think, is exactly the OECD's efforts to force these countries into a model that is inappropriate for their developmental state and inappropriate for their own goals for their societies. Just as an example, so Mauritius got started by having a tax treaty with India. And it had a tax treaty with India because it's relatively near India and there are ethnically Indian people in Mauritius and other people were doing business. Then we should have a tax treaty. This is a time in the 70s when India is relatively closed foreign investment, when India began to open up to foreign investment, before it established the changes in Indian law to facilitate, you could invest into India through Mauritius, and people did. And some people in India said, well, this is ridiculous. We're missing out on tax revenue. The Indian government said, no, we want the investment. Now later, about 20 years later, they said, okay, we're done. We've now reformed our domestic tax system to the point where we can get investment without going through Mauritius. So we're gonna renegotiate the treaty with Mauritius to end this thing. But basically, India was willing to discount its tax collection to get the investment at a time it needed the investment, and it did. Mauritius, having learned we can make money off doing this business, had seen the end of the India deal coming, and so started signing treaties with countries in Africa saying we'll be the gateway to Africa. And I think it's fundamentally misguided, if not pernicious, of the NGOs to go and say, cancel your treaties that are enabling you to get investment that you wouldn't otherwise get, right? That investment would not come there. As far as the implication, so I don't think it's that tax revenue doesn't do any good, although countries that have corruption problems, maybe it doesn't. But it's that you wouldn't get you're not going to get the tax revenue either way. The question is, are you willing to forego revenue from directly taxing economic activity that won't occur if you don't forego it? And most countries have said, well, we'd rather have the economic activity because that's how we're going to grow. And that's been a successful strategy. So you asked your comment on the other paper, has anybody grown through investment? Well, the US is an example. In the 19th century, we got massive capital investment from Europe. And I think that investment made possible the railroads, it made possible development of industry, it made possible development of large-scale agriculture in the West. So that would be my counter to.
Actually, it's China and US.
Yeah.
Two things, short things to add to what Andy said. I think one on the 3D networks. I think what this work that we've done so far demonstrates is that there's an alternative paths. And I think that's the key there. Now, what's going to do with those alternative paths, that's up to the pairings and the relationships that are built. But that's so you're not just captive of a single like OECD network or whatever. There are some other ways you might be able to go, and you could maybe control your destiny a little bit more. With regard to the the internal impact factor, I would say where we are is just kind of a start. It's sort of like, okay, maybe in the sort of not very sophisticated manner we looked at it, doesn't seem to have done harm. The question is what will facilitate growth within. And I think this then goes to your other question with regard to the benefit, which it's not just the investment itself. There's the legal infrastructure potentially that could. I think some of the really interesting points that were brought up by colleagues here is to sort of leverage these relationships. And I really like the idea of the facilitation to basically create systems where you actually can begin to meet these objectives. because you're trying to combine stakeholders and interests together. And the mixing bowl is kind of at the domestic level. And so to enhance that capacity is potentially where some of this international activity can also play.
Yeah, so thank you very much for the question. Perhaps I wasn't clear in my assertion. I'm not at all saying that trade and investment are not important for countries. What I'm saying is that international investment agreements, there is no the empirical evidence suggesting that those agreements are the way that investment is attractive into a country is equivocal. So there's been lots of empirical studies on this area. And so we now believe that investment agreements might be one factor that is important, but it's definitely not the defining factor.
I believe this.
Laura?
Yes. I'd like to ask a question to like Andrew and Charlotte. So first of all, like in line with the debates that you were having before about this is more of a comment in terms of choices by states on foregoing some revenue for other purposes. I'm thinking about an even more radical choice, which is the case of Cayman Airways. So Cayman Islands has got its own airline despite the small size of the country. And it is an airline that is like a statutory governmental company, and it runs permanently on deficit, and it always has to be funded with extra resources. However, the thought behind it is, first of all, we do provide a service to the people that live in Cayman. For instance, during COVID, we kept our flights with strategic places because Cayman Airways kept running. And then also, it's not about the direct revenue that you make, it's about providing flights, particularly from different places in the US, so that tourists come on islands, so that then the local economy benefits from it. So definitely a very interesting debate. And also from former economists and jurists to current and certainly more qualified economists, I do have a question as to the pathways for the future. So you have touched upon what the situation is like now and have provided a very, very clear picture. So I wonder, how do you feel that this area is going to develop and whether there's even space to create those decentralized networks?
So I've written about Cayman and been to Cayman. I just take students to Cayman. So Cayman Airways is a really interesting question because people have very strong opinions about Cayman Airways, but I think it will never go away because you're in an island in a path of hurricanes. You need when hurricanes came, the other airlines left, and Cayman Air was there to take people out. So it will continue. Whether the board members continue to get lifetime free passes on it or not, no, they do. So I having a lifetime goal of being a board member is something that you should pursue. But I mean, Cayman is a great example. In 1960, Cayman was a barter economy and exported its labor on U.S. merchant marine ships, and the women made thatched rope on the beach, and there were a lot of mosquitoes. Well, there's a lot fewer. I mean, cattle choke to death on mosquitoes, and people, you put your hand on a screen, the stories are, and you take it away, and it'd be a black hand of mosquitoes on the other side of the screen. And by 1980, it passed Britain in GDP per capita. So that came from monetizing its legal system and becoming an important player in the global economy, facilitating transactions, right? The money wasn't in Cayman. It's, you've got the Ritz-Carlton and there's not much else to invest in. The investment flows through Cayman elsewhere. So I think trying to keep like those kinds of jurisdictions from playing that role, which is what the OECD has devoted itself to doing, is actually harmful to development because you can trace lots of development, particularly in Latin America, to funds that flow through Cayman, because Cayman has investment fund structures that give investors confidence. They understand the legal system. There's an appeal to the Privy, ultimately to the Privy Council, but a very distinguished judiciary in Cayman. You have KCs coming over to argue cases in Cayman. I mean, the quality of the legal system there is as good or better than anywhere else in the world. And that is a really valuable contribution to the world economy. So I think having investment through places like Cayman, Jersey does an enormous amount of investment funneling into Africa. Some of Africa's largest companies are Jersey organized in Jersey. So Africell is a Jersey company. It was on the London Stock Exchange. But you know, these places play a vital role in channeling investment. And I think the sort of knee-jerk reaction, well, they must be doing something dodgy, is very unfortunate because this is how money gets into developing economies, from pooled and flowing through those jurisdictions, right? So I think that you have, if we really want to see development, we want to see jurisdictions like Cayman and Jersey and so forth succeed in their role of doing this. Now, eventually, places like India outgrow their need for Mauritius, and they can adjust. But India would not have gotten to where it got to as quickly, I think, but for Mauritius, making it possible for foreign investors to circumvent some of the red tape and so forth that India had built up during the period of we don't really want foreign investment. And for a couple of decades, India said, okay, now we've cleaned things up and we can move forward. But places like Cayman then have figured out the next thing, right? So this is, if you're an American, your healthcare is better because of Cayman, because captive insurance companies in Cayman have made hospitals more efficient in the US. All these kind of hidden things that we don't think about are really, really important to the global economy.
I think to your question about the decentralized networks, I'd actually go back to what Katrina Kuhlman was talking about yesterday about regional, because, you know, while, you know, you were all ending on a somewhat anxious note, I would say, yesterday, actually, maybe it's not such a bad place to be because, and again, I think this panel demonstrates, you know, a lot of what's going on under the surface that we haven't quite seen, it's just not been visible. You know, I like your concept of visibility. And now, for whatever reason, you know, more of these things are coming to the fore, largely because we have more judicial process in place, regional judicial process, you know, the changing dispute resolution mechanisms and all of which is getting us to understand where there are the disconnects, where things are not fitting. And in some of these smaller arrangements or newer arrangements, you know, you have the opportunity to sort of reinvent well, you know, where retrofitting is always more difficult. So when you start anew, so I think, you know, understanding really what the goals of today are, including, you know, at the domestic level, I think this is the opportunity we have. So I think in terms of your question of, you know, these decentralized networks, I think it's great because out of this, hopefully will come, you know, better packaging, better solutions with better participation, better dispute resolution and all of that, taking into account all the lessons we've now learned. But we actually know these lessons because of academic work and other things. So that's good. So you're not building completely anew, but you have, you know, places where you can experiment and try things out. So, you know, I actually, hopefully, you know, without too much more damage, unfortunately, on the path towards going to where this new reality will be, you know, that's the problem. Trying to contain the damage while one is taking the journey. But the journey itself, in many respects, is kind of exciting because we sort of know where we've been, we know where we might like to go. We're not entirely sure how we're going to get there, but you know, there's a path, there's a possible path.
Just one other concrete example. So working with the Danish Red Cross, Aon, which is a big global insurer, set up insurance products in Guernsey that basically have insured against all the volcanoes in developing countries. Eruptions there, so that if a volcano goes off in a developing country, money will immediately be handed to the Danish Red Cross to do relief work, right? So there's no waiting, there's no getting Hollywood stars to hold a benefit concert or to organize things. They're trying to petition governments to contribute more money. The money will be in their hand, and this is funded at, you know, millions of euros of funds available at a relatively modest cost that the Danish Red Cross could do. That kind of innovation only happens in small places like Guernsey and Cayman and Africa because those governments are on, you know, they see their futures. We have to provide service and we have to show that we're valuable in the world economy. And that kind of decentralization, I think, is absolutely vital to have these small jurisdictions innovate.
What was that arrangement put into place?
Couple of years ago, and there's maybe 2 or 3 years ago, I think it got started. There's a whole series. I can send you stuff about it if you're interested.
Please do.
Yeah.
Thank you.
I see. All right. I just want to see how many more we have. I think it's 3. So let me let's hear those questions together, and then we can see. That way, we can make sure we give everyone a couple minutes to respond. So Gus, and then.
Hi. I have a quick question. I'm sorry. I'm a student, and it's kind of hard to keep up with all the acronyms. But my question was to Professor Karyuki. I was wondering, when you're dealing with indigenous land rights, are these rights codified in any sort of way with the countries that they're in? And if so, when a treaty is made with this country and somebody else, to what extent, and the courts that govern those treaties, to what extent does a potential violation of one country's intercode affect the actual treaty itself? Is there a mechanism in there, or does it have to be built?
All right, so one second, I'm gonna take these other.
Okay, I have a couple of comments and a couple of questions, so I'll try to be really quick. I think my questions are mainly, not surprisingly, probably for Barnali and Ali on the sustainable development aspect of the CFTA. And I completely agree that this has been like an area of experimentation, and it's really exciting to see how it's developing. I was just curious on the ASCFTA, Ali, you talked a lot about how the ASCFTA fits in with the regional economic communities, and of course the treaty talks about that quite a bit, but it's still fairly unclear, I think, on how that's actually going to work in practice. They're mentioned as building blocks, and there's like an APE, concept built in, but I think it might be interesting to look at other areas in which the RECs have addressed sustainable development and sustainability beyond just investment, because I think that you might find things that could be kind of pulled into this investment sphere that are outside of pure investment. Just a thought, if and I started doing that at one point, but you've probably done more than I, but I think that might be an interesting thing. And I think Barnali, our conversation last time was really interesting to me about like, how do you, how does this really start to get real traction? I think South Africa is probably the only example so far where you had South Africa really abrogating its bids, rewriting its bids. You had the SADC model bid reflecting what was happening in South Africa, and then the ASCFTA kind of building off the SADC model bid and efforts with COMESA and elsewhere. And I mean, South Africa is fairly unique, right? I think it's a unique economy on the continent, but maybe that's something to pull into this as well, is kind of looking at that as a case study almost of what happens. And then just two really quick comments for Irene and Daniel. I think those were both really interesting presentations. On the Indigenous rights part, I think maybe it would be worth looking at countries like New Zealand too, to see where Indigenous rights and investment have intersected and whether there are more procedural. I talked yesterday about procedural mechanisms on trade, but I would do that on investment too, and I think that could be a good example. And Daniel, I think on the US Inflation Reduction Act, I would say that's industrial policy probably, right? I mean, it's called Inflation Reduction Act, but I think it's really trying to, and of course now it's like contested. There's also the CHIPS Act on semiconductors. And so like those two things I think show that the US is really veering in this direction of heavier industrial policy. It would be interesting to your research. I thought everybody's presentation was fantastic. Thank you, those now.
So my question is to Sir Andy and Charlotte. So I was wondering about the US corporate tax system and how that might affect foreign investment and using these tax hubs. So in the US, obviously, there's always a huge debate about who's paying their fair share of taxes. Corporations aren't paying that much, and there are some suggestions that like the statute of limitation for corporate tax should be expanded to 7 to 10 years sometimes to cut some of the deferrals. And also transfer pricing methods, for example, there are some strict compliance measures that corporations can take that are somewhat being abused and based on what some people are suggesting. And also the 368 tax exemption, how sometimes these foreign investments can be kind of written off just like in terms of tax purposes by using the 368 tax exemption where you have to use mergers and acquisitions in order to kind of offset profits, and also use the depreciation deductions in order to reduce their capital gains tax after they leave offshore from the foreign subsidiaries. Obviously, there's like other probably international tax issues there, which when it comes to international tax, all that I know is Toronto Raptors players need better accountants. So I guess my questions are less aligned there. But I just wanted to know if the US does indeed have strict stricter compliance and enforcement mechanisms, the IRS, for certain corporations, especially transnational corporations, would that, in your opinion, stifle, increase, deter, or affect foreign investment?
Yeah, and I'm just gonna throw in a very quick question to the other Andrew, to maybe share a little bit about what you see as the I don't know, the causal story for how this evolution came about. And I don't know if you said it outright, but I'm assuming you don't think it's a good trend that this trend is in this direction. So I'm curious if you have thoughts on the appropriate intervention or kind of a way to shift away from this problematic, trend in the jurisprudence. So with limited.
I have a quick footnote, I forgot one thing, I'll be really fast, is that okay? On the AFCFTA, business and human rights, I think, is also notable in that investment protocol. And I would say it goes well beyond corporate social responsibility. It's putting actual obligations on investors for environmental and social labor rights as well. I think that's another innovation in that agreement. I wonder what you think of that. Sorry.
Okay.
So read my own notes.
So I'm hoping that what we could do is maybe give every person about 90 seconds reactions, because that way we can finish up a little bit on that, or almost on that. So why don't we just go ahead and start at the other end, and we'll look at that.
Okay.
And you can continue conversations after, right? So yes, just your initial thoughts to the question.
Okay. Like to thank you again, and I think as Professor Ingrid said, we are thinking about states are thinking about new ways to dealing with the investment in environment, and especially we passed through so many economic crises, and especially COVID has shifted the scenario. So it's important to see how states are trying to do something different in the economic area. So thanks.
Okay. Thank you, Katrina. Thank you for the information. I'll definitely look at that. Yeah. So to your question, we have. And I'll use Africa as an example. Unfortunately, the situation is very few countries have national legislation specifically touching on the indigenous people. And I'll give an example, like Kenya has, in the constitution, recognizes ancestral land. It doesn't speak too much about indigenous peoples. Find DRC also has, a Democratic Republic of Congo also has something in their local laws. But now the situation, for most countries do not have that, and that tells you also that there is no mechanism in which the local laws and the treaties are able to there is that mismatch between the laws and the treaties. They have not caught up yet, so that's a challenge as it is right now. Yeah.
Thank you, Catherine, for your feedback. To be honest, it was a short time for me to present all the things within the AFCFTA, but I want just to add something for the audience. What I will explain why I focus just on investment protocol, because there is an entanglement and overlapping between the different protocols concerning the sustainable development objectives. It's just because some African states, from, for example, SADC, particularly South Africa, Ethiopia, and Nigeria, and I make a reference to the PIT, Morocco, Nigeria, took a political decision within the annex of the ACI-ICDS, because the investment protocol of FCTA include an annex of investment dispute settlements, and we have a problem now, are stuck, because we have the two groups of states. One group who they want to keep investment arbitration, and the other groups who want to exclude the investment arbitration. And the first group is leading by the South Africa, Nigeria, and Ethiopia, and the second group now is leading by Morocco, Egypt, and Mauritius also. Then, that is the main issue. We are stuck before the situation, and we cannot safeguard and guarantee the sustainable development without investment settlement dispute mechanism. It's there is an emergency to find a way, or to find solution to unlock the situation. But it's for me very complicated. We have been discussing with the Secretary General of FCFTA on Kerimele, but this depends on the state sovereignty. that is the limit of maybe the experts or the advice, council, etc. Because states have a specific vision, the public interests, also the geopolitical, because yesterday a colleague from Bangladesh talked about that. We have many conflicts, many crises across Africa between the DRC and Rwanda, about the recent peace agreements, and we bring something very dangerous within the investment protocol. It's the Article 44 concerning the protection diplomacy. I think that it's a very, very bad idea to use a protection diplomacy within the investment dispute settlement, because if you have, for example, a dispute between investor and state, you will transform it in interstate arbitration, and for me, in some cases within Africa, it's impossible. And thank you very much.
Great. So thanks very much for your question. So the paper does talk about the South African model. It also talks about Brazil as also an alternative model, but for the sake of time, I wasn't able to present it. I still think we could do more though, and I think those are both unique examples, but that doesn't address the 1,300 IIAs that are already present.
True.
Yeah, thanks, Rich. Just to be blunt about it, I think we should get rid of investment treaties in their current form. I think that, the efforts to change the language of these treaties haven't been successful. I'm skeptical that changing the institutional setting will matter. More nuanced conversation to be had there, but and I think that stems from the basic design of the system as an investor rights system, and the sort of intellectual lineage of things like the sole effects doctrine, which focus from the investor's perspective on the legitimacy of public action, background policy notions like this concept of an obsolescent bargain that treat with suspicion state actions that interfere with expected profits. And then you see this sort of shift in time as the sort of Penn Central Trust in investment cases and its requirement of complete deprivation leaves unsatisfied aggrieved investors who suffered partial losses. Then you see the expansion of these concepts and the growth of claims on an FET or fair and equity treatment today.
I will see my
Tax rules aren't complicated by accident, right? They're complicated because people want to special provisions in them. I did a course with IBFD in Amsterdam on transfer pricing and stuff, and the glee with which these Dutch tax lawyers explained the complexity that required hiring them to unravel was, this is full employment for lawyers. So what tax treaties do, yes, we're in favor of that, right? But we are transaction costs, and what tax treaties do is they bring clarity to whose rules apply, and that's really important. I think that's more important. If you want to look at the sort of titanic struggles in tax, though, I think it's the U.S. refusal to provide tax sparing provisions where we forego our taxes when a developing country says we're gonna give a company a tax break, and we say fine, well then we'll tax that income because so we'll collect the tax. So if we undermine the ability to do that. And the other thing driving global tax right now is the battle between the US and the EU over the EU's effort to tax American tech companies, because the EU doesn't have any tech companies because they're not good at it. So they want to get our revenue, right? And we're trying to protect our national champions against Europe's attempts to develop national champions. That's what's driving this. Developing countries are a sideline to the battle of global tax rules, which is over who's going to tax American multinational tech companies. Is it going to be Europe or us?
Okay, so let's thank the panel for a great discussion.
Is everyone ready? Sorry to cut the conversation short, but we have lunch after this, so you can all keep talking and exchanging ideas. I know there's been so much great discussion. I'm particularly excited about this panel. I think that this is one of the most important panels of the entire conference. We are going to hear from 3 fabulous emerging scholars about their work. Their papers are excellent. I encourage you to read them. So I am just going to do brief introductions, and I'm going to keep time. I'm going to ask for your questions. So ask some good questions. Think about your questions. So first, I am going to turn to Muad Al-Jahani, who is a JSD candidate at Washington University of St. Louis. And he is also a lecturer in Saudi Arabia at the Imam Abdul Rahman bin Fazl University, the College of Sharia and Law. And I think this is such exciting work. As he and I were talking before the panel, I think that there is a gap in international legal scholarship in this area. So I'm so excited for his presentation. I will hand over to you.
Okay. Hi, everyone. Good morning. My name is Muad Al-Jahani. Today, I want to invite you to take a look for a case study. I think it's a rich case study for law and development and sociology of law, law and political economy, which is the case of legal reform going now in Saudi Arabia. My favorite title, Law, Bureaucracy and Development. And I will argue clearly the codification process, which is essentially a legal process, is actually an economic and bureaucratic tool in Saudi case. Here's where we are going today. We will start with the puzzle about timing of this codification, move to diagnosis of bureaucratic structure, and end with analysis of new hybrid system that is emerging. Let us start with some data. The issue of codification, which is, have laws written in, let me say, civil law as a civil law, system, is something that being, debated before the unification of Saudi Arabia itself. The unification happened in 1932, and the first attempt was in 1927. The first attempt to codify the law failed. Also, with the economic oil boom that happened in the 70s, the state could not produce, even commercial code or civil transaction law. In 2014, there was, a wish to also re-imagine this project, but also it has, stalled. So the conclusion for that, for nearly 90 years, the narrative was clear. Saudi Arabia cannot or will not codify its law. Too many, researchers, this look like permanent traditional resistance. But here is the puzzle. In 2021, this century-long, debate ended overnight. In just 2 years, Saudi Arabia released 4 major codes covering the entire legal spectrum. This is also adding to more than 900 regulation, reform. So, if, the culture prevented that for 90 years, how did it happen, suddenly? Clearly, culture or let me say, the religion did not change that fast. So my argument is that the variable that changed was the state capacity, so the state itself. So, has the existing literature, explained this history. It had largely been, divided into main schools. This is, explaining the Saudi legal system. On one side, you have the modernist view represented by a scholar like Ayoub al-Jabur. They argued that the absence of code was the root of, traditionalists causing inconsistent rules and affected the economy. Their solution was simple. Establishing laws as in all Arab world countries. On the other side, you have traditionalist defense. Let me call them like this just to explain, led by scholars like Frank Vogel. And they argued that, Saudi Arabia didn't need a civil law code because the established and the existing practice of judges already provided a kind of stability. But here is my intervention. I believe the both sides missed the crucial variable. The real barrier to the reform and legal reform was not just a battle between text versus, tradition. It was problem of state capacity. The state simply lacked bureaucratic machinery to produce these laws, and this is what has changed now. So also, just to give a context, before we dive into the Saudi solution, we must step back to look to the broader regional context, especially in Arab world. Scholars like Leonard Good remind us that historically codification in the Arab world was almost synonyms for Westernization. It usually meant importing the French civil code via Egyptian model, and there is a long history, for that. And also Muhammad Fazl points out this often created crisis of legitimacy because these codes felt like colonial tool. They were viewed with a deep, spectacle by especially Sharia scholar. So with taking this in our mind, we'll turn to what's going on now in Saudi Arabia. Most people know the Vision 2030, and which is an economic plan to move, and diversify the sources of the oil. The income of the country. With the mega projects and the main thing that I want to focus, it comes with bureaucratic centralization, and this is also that affected the legal system itself. It has stated clearly, to attract a global investment for these mega projects to be a legal, to be AI hub in the globe. We have to move to written laws to enhance the predictability, to make, a safe environment for the investment. And yeah, so now I will mention the core argument of my thesis in this paper, which is, I argue that the historical delay was caused by bureaucratic fragmentation of the rentier type of economy of Saudi Arabia before. Second, the current, success of the country in moving to the codified for the executive centralization. And finally, the result of it's not, Western secular law. It's something that we can, frame it as hybrid state. Yes. So, just to give, theoretical framework, we bring two layers of from the Weberian school, which is I start with the. Max Weber famously taught us that modern capitalism cannot function without formal rational law because markets run on calculability or predictability. But I think the new Weberian schools, when they, not just focus on the products itself, but also focus on the role of the state. So they focus more on rule maker, which is, I find new Weberian lens here is crucial. The state, it's not just a legislator, it's also a manager dealing with, the outcome with legal system to support the economic deliverable, goals. So when we look to the old model of the bureaucracy in Saudi Arabia, we find it affected by the type of economy at that time, which is rentier state, which is a state prioritized distributing wealth over building efficient institutions. In that time in Saudi Arabia, the oil boom led to rapid bureaucratic growth, but without central plan. As also Stephen Herzog, which is a scholar, study intensively the Saudi state, called it administrative dividends. each ministry become an island. The Ministry of Commerce worked in isolation with the Ministry of Justice and so on, and you can apply it to all, administrative agencies. My contribution to extend that description of the bureaucracy to, the court systems. And I bring here the case, commercial court case, which is when we notice the timeline, we find it, a battle of, a battle between the ministries who will be run the commercial, cases. So in 1950, starting from 1931, there was, specialized commercial court. In 1954, the country abolished the specialized commercial court and moved it to general public court. In the 70s and 80s, the commercial, each ministry established, what they call it, quasi-judicial committee to run cases that, related to each ministry. This being, described by a scholar like, so in 2006, there were, over 70 committee run just the commercial, jurisdiction. So that, created, created what we can describe, for investor, they could not predict which, court, which committee they, can file their suit to. This is let alone ruling, how it would be. So, and this is described also by many reports. One of these crucial reports by National Human Rights Organization, when they, describe some, legal reform plan, and titled by, and the title, describe the whole report, ambitious leadership and weak government performance, and they summarize it in 3 points. First, simply putting reforms on paper was not enough. The second, there were significant bureaucratic delays and lack of coordination. And third, the judiciary faced, many cases, and there were a lack of specialized training for judges. So also, in 2007, where there was, a law that, called for abolishing all these quasi-judicial committee and established specialized commercial court, and that not happened until 2018. So it took more than 11 years to establish this court. So why? This is, how the legal structure, look like. It's, centralized the machine of, producing laws by the Council of Economic Development Affairs, and under this council there was two, national committees, which is the NCC, National Competitiveness Center, which is, established in 2019, and it has led over 900 legal procedural reforms, and also there was, a main committee, which is a temporary committee to, produce 4 main laws, as we mentioned. And okay, so just, to end, I think, I cannot cover all the whole presentation. And they also established, some guidelines and to standardize the how these laws being produced. So, also to support my argument, it's administrative rationalization, it's not legal. One, let us look to the outcomes. So we'll give, 3 case studies, which is the first, the 7th transaction law, which is involved in 2023. And we find, in studying this law, which is the longest law, more than 721 articles, we find, the judge has, high, discretion in putting standards. It's the law itself, it seems like a guideline more than it's rigid law. It started also from the first article. Also, I mean, when we look to company law cases, company law case, we find that company law has changed 3 times within 6 years. Why? Because they are not looking for a legal document. They're looking for how they, I mean, economic policy, I mean, and they're supported by this law. Just to end, also, I mean, the judicial principles also, I mean, become a law itself, which is something that before have just documented just to support the awareness about the rules. So the conclusion, the conclusion, I would like to leave you with 3 main thoughts. First, as we have seen today, the Saudi legal reform is much more than just writing new codes. It's a complex state building project. Second, these changes through new Vivian lens, we can understand clarification, not just a legal necessity, but as a critical governance tool designed to overcome bureaucratic fragmentation. Third, the result, of hybrid system, it's a pragmatic way to balance the predictability with, flexibility that required for legitimacy of the state. Finally, for my, for this distinguished scholar of law and development, I believe the Saudi experience offers a unique and rich case study that it's leaving laboratory of law intersect with the Arabic economic development, and I humbly suggest that is a case truly worth your attention and further research. Thank you so much.
Okay, so we will go to our next speaker. I am not sure though that I know how to do the slides.
I will do it.
You do know? Okay. You do know how to switch them on? Aha, excellent. Okay, so next we are going to hear from the multi-talented Dr. Fabrizia Cesarano, who is a researcher at the Scuola Superiore Meridionali. Did I say that right?
Yes.
Oh, you guys are testing me today. In Naples, Italy, where we all wish we could come and visit her. So, I'm looking forward to her presentation.
Yeah.
Whew. I will, I'll let you know when 5 minutes and 2 and 1 minute.
Okay, go. Okay, so good morning, everyone. First of all, I would like to thank Professor Lee and Professor Chen for the organization. I don't see him, and for all the work that we have done these days and also the months before this conference, and also for choosing me and selecting me, so that I had the opportunity to present my work in such a beautiful venue and such a fantastic setting. So my name is Fabrizia Cesarano, and I'm a research fellow from Scuola Superiore Meridionale, which is a higher university institution in Naples. And I hold a PhD in private law. And in real life, I'm also an artist. And this is not just a curiosity that I pop up to you, but it's very important because it's linked with my research, because I'm very interested in understanding how culture and artistic practices can be linked to property law, and how communities manage in cultural way urban spaces. So this is the title of my paper, because I changed it because probably research is a process. So now it's collective properties and urban commons in Italy between the social function of property and sustainable practice of cultural commoning. And as a proud Italian and proud Napolitan, and following Professor Coino, who yesterday talked about Sardinia, I will also talk about what is happening in Naples, my city, because I think that Naples is a very interesting urban laboratory on this. So before going into the legal aspect of my presentation, I would love to change the slide. But it's not working.
You might need to.
Okay.
Are you doing? Yeah. Sorry.
Okay, it's changed. I cannot
There we go.
change from
Yeah.
there.
Now it's changing.
Okay. So before going into the legal aspect of my presentation, this is like a glossary of the concept that I'm gonna use because I did this because, for example, the concept of commons doesn't have a legal unique definition in the Italian national legal system. So when I'm talking about commons, I talk about assets where material or immaterial reserves that where what is important is in this asset is not who actually owns it, but the function that this asset realized. And we have both urban commons and cultural commons. I will talk specifically about urban commons, so these are goods that are always often public and are usually like abandoned buildings where the community decide to somehow reuse this building in order to give it back to the community. And what I'm saying is that these urban cultures these urban commons are actually urban cultural commons, because in this situation, culture is not something that is made top down, but it's a process. So here it's like culture is a collective process that is rooted in the community. And this thing take me to the right to the city in the way that Henri Lefebvre understood it. So the idea that the right to the city is not just have the access to urban spaces, but actually co-participated and co-create what is happening in the city that you actually inhabit. And I see all these phenomena through the lens of urban regeneration, but urban regeneration understood in a cultural-led way. So I don't think that urban regeneration is just the requalification of a space in an aesthetic way, but it's actually the requalification of a space, an urban space in this case, starting from the participation of the people who actually live the place. And in this way, when we requalify a place, we don't go, hopefully, into phenomena like overtourism or gentrification. And this is something that is actually happening in my city. So this is the question I started from, but somehow the reflection was also that the nature resources are gonna finish, so maybe we should try to find a new way to understand the property. And so in all the presentation, I will not think about property from an individualistic point of view, and so not from a patrimonial approach somehow, but I will try to think about property from a social function of property, so from a personalistic approach that it's actually written in the Italian Constitution. After that, I will talk a little bit about collective properties in the rural area and how this was very important in the Italian legislation, because the only law that we have in Italy about collective property is a law of 2017 about collective rural property. And the link and somehow the difference that there is between collective property in rural area and in urban area. And I will arrive at the end saying somehow that probably we should not link the function, the social function or the cultural function to an asset, to a good, but to the practices. So what actually make a good, a common good or a cultural good is not the static function of the destination of the good, but the practices and the dynamic processes that are gonna actually do the governance of a place. So I will not go into the Italian legislation property law, probably because just Professor Quino will be interested on it. The important thing is that our civil code is on property law adopted an individualistic approach. Also the civil code that we had before 1942, so the one of 1865, had just the idea of property from, I mean, the same of the Neapolitan Code, so the idea that property is an exclusive right. And this situation doesn't really link with the empirical reality that we had in Italy, because in Italy there were a lot of actually collective property all over the state, and these were heritage from the feudalism. So the empirical situation didn't really match to the law. And somehow the Italian doctrine tried to point this out and to make understand how there were a lot of community in Italy that actually used, and in some situation also had right of property to these lands. And so starting on rereading the civil code from the personalistic approach of the Constitution, because even if there are just 6 years of gap between the civil code and Italian Constitution, the Italian Constitution has a personalistic approach on property. So the Italian Constitution say that the property should have a social function, and also if we link it with Article 2, should have a social function and a personalistic approach. So somehow the Italian doctrine, the private Italian doctrine, reread the civil code starting from the Constitution and pointing out all this empirical reality that was part of Italy. And so all the collective property that before were under a fascist law, which was a law from 1927 that said that all the collective right should have been cancelled. So the law was about the liquidation of all these collective properties. They were both property law and also right to use on someone else's owner laws. So there were different kind of rights. And the idea was just to cancel all this kind of rights on the land, because the idea was make the land just be free to be sold and circulated. In 2017, we had this new law on collecting land rights. And for the first time, there was a law in Italy that linked this collective property to a community. So we have both domini collettivi, who are actually an instrument when there is a community that have a right on property on the land. And then we have also usi civici, which is a very, very interesting instrument, because with these usi civici, these are real right of someone else's property, and still it's the community who owns the right. And each individual is part of the community, but me as part of in order to have this right as an individual, I need to be part of the community. So I have this right as long as I'm part of the community. And this is something like unique in the Italian legal system. The only problem is that these civic uses are just on the rural areas. So everything that happened in the urban areas doesn't really fit into this law. And also this law, the principle is the recognition. Is the principle of recognition. So we cannot create actually new collective property. Why I'm saying this? Because we will use again the instrument of civic uses, because what is happening in Naples is that in the urban collective properties, they are using this instrument, which was a federal instrument, a rural instrument, but so they're using it without actually a legal recognition. In Italy, we don't have a legislation of commons. Of course, commons are everywhere since the beginning of the war, probably, but thanks to Elinor Ostrom in 2009, who won the Nobel Prize, we have known more about it. And so she pointed out that with the 8 different design principles, she somehow go through the tragedy of commons, who was written by Hardin. And so Elinor Ostrom pointed out how with these 8 design principles, the shared management of resources actually was better than the individual governance of resources. Of course, other scholars go through it. And in Italy, we don't have a legislation on commons. In 2007, the Rodotà Commission tried to change the civil code in order to put the next to public property and private property, the concept of commons. But in the end, this proposal never became actually a law. The idea, the work of the Rodotà Commission started because in 2007, a group of scholars pointed out how there was a massive privatization of public assets. So there were like 150 billion of euros of public assets who were privatized without actually a real in theory, when you privatize the public assets in Italy, is because that asset doesn't have any more a public interest. But this was not what actually happened. The privatization, the idea of the privatization was just made because of political and financial problems. And so this proposal never became a law, but the definition from the that was written in the Rota proposal was used in a lot of regulation about urban commons that are now made just in a regional and municipality legal situation. And that's because what happened after the Rota Commission and after the referendum on water as a common good, a lot of communities begin to occupy public spaces that were both in disuse or were under a process of privatization. So the first one was a theater, Teatro Valle in Roma, and this community decided to occupy it because the state wanted to transform it in a casino. So now we have two different kind of urban governance models. One that is the co-managed model that I will not talk about it now, but and the other one is the collective self-governance model. That is the one that is happening in Naples, because Naples is the only city when we change the municipality state and we put in the municipality state the concept of common good. And there were, in this map you can see it, 13 spaces that after the occupation that started from a group of artists or people who actually work in the art or culture field, all these spaces are now being recognized as civic uses, urban civic uses. Of course, this is not actually a legal recognition because it's more like a political act and a political recognition, and also is linked to the specific asset and the specific building. What happened in all these places, I will not still go through it, but I've been part of an urban laboratory, living laboratory on one of these places. And these places are like the heart of the community and the neighborhood. So there are, I don't know, exhibition here. In each of these there is a theater, but for example, there is like a free legal clinic, or if you have a medical issue, there are some doctors there that can help you. So it's like these are social and cultural spaces. Of course, these are civic urban uses are not the same as the rural one from a legal perspective, because they're can go under the law of 2017 because they, first of all, the community is not formal, so it's an informal community. And the people that actually do the governance of these places are changed in every time. The fact is that the practice is always the same. It's a mutual horizontal practice where there is an assembly. So if you want to propose something, if you want to be part of the community, you just have to show up and be part of it. And the other point is that, of course, the law, as I said, the one from 2017, is just about the rural areas. So it's not possible to recognize these urban civic uses as the civic uses of the law of 2017. There are some limitations, of course, of this model. First of all, they're based on a political act, and also the decision making is very difficult and it's challenging because everything is very horizontal. So what I'm saying at the end is, at first, probably understanding that these are real rights of someone's owner could be something, but more of it, I think that we should go from the idea of urban commons and of commons to the idea of commoning. So coming from the static and traditional category to something more dynamic, and so link the function to the practices, both the common function and social function of property, but also the cultural function, because the problem is also that all these places are not recognized as cultural goods in Italy. So they are not cultural goods, so they cannot get the cultural funds. So if we get if we link the function to the practices and the governance somehow, maybe we could understand that these places actually realize the right to the city and urban cultural-led urban regeneration. And that's it. These are some references. Thank you. Thank you so much.
Presentation was slow to load. Okay, wonderful, both of you. And so for our final speaker, we have Eugene So, who's at the Law and Development Institute. And I have to say, an extra thanks to Professor Chen and Professor Lee, but also thank you to you, Jen. So we're excited to hear about your research.
Good morning, everyone. So today I would like to give a presentation about how bilateral investment treaties function during wartime using the ongoing conflict between Russia and Ukraine as primary case study. So usually we think of investment treaties as tools for peacetime economic cooperation. But what happens when the host state and the investor's home state go to war? This presentation explores legal applicability, necessity, feasibility of implementing BITs during political crisis. So I would first briefly mention the factual background, the key components of BIT, and discuss Russia-Ukraine BIT in some key cases, and mention how implementing BITs during political crisis work, and give a brief conclusion. So to understand the legal claims, we have to first understand the factual background. Conflict between Russia and Ukraine dates back to 2014, when Russian special forces took control of the Crimean Peninsula, leading to its formal annexation in March 2014. This created a unique legal situation. Ukrainian companies, which had previously been domestic investors, suddenly found themselves in the territory under the de facto control of Russia. Then in February 2022, the conflict escalated into a full-scale invasion, as we know now. In both phases, Russia implemented expropriation measures, seizing Ukrainian assets such as petrol stations and nuclear power plants, which triggered a wave of international arbitration claims under the Russian-Ukraine BIT. So BITs are agreements between two countries that establish reciprocal obligations concerning the promotion and protection of investments made by investors from one contracting state and the territory of the other. BITs typically encompass four elements, which are the fair and equitable treatment, full protection and security, compensation for expropriation, and the investor-state dispute settlement mechanism. First is fair and equitable treatment, which is one of the general standards of the treatment. And in the Russian-Ukraine BIT, Article 3 states that each contracting party must provide a regime no less favorable to the investments that it grants to its own investors or investors of any third state, thereby ensuring national treatment and most favored nation treatment as a matter of fair and equitable treatment. Full protection and security ensures the physical, legal, and commercial security of the investments. In the Russia-Ukraine BIT, Article 2 states that each contracting party guarantees the complete and unconditional legal protection of investments of the other contracting party, encompassing the concept of full protection and security. The third element is compensation for expropriation. Most BITs do not allow expropriation unless they meet the general four requirements for lawful expropriation, which should be carried out for a public purpose, conducted on a non-discriminatory manner, implemented in accordance with due process of law, and accompanied by prompt, adequate, and effective compensation. In Russia-Ukraine BIT, Article 5 states that investment should not be subject to expropriation unless it is non-discriminatory and entails prompt, adequate, and effective compensation, and that the compensation must correspond to the fair market value of the investments, conforming to the compensation standards. And finally, the investor state dispute mechanism offers investors to sue sovereign states directly. Among the most frequently used institutional forms and rules are the International Center for the Settlement of Disputes. And other than these institutional systems, BITs also allow submitting the dispute to ad hoc arbitration. And in such cases, parties frequently agree to conduct dispute proceedings in accordance with the arbitration rules of the United Nations Commission on International Trade Law. In the Russian-Ukraine BIT, Article 9 states the ICS principle, where a dispute can be submitted to the Arbitration Institute of the Chamber of Commerce in Stockholm, or an ad hoc arbitration conforming to the UN Commission on International Trade Law regulations. So the Russia-Ukraine BIT, which is at the center of dispute cases between the two countries, was signed in 1998. And although Ukraine has moved to terminate this treaty effective January 2025, the sunset provision ensures investments made before termination to remain protected until 2035. Amid the war between Russia and Ukraine, the most important question is whether the BIT applies during the war. The treaty does not explicitly say it applies, nor does it say it stops. However, Article 6 mentions that compensation for damages due to war or civil disturbance, implying that the treaty is intended to survive the conflict. Several key dispute cases between Russia and Ukraine identify central considerations to analyze BIT implementations during these political conflicts. So between 2014 and 2022, 10 known ISDS cases were brought against Russia by Ukrainian investors. And among them, the Stavela and others versus Russia, Oscar Bank versus Russia, and Naftogaz versus Russia are notable cases. So started in 2015, the Stavela and others versus Russia case was brought up regarding the expropriation of Crimean petrol stations owned by Ukrainian investors. And Oscar Bank versus Russia case was brought by Ukrainian Public Joint Stock Company when they were faced with a prohibition on banking activities and some fiscal seizure of cash and valuables they own. The Naftogaz versus Russia was brought by Ukraine's national oil and gas company and in response to Russia's expropriation of their assets invested in Crimea. In these cases, the key issue was that the tribunals had to decide if the BIT applied to Crimea, and the tribunal concluded that Russia has de facto control over Crimea, and that the term territory includes all territory over which a contracting party has de facto control, thereby acknowledging territorial jurisdiction. The tribunal's decision demonstrates that claims under the BIT do not require a Ukrainian company to accept that the occupied regions are under Russian sovereignty as a matter of international law. Rather, Russia exercising effective control over the relevant territory, including fiscal occupation, is sufficient to activate the obligations that a host state is required to provide to investors. Russian entities have also invoked the BIT to file claims against Ukraine, and among them, the Russian state-owned bank filings is most notable. So BEB initiated arbitration proceedings in 2019 in response to its assets being seized in Ukraine, specifically referring to rulings by Ukrainian courts that authorized the seizure of its assets in Ukraine to satisfy the $150 million award rendered in Everest versus Russia. Well, this proves that the BIT is also a two-way street used by entities from both sides of the conflict. Based on the examination of such cases, the applicability, necessity, and feasibility of implementing BITs during wartime can be further analyzed. So in terms of legal applicability, the overarching principle as reflected in the International Law Commission's draft articles on the effects of armed conflicts and treaties is that armed conflict does not, ipso facto, cause termination or suspension of a treaty, and BITs are included in the list of treaties that continue to operate during armed conflict according to the annex of the article. And also, the Vienna Convention on the Law of Treaties may also be taken into consideration. Article 63 of the BCLT also states that the experience of diplomatic relations between parties to a treaty does not affect the legal relations established between them by the treaty, implying that the state of war itself does not cause a change in the effect of the treaty. However, states may raise jurisdictional objections. The BCLT Article 61 is a provision on supervening impossibility to perform, allowing termination or withdrawal by invoking impossibility of performing if a necessary object or for performing the treaty permanently disappears or is kind of destroyed. While this provision is not necessarily triggered by armed conflict, such an outbreak can create factual circumstances that may be questioned under these doctrines. But yet taken together, regardless of whether a bilateral investment treaty expressly addresses its applicability in situations of war, the decisive issue lies in the interpretation and application of the treaty provision in individual cases. And the ISDS cases between Ukraine and Russia illustrates that arbitral tribunals have been willing to assert jurisdiction under the BIT, bypassing the complicated question of legal sovereignty over Crimea. This brings us to the question of the reason why BIT should be enforced during wartime. Some argue that the very objective of BITs is to promote foreign investment in the host country by enhancing protections or enabling them to seek remedies when provisions have been breached. Others argue that upholding BITs in situations of political conflict can unfairly restrict a state's sovereign rights to address security concerns and protect its security interests. However, without an explicit suspension clause, a state generally cannot suspend the BIT in full on security grounds. Instead, such justification would depend on the security-related justifications of specific measures taken by the host state against the foreign investors within its territory. Moreover, the continuing application of BITs may help promote peace by penalizing aggressors, aligning with the concept of lawfare, where legal tools substitute for military force. Additionally, when a contracting state faces military attacks from the other contracting state, BIT and ISDS mechanisms can name and shame the aggressors through legal adjudication. And more broadly, strong treaty commitment can deter conflict by forcing states to weigh foreign direct investment benefits against the reputational risks of ISDS claims. In addition to the questions above, the practical feasibility of implementing BITs raises further considerations regarding the underlying political and economic factors. First, the procedural challenges may emerge, including delays in appointing the arbitrators to ad hoc tribunals. So, in the absence of a permanent international investment court, arbitral tribunals are essentially ad hoc, often consisting of 3 members. One chosen by the investor, one selected by the state, and a third member who is mutually agreed upon by the arbitrators. Under the arbitration rules of the UN Commission on International Trade Law, when parties disagree on the appointment of arbitrators or when one party fails to participate, the appointing authority intervenes. In Russian-Ukraine cases, Russia did not appoint the arbitrators after the claim application, leaving the appointing authority to appoint the second arbitrator. The economic feasibility of BIT implementation in a political crisis revolves around the issue of how the award can actually be enforced. And under the New York Convention, arbitral awards are enforceable wherever the respondent's assets are found. So, for example, in 2023, Ukraine state energy company Naftogaz was awarded $5 billion in compensation for unlawful expropriation of its assets in Crimea. And Paris main civil law court has recognized it, allowing Naftogaz to register mortgages on Russia's state-owned assets located in France. However, sovereign immunity may be invoked as it shields assets tied to sovereign acts like military operations. But still, sovereign immunity does not apply to commercial matters or where there is state consent. And the state's initial consent to BIT forms the basis for the enforcement of arbitral awards. Additional challenges lie in matters such as asset location and availability. And Russia holds kind of limited foreign assets, and also multi-jurisdictional enforcement can involve high posture costs. So the Russia-Ukraine BIT and the investment disputes between the two countries have presented a valuable case study for examining the applicability of BITs in situations of political conflict. And despite other viewpoints, the legal applicability and necessity of implementing BITs during wartime continue to carry significant weight. And while actual enforcement faces practical hurdles, international legal mechanisms provide a pathway for investors to seek redress even while the conflict continues. Thank you for listening to my presentation.
Good job. Really fantastic. All three presentations were just great. So we have, I think, about 15 minutes for Q&A before lunch, and then hopefully you can continue conversations over lunch. Go ahead.
My question is for Fabrizia. So I really appreciate the presentation. Like you and I have discussed this before, that my own city where I was born, Barcelona, does have a similar movement. So I wonder to what extent the Italian system solves the issue, like rather squares the circle rather than solve the issue with the same tools. Because in Spain, like the way that you put it, it seems that it's recognition, but it's not consolidation. So to me, it sounds more like tolerating the use rather than actually accepting it. The way that I think it is solved in Spain is by going all the way back to Roman law. Centuries and centuries, we do like old stuff in Spain. And if you've been there, you'll see buildings everywhere. So the way that it is solved is by like ius capio from Roman law, where depending on the conditions in 20 or 30 years, someone that has effectively used that property and has paid all of the services associated with property can actually have a sustainable and righteous claim to the property. And that's how it's solved. And that is an actual legal recognition. So I wonder, having explained that, I wonder what happens if someone goes to one of those commons in Italy with a claim of ownership that effectively opposes this common use, and how is it helpful?
Ius capio couldn't work in this situation in Italy. First of all, because you can do it with a public space. So usually these are public buildings, so this is not possible. And also in all this situation, as you said, there is like toleration, but the municipality, for example, pays the bill. So there isn't like a real usucapio, as in the Roman law. We have usucapione in Italy too, but the idea is that there is not just a toleration from the other part, but in a situation, for example, if I occupy a place that is your property, for example, but if I pay each month some money to the rent, exactly, and this kind of stuff, this is not an occupation at the end. Or if you do anything to prove that you somehow knows and understand that I'm occupying the place, the usucapio stop. So this couldn't work in this situation, because they try to. A lot of people linked this. A lot of scholars linked this civic use to the public use of the Roman law, which is actually better than the civic use in the rural area for all the reasons that I said. Actually, what I think we should do is to recognize these urban civic uses as a typical right of ownership of someone else's property. But I need to study more about it to prove that. But yeah, in Italian legal system, usucapio couldn't work.
Thank you.
Thank you so much for the question. So you had a question first, and then we'll go here and okay, we'll take all of the questions. We could maybe take two at a time. Let's do that. Go ahead. Berna.
Sorry. So my question's so I was just wondering, and it might be a little out of date, I don't know, but Have you thought about the concept of previous extendedness as an argument for terminating the treaties during political war? And the reason I asked is that when I was a baby lawyer and we sued to represent American investors suing Argentina during their financial crisis, that was one of the arguments that I have taught PIL for 2 years. I don't know if it's out of fashion. There's
thank you for the question. I actually haven't heard of that concept. I'm still in the learning process, so I guess I would have to look up about it, but I think that's something I have to learn more. So that that's all to answer for now. But thank you for your comments and questions.
Thanks, go ahead. And then we'll go here, and I don't know whether I missed any hands. I hope, go ahead.
Thank you. Kind of refrain from asking a question to Fabrizia. This is also intended to give us the opportunity to explain how rural uses can be maybe the ultimate shield for the protection of the environment and landscape in Italy. There are hundreds of thousands of civic uses scattered throughout the rural areas in Italy. And to be clear, these are places where anyone can go for a walk or to the mountains to pick mushrooms and asparagus and graze sheep and cows. And according to the civil code, they cannot be sold or modified in their use. Especially, they cannot be sold to private individuals or especially companies such as the telecommunication companies that would like to buy them to install antennas or ensure total coverage of the territory, or to renewable energy companies that would like to install plants over there. So I wanted to ask Fabrizia if, in her opinion, how long they will be able to resist the economical and political pressure resulting from the most recent European Union policy, but actually global policies. For example, as we were saying yesterday about the renewables.
Thanks to research scholarship. I think that you pointed the point somehow because these are sustainable way to manage the resource. So the idea is also, as I said at the beginning of the presentation, we are running out of resources. So we need to think how to manage and governance the resources. So that's why we think about reuse, requalification, urban regeneration, rural regeneration, and all this kind of stuff. So I think that probably really thanks to research and activists and all the people who are just saying, come on, look at this situation. The communities and the people are not just enjoying these spaces, but really their life is getting better thanks to these places, and they know better how to governance and to manage these resources than, I don't know, a random company that comes pop out from another country. Maybe this could be a way, but I don't know. I'm very, hopeful. Optimistic. Yeah, we need optimism.
Thank you. It's also very delightful presentations. Thank you all. So I have one question for Mr. Al-Juhani and William. So the question of codifying Sharia law is fascinating, partly because I worked with Mr. Salim Bara. I'm sure if you've heard him, it's a well-known Muslim scholar. His British origin is a white guy. His long descendant came from Syria. It's practicing Muslim. So he says, look, codifying Sharia law would involve huge political risk because everybody's afraid of being deviated unintentionally from the Sharia itself. And religious aspect. So my question to you is that the reason why codification has been stagnated? Or underneath of that, is there any move by scholars else to modernize or reflect against that, which is sort of state side. I'm curious why real reason behind the stagnation. This question to you, Eugene. I mean, I got fascinated by your paper because at the time of war, killing each other, that's what we do. And then somehow we have to protect the investor from the other combatant country. Psychologically, it's hard to process, right? You got to win this country, but then again, we have to protect the investor from that country. And that's actually what's happening by the tribunals. So how do we resolve or reconcile this condition? We have to be at a higher level thinking that, okay, we might be killing the soldiers from the other country, but we are protecting love investors from the other country. The humanity has to be changed like that. More realistically, do you think we should have a pragmatic clause in, investment treaty that says, at the outbreak of war, we can't apply this treaty? Well, which one is the way to go? So I guess it's okay.
Very good questions.
Okay, thank you from Lee for this, insightful question. And I'm still researcher. I believe, going beyond the narrative that, because usually how the issue of codification in Saudi Arabia or in general in Muslim countries presented as there is, a religious resistance for this, say move, which is in fact, I think it's true, but it will give us, limited view for the issue itself. As you mentioned, it has a political part, which is, I think, knowing the history of these codes, how being, imposed on these countries, it's imposed by, let me say, by, incubation, by, as people and native, describe it from foreigners, which is the case mainly what happened in Egypt. Egypt, it's central and influential case for, in modern bureaucratic Arab country, all Arab countries. Also, I believe also, and this is highlighted by Dr. Mohammed Fadl. He is a professor in Toronto Law School, writing intensively in law and Islamic law and modernity. And he also, there is an issue that the clash between Sharia and modern laws, it has happened with the French civil law, which is sometimes, I try to find a nice word, a rigid, type of laws, and this is linked to, and that's linked for the history of France itself, because these laws, it's not just for implementing doctrines, but also for political view, raising the kings and, so he argued that Sharia mostly, similar to common law. And I think more, research and more, work on linked Sharia with common law will give, better results. This is, his argument, and I lean with that argument. So I think the history has, root. Also, there is a somehow religious, resistance, but it's not, complete, factor in this issue. There is a political, and the case of Saudi Arabia also, show us, a new, case how the state, being pragmatic with aligning modern concepts with, we say, traditional practice.
I just have a very quick follow-up question. I think that's such a good question to ask. When you mentioned at the end of your presentation that there should be flexibility in the approach, is this what you had in mind? Is that what you meant by flexibility, or did you have something else?
Yeah, exactly. I'm and also just, I want to point that I'm trying to be descriptive. Maybe, I have, views, but my analysis here to just, show the case. Sometimes I have a view contradict with the description, but Yeah, I mean, my work here just to show the case itself. In my dissertation, also extend my work to current, cases from the commercial code. New commercial code, how they apply civic transaction law. And there is outcomes fascinating, and also it's approved my argument, which is it's a bureaucratic administrative rationalization. It's not illegal because this is new cases. I make analysis for 40 commercial cases, and I find that the practice of judges with laws, it's still same as before. Nothing has changed.
Very interesting. Yujin, go ahead.
Yeah, so thank you for the question. And I personally believe that we have to consider both viewpoints because like ideologically, I do believe that even in situations of war, especially if we consider like international humanitarian law, there are some things that need to be protected and secured, even in the tragic situation of killing each other. But practically, I do believe that bilateral investment treaties should make specific clauses if they can, because I think the current like geopolitical situations is not that peaceful. Obviously, the Russia-Ukraine war is ongoing. Conflicts has happened in the Middle Eastern, and obviously also East Asia is not really safe from those kind of conflicts. So yes, I do believe that these kind of war and political conflicts might happen again. But in the complicated world of investment treaties and international investment law, that might cause problems that investors haven't really thought about before making the investment in the host country. So I think making specific clauses would be a part of a practical solution for now.
Very good, very good. I think you have the final question. Sir, go ahead.
I have two questions for you, also from mine. But I will provide some recommendation for you. I appreciate a lot the presentation of Brahim, because you support also my arguments concerning the problem with diplomatic protection. You can use it now in the situation of crisis, but also you can look on the recent book of the Fabrizio Marini, an Italian colleague from Venezia University, and they released a book about the armed conflict within international investment law, 500 pages, very interesting book about this issue. And my question to you, if I understand well your reflection, you suggest a hardship clause within the BIT or force majeure clause. I want to understand if it's force majeure clause or hardship clause. It will be very interesting if it's hardship clause because you can renegotiate the BIT during the crisis period. It will be very interesting. For Wahab, it's just about the new Saudi investment law since 2024, I think. Because if I understand well, the Saudi Arabia give the jurisdiction to domestic courts to resolve the investment dispute between foreign investors and Saudi Arabia. Could you tell us more about that? Because it's very interesting. It's a modern approach. Carbo clause. We can find it the same within the ASEAN agreement between USA, Canada, and Mexico. We can resolve the dispute, investment dispute between Canada and USA before the domestic courts also.
Very interesting. Picking up on themes from the last panel. So I'll ask each of you to respond briefly, and Fabrizio, if you have any parting, final words, you are welcome to share those too. Maybe just take a minute or so each, since we're almost to lunch. So go ahead.
Yeah. So regarding first, thank you for the recommendation of the book. I will definitely look it up. And regarding the clause, I guess I'm not quite like familiar yet with all the concepts of international investment law. So, but if I just kind of make a brief recommendation, I think it would be better to if countries and if countries can, I think it would be better to like renegotiate, like you mentioned, the BITs, especially considering that, especially that they have to consider possible political conflicts. I mean, it would be best if not those conflicts does not happen at all, but considering how political climates are right now, I think it would be nice for countries to have the chance to kind of renegotiate specific clauses if they can.
Thank you, Dr. Ali. And I have to mention Dr. Ali is a scholar that I benefit from him a lot of things. I mean, to be honest, and I have to admit, I did get a chance to look to the law itself. But one thing that I want to highlight that that's not the first, law being issued about the investment. There is Investment Act issued in 2004. And Stephen Hertig in his book, Princes, Brokers, and Bureaucracy, Oil and State in Saudi Arabia, in chapter 5, he lay out the history of this law, which is the Investment Act. And from that chapter, I departure to reach to this paper. So his argument that it's not about law, it's just about the interest of each ministry, how they defend sometimes the implication of the law. So this is one thing just I want to make comment about.
So Fabrizio, did you want to say anything final? Well, no? Good. Thank you for listening. Thank you for the comments and the questions.
As to why, well, proponents say we need this protection because outsiders are going to come in and are coming in, appropriating our culture, which they want to commercially exploit and kind of commodify. And in this process, they're going to adapt it and adulterate it, contaminate it, degrading the heritage, causing harm to the heritage and to the underlying source communities. There's a whole literature kind of documenting these harms. And I should say this isn't just a theoretical debate. These rights do in fact exist. There are many countries widely have it. Actually, these rights are widely adopted in countries in the global south. There are regional agreements in effect. And in fact, there are some multilateral treaties under negotiation in Geneva, the auspices of the World Intellectual Property Organization. So people are really pushing this. There is, of course, the critical literature, which is skeptical of this propertization approach. I'm not the first one to raise objections. And most of the critics kind of focus on the harm, the sort of undesirable or unintended attribute results of a propertization model. They question the notion of a community as maybe an arbitrary construct. And they also ask about who's going to actually control these rights if they're deployed, who are these so-called cultural stewards who are going to guide the culture? Are we just handing the keys to the culture, to the heritage, to a bunch of grumpy old men who are going to censor anything that's new and jarring and discordant? And also silence alternative voices and perspectives within their community. So this is the critique essentially that focuses on the property model, propertizing natural heritage, and basically arguing the cure is worse than the disease. So unintended consequences of this approach. So I agree with this critique and kind of incorporate some of it in my paper. But my emphasis here is really slightly different. Rather than arguing about criticizing the cure of intangible property rights, I want to suggest in this presentation that the disease, commodification, in some cases is not quite as scary as advertised. And to illustrate this, I have a couple of case studies that I'm going to present. One is this example of Cuban music, which is a case in which I think commodifications played you could argue a constructive role, maybe even a laudatory role in helping the heritage evolve, get recognition. The second is actually one closer to home, right here in Hawaii, the hula, the native dance form. And here I argue commodification may have initially seemed bad, but the point is it gets better. It has gotten better over time. So if it's a disease, it's kind of a self-curing one. We don't need external rights. Okay, so we start with Cuba and roll the clock back to the end of the 19th century. If you looked kind of what Cuban music was and asked what's this form of heritage, it's really a tale of two different types of heritage. If you go to Havana, hang out in elite circles, and ask what Cuban music is, you'll be exposed and treated to something that's basically a derivative version of Spanish music. Guitars and kind of stuff in the European folk and classical tradition, musical expression kind of in that vein. That's slightly Cuban versions of it, but that's what they would say was our musical heritage. If you go to the eastern part of Cuba, however, the population was heavily Afro-Cuban, and you would find a different type of music that was really reflecting the heritage of the Afro-Cuban population that had brought their culture from West Africa. Music involved a lot of drumming, which quite scandalously involved drumming with your hands rather than civilized drumsticks. And at least the elites kind of looked down on this music, but that was the music you would find in that population. The interesting thing that happens as the century turns, we move into the 20th century, is that some of those Afro-Cuban musicians make their way to Havana, and there's a little kind of cross-pollination and sort of a hybrid fusion music evolves and emerges that blends Spanish guitar with African rhythms and really yields some quite exciting results. It's not just the Afro-Cubans, it kind of becomes the music of the working class. And there's these new forms, the son, the rumba, bolero, and different sort of forms of these hybrid musics that are really quite exciting, and people are really into it, but not the cultural elites. They are actually quite scandalized by this barbaric African influence in the music and actually take steps to repress it, and their police rage shutting down the clubs where this is being performed, and all this kind of criticism among elite circles of this music that's disgrace, reflects the ignorance and degeneration that has contaminated Cuban music, quote, at the time. They criticize rumba as this writhing African jungle dance. So really quite racist, classist attitudes, the so-called cultural guardians. So maybe this is an example again of if you had heritage rights, it'd be used by these people kind of repressive ways. But I don't want to focus on that. I want to talk about how things kind of turn around and really the agent for kind of getting these new exciting musics to receive recognition and credit and they were due, came through the agent of commodification, external commodification in the guise of Yankee tourists who are attracted to Cuba in growing numbers during Prohibition initially. They come for the rum, but they stay for the rumba. And some of the avant-garde musicians, George Gershwin was among them, seek out these underground music halls and are really interested in this new music. It's really exciting to them, and Gershwin brings it back and incorporates it into some of his own compositions, but it eventually spills out beyond just elite avant-garde circles in the US. It incites this whole Cuban Latin music craze that brings in all these musical forms, somewhat adapted and adulterated by Cuban Americans for mass audiences. But that consumption in the US spurs new interest and more tourism, and more American tourists are going to Cuba specifically to encounter this music, and they're looking, for the authentic source as close as they can find. And so eventually the Cuban elite authorities recognize there's money here, and they begin to sort of acquiesce and accept the music, and even start to find some pride over, a decade or two, a new generation comes up and this becomes like the national music of Cuba. That's widely recognized both in Cuba and internationally. And by the 50s, this is the music that dominates and receives all this recognition. There's a little kind of further kind of coda to my story, I'll say quickly. At the end of the 50s, there's a revolution. Castro comes in and introduces a socialist regime, and he rejects this old music as part of the old regime, and all those musicians are thrown out of work. And new music that's more keeping with socialist values is the kind of received official recognition. And again, the revival of this old music, this musical heritage, is recovered through the agent of commodification. This is really the story of Buena Vista Social Club, which those of you who don't know that album, you should. It's a Grammy-winning, widely successful album that was then an award-winning film. And it's actually now a Broadway musical. It's playing on Broadway at Juan Tony's. So yeah, commodification in Cuba, I think actually, say arguably, has kind of a benign role in getting musical heritage, particularly from these lower working class Afro-Cuban roots, giving it recognition that the ruling authorities weren't going to give it, didn't give it. Okay, and there are other examples of this where commodification has played this sort of somewhat emancipatory role in giving recognition. I talked about a few of them in my paper. I want to transition to Hawaii, where actually you could tell a little bit of the same story to some extent about the hula, which was originally banned at the behest of the white Christian missionaries that convinced Queen Kaahumanu to ban public performances of hula in 1830. It remained banned for many decades. And part of the story about how hula becomes rehabilitated and gets recognized is the story of commodification through tourism. I don't want to overemphasize that story. It's really, most of the credit goes to the Hawaiian people in this instance, so it's only kind of a secondary role. But the story I want to tell about hula is more just the way it's commodified. Because I grew up here in Hawaii, and I can remember going to Waikiki and other places where a commercial commodified hula is presented. And I remember it was being, as a young adult, it was kind of tacky and vulgar and not quite the same as the hula you would see elsewhere in non-commodified settings. I'm not saying you can't encounter that same experience today, but in general, I think the visitor industry, the type of hula you see performed, is a little closer, and the experience is the level of care and attention to cultural, to the roots of the culture and the way it's presented is a little closer to hula you would find outside. And that's true to a number of reasons. Native Hawaiians have put some pressure on Waikiki and the tourist industry to raise their game. But I think it's also that the audiences are receptive to it. And there actually is a lot of repeat visitors to Hawaii, and people have been exposed to hula through various commodified forms, but they come to Hawaii looking now for the actual quote authentic experience, and they're not getting exactly that, but there is a real receptivity to that. That's partly due to repeat exposure over time. And this is kind of the theory I have about culture and cultural commodification. You can see this also. 2 minutes. Okay, thank you. You can see the same. Thanks. You can see this same phenomenon with ethnic food, where I grew up in Hawaii. I think we had pretty good Chinese restaurants even when I was a kid, and I did go to China in the early 80s. So I had a pretty good idea what Chinese food I thought should taste like. And then I went to the mainland. As a kid, I remember a family friend took us to a chop suey in Boston. And it was like the most revolting, sweet and sour, cornstarchy slop that was, I guess that's what Chinese restaurateurs thought they needed to do to their food to make it receptive and palatable to people in Boston, restaurateurs in Boston. But you can go to Boston now and find actually quite good Chinese restaurants and a very kind of sophisticated array of Hunanese and Sichuan, not just Cantonese. And so you see an evolution of taste over time, that the food gets translated, and initially it's kind of an ugly, adulterated process that looks quite vulgar and degraded, but maybe the level can converge upwards. Not that it drags down the normal narrative in cultural protective, it's that this contamination is going to spread back to the source and drag that down to the gutter. But actually, I think what you see with ethnic food and hula is more of a convergence upward. The hula continues, and in fact, in Hawaii with the native sovereignty movement and more investment is, recovered more of that traditions. But the commodified version has been kind of leveling upward the convergence. So maybe it's actually a benign thing that may seem initially ugly and repulsive, but the problem kind of fixes itself. So I'm not claiming this happens all the time, and even it's the rule, not the exception. But I guess what I am saying is there's a bit of epistemic uncertainty we have about how things are going to play out, and maybe we don't want to appoint cultural stewards, and we want to approach some gentler approaches to cultural stewardship rather than property. Thank you.
Our next speaker is David Finnegan.
So let me begin by thanking Professor Lee and the Law and Development Institute for hosting another wonderful conference, and also to Professor Chen and the Richardson School for being such gracious hosts. My paper takes a traditional property law principle, the numerous clauses principle, and explores how it might be used to evaluate land law systems in Africa using Tanzania as a case study. The numerous clauses principle is a common feature of property law systems around the world, and has long been used by legal scholars as a tool to compare the specification of property rights and of property law doctrine across national legal systems. But much of the comparative literature on the numerous clauses principle and its functions focuses on legal systems in the developed world. So the paper hopes to contribute to an understanding of the principle by exploring its usefulness in the African context. So I'm going to begin by briefly describing the principle and some of its functions, and then discuss briefly the case of Tanzania. So first, something about this numerous clauses principle. So in most legal systems, there's a presumption in favor of freedom of contract. With limited exceptions, people and corporations should enjoy wide-ranging autonomy to create legally binding relationships that are enforceable as contracts that give rise to enforceable rights and obligations. But when it comes to property rights, the presumption runs in the exact opposite direction. The legal system constrains individual autonomy when it comes to the creation and transfer of enforceable interests in land. These constraints are reflected in this numerous clauses principle, and the principle involves or embodies two related propositions. First, that the legal system fixes and limits the number and types of enforceable interests in land. So when you're engaging in a real estate transaction, you lack the autonomy to create and convey new and different types of land interests. The state, via the legal system, provides a fixed menu of available interests in land, and you can pick and choose from that menu when you're deciding what types of ownership interest to create or to convey, to transfer in some way or another, but you can't order off the menu. The class of available interest is closed, numerous clauses. Second, the legal system defines in a fixed and ascertainable manner the rights and characteristics of each recognized type of interest. The scope of each enforceable interest is fixed. So market participants further lack the autonomy to bargain over and to alter the characteristics of particular land use interests when structuring transactions. There is broad consensus today that legal systems around the world generally reflect the numerous clauses principle. In civil law jurisdictions like those in continental Europe, the principle is typically incorporated explicitly into the applicable code. In Anglo-American common law systems, like in the United States or Australia or the United Kingdom, the principle is reflected in patterns of judicial enforcement of traditional and statutory property rules. So let me say something about the functions and purposes served by this principle, by structuring a property law system in a manner consistent with the principle. Comparative legal scholars have identified a range of purposes and functions served by standardizing property rights in this manner, including reducing information costs, making market transactions more efficient, facilitating and promoting legal certainty, better protecting the rights of third parties, and even safeguarding basic freedoms. So let me just comment on a few of those purposes, starting with market efficiency. The standardization of property interests operates to reduce potential transactions costs associated with land transactions, particularly measurement and information costs. Standardization prevents the proliferation of idiosyncratic property interests that would require costly case-by-case assessment by legal professions to figure out, what's going on with these new and unusual interests. By limiting property interest to a standardized set of enforceable rights, the legal system provides a common vocabulary that lawyers, courts, and market participants can understand. And so when market participants approach a particular transaction and they're presented with a fee simple or an easement, they kind of know what that means. They know its essential characteristics, the scope of the rights involved, without having to spend time and money on extensive investigation. So that's one arguable purpose for the principle. Another has to do with legal certainty and protecting the rights of third parties, people that are not involved directly in real estate transactions. The principle contributes to certainty about the content of each type of property interest and the rules governing its creation and transfer, and it thereby contributes to foreseeability and predictability regarding interests in land for both parties to a transaction and to everyone else. A contract generally impacts the rights and obligations of the contracting parties, those who are now in privity of contract. But property rights have an in rem character. If a seller conveys an ownership interest in land to a buyer, the buyer obtains rights that are not just enforceable against the seller, but against the rest of the world. And so how does the rest of the world, third parties not involved in the transaction, sort of come to an understanding of what those enforceable rights mean? The principle protects third parties by ensuring that land transactions follow predictable patterns that can be adequately communicated through established recording, registration, or other notice systems. And this helps ensure that third parties will understand the scope of the rights involved. They will act in a way that is consistent with those rights, not risk violating them. And that has the effect of reducing the likelihood that land use conflicts will resolve or will result in the first place. At least that's the theory. So let me say something about the Tanzanian case, thinking about how we can take the principle and use it to evaluate land law in that country. Much of the comparative literature on numerous clauses discusses the principle in the context of civil law and common law systems in the developed world. But to what extent is the principle relevant to land law in Africa? Is the specification and enforcement of land use rights in Africa consistent with numerous clauses? African legal systems comprise both formal and customary land use rights, as we heard earlier today. Does legal pluralism impact the likelihood that the purposes of numerous clauses will be achieved? And to what extent can the principle be used as a tool to assess the legal framework and to suggest avenues for future land law reform? So my paper considers these questions by examining the case of Tanzania. Now, the express terms of land law legislation in Tanzania appear on their face to be consistent with the numerous clauses principle. They provide a menu of interests in real property that will be recognized and enforced in the country, and the statutes codify rules governing the disposition of those interests. At the same time, the statutory framework creates rules and procedures that, as applied, may actually work to undercut the numerous clauses, that may impede the ability of the legal system to accomplish the purposes underlying the principle. And I briefly discussed two examples in the paper. One has to do with the role played by government administration of land law in urban areas in Tanzania. And the other has to do with legal pluralism and the specification and enforcement of customary land use rights in rural parts of the country. For purposes of my remarks here today, I'm going to focus on land law administration in urban areas. You heard Jonathan in his keynote address yesterday refer to the 21st century as the century of the city. The United Nations recently projected that by the year 2050, there will be over 35 megacities, cities that have populations of at least 10 million people. And one of the cities that will be added to that list by 2050, actually 2050 is what I meant to say, is the city of Dar es Salaam, which is the largest city in the commercial capital in the country. So I'm going to talk a little bit about some of the land law rules that apply to cities in Tanzania. So the primary form of possessory rights recognized in Tanzania, the main form of title available in Tanzania is called a granted right of occupancy. By statute, all land in Tanzania is public land and is vested in the president as a trustee for the people. And so the government grants rights to occupy land and issues certificates acknowledging the granted rights. The granted right of occupancy lasts for a fixed term up to but not to exceed 99 years, but they're subject to renewal under certain circumstances. And once granted, the holder of the certificate can dispose of the right in a number of ways, including by sale. So these rights of occupancy may be sold. On its face, the Land Act codifies a fixed menu of interests in land, but at the same time, the Act authorizes substantial administrative variation in the scope of granted rights when they are created. And that variation introduces measurement and information costs that dilute the principle's efficiency promoting functions. Granted rights of occupancy are subject to use conditions imposed by the government at the time that certificates are issued. And failure to abide by those conditions may lead to fines or forfeiture, a revocation of the right. Certain mandatory conditions are prescribed in the statute or established by applicable regulation. For example, if the right is obtained for purposes of building on undeveloped land, the occupier must apply for a building permit within 6 months of obtaining the right of occupancy. An occupier cannot let undeveloped land lie unimproved for very long. If the land is to be used for agricultural or pastoral purposes, then a certain percentage of the land's area must be cultivated or stocked with cattle within a certain period of time. But the government also has broad discretion under the Act to impose, quote, any additional condition which it considers necessary or desirable to ensure the beneficial occupation and use of the land that is subject to the right of occupancy. And similar language appears in implementing regulations. So although citizens do not have the ability to alter the scope of land use rights beyond the menu provided in the Act, the government does have discretionary authority to tailor the scope of each particular right of occupancy granted. And this arguably extends the menu of enforceable interest in land beyond a discrete and limited number of categories. The administrative discretion impacts land use rights in other ways as well. Certain types of transfers of granted rights of occupancy are subject to prior government approval. Every proposed transfer must be notified to the government, and the government has the right to approve or disapprove proposed transfers. For example, the government approval is required for any assignment of a right of occupancy within 3 years after the right was first granted. Implementing regulations identify other dispositions that require government approval to be enforceable, including any transfer or sale. So these examples of administrative discretion authorized by statute and applicable to most granted rights of occupancy inject an uncertainty in the scope of land use rights. And this uncertainty introduces transaction costs into the market for land titles in a way that arguably cuts against the underlying functions and purposes of the numerous clauses principle.
Next speaker is Myra Williamson. Yeah.
It's nice. Cheers, PowerPoint, yeah.
I don't see.
Was it loaded already? Yeah. Was it loaded? It might be.
And like that, just stop. No matter what, just stop. I get you.
What's the you were? I thought so.
All right. Okay, so. River. Okay. It's not rainbow.
What button?
Yeah.
I got it.
Is it down here?
No, sorry.
Yeah. Okay. So, excellent. Anybody will be able to see, I wrote it down, so, no. I know you can't move very much, but you won't be able to see it either, I'm sure you can. Sit down. All right. Oh, yeah. Okay, kia ora koutou. My name is Myra Williamson and I am from Auckland University of Technology, otherwise known as AUT, in Auckland, New Zealand. This is for you to memorize. No. My colleague Alberto acknowledged the people of the land, and that made me go and search for what I should be saying. And I found that the University of Hawaii has a very nice land acknowledgement. So I put it up there, but I'm not going to read it out to you, but you can read it if you wish. And I have the link at the bottom. So I'm going to start today by acknowledging the people of the land where we are. And I'd also like to thank the professors who have invited me here, Professor Lee and Professor Chen. Thank you very much for reading my paper. I really appreciate you getting through that and inviting me here today. Because we're in the lecture theatre, I thought I'll just do a quick audience participation thing. You know, you're all lecturers, so you're used to people falling asleep in front of you, and how demoralizing that can be. So who knows what seabed mining is? Seabed mining. Anybody know what that is? If you know what it is, or you think you know what it is, put your hand up. I'm not going to ask you, so there you go. This is not the Socratic method here. Okay, if you know what it is, put your hand up, or even a little bit. Okay, if you would like to see seabed mining in the coastal area around your country, keep your hand up. All right, so I'm finished now. That is my presentation today. So I have 3 stories to tell you. It's going to be a very short story at all levels because of the 15-minute time frame. But the first thing is a little bit about my story.
This is my story here. I have a quick disclosure. I'm a member of the New Zealand Labour Party. I'm a left-wing person, and I'm seeking election. So anything I say has to be taken with a grain of salt. I am not neutral. But I am from New Zealand, born and raised there. And this is my pepeha, which I would normally read out to you in a New Zealand setting. So, tēnā koutou katoa, ko kotirana, me airana te whakapaparanga mai, ko kirikiri roa te whenua tupu, ko kirikiri roa kāinga, ko Myra Williamson to ingoa, tēnā koutou katoa. Yeah, so I'm from New Zealand, and the story behind this paper is that I saw a call for papers, and the conference was in Hawaii. And I said, I don't know anything about law and development. I need to find out what this discipline is all about. And I know some of you are in the same boat, so you know, tell me, I get there. I have not heard of this discipline before, but I have done comparative law before. And it resonated with me having to set up a course in comparative law in the past, and I started reading it. I bought the book, I read the book, and I said, I get this. What I want to do is I want to test a theory in this book against a situation that I'm very concerned about, which is seabed mining in New Zealand. And then I said to myself, I don't know if this is a thing. I don't know if this is the way practitioners do it. So I'm just going to put in the abstract and see what happens. And voila, here I am today. So I still don't know if this is how practitioners do it, but that's the story behind the paper. These are the threads I'm going to try to bring together. A little bit about my country, Aotearoa, New Zealand. I'm going to try to test part of Professor Lee's general theory of law and development. The second part of it, I'm going to talk about seabed mining. I'm going to talk about some legislation called the Fast Track Approvals Act, and also some other legislation I might mention, something called the Regulatory Standards Act, which had huge amount of opposition in New Zealand, with about 99.5% of submissions were against that bill, and it just became law in November. So a very unpopular piece of legislation which prioritizes property rights over just about everything else. That's why I'm in this particular panel. And then some changes have just been made to this Marine and Coastal Area Act to make it harder for Indigenous Māori to assert their customary title to the seabed. Okay, so these are my research questions. Can Professor Lee's general theory of law and development, the second part of it, provide a useful framework for predicting the effectiveness of any law to produce economic development? That's pretty much in a nutshell. And in addition, is it likely that New Zealand's growth push, which we hear on a daily basis in New Zealand, is it likely to deliver economic development? And what role would these other pieces of legislation have on seabed mining and economic growth in New Zealand? I don't have too much time to tell you the story about our country. It's a developed country. It's a free market economy, deregulated. We believe in free trade and all those good things you've heard up until this point. But we have a productivity problem. We are unproductive. We cannot seem to address this productivity problem. So that has been one of the things. And we had an election in October 2023. We used to have an amazing Prime Minister, whose name was Jacinda Ardern, but she resigned because of some COVID crazy people who were giving her a really hard time. And she handed it over to Christopher Hipkins. I think I've got a photo of him somewhere. I'm going to flick back and forth to keep you awake, okay? Because I know it's really hard. There he is. You can't see him. He's behind the chair. That's Chris Hipkins, hopefully the next Prime Minister of New Zealand. And he took over and he lost. And we got a centre-right government made up of three parties. The National Party had the majority. Plus, they needed another party called ACT, and they needed another party called New Zealand First. And so those three parties together put in all their requirements, and they got these two coalition agreements with a lot of bad stuff in them. And one of them is that we are now drilling for oil and gas. We're going to be open for drilling for oil and gas again, because some people in our current government don't think that climate change is a thing. So we're revisiting all of that. But under the previous government, we had signed up to an international moratorium on deep sea seabed mining, so we didn't want to see that happen. And under the previous government, we wouldn't have been mining our coastal areas either. But we lost National One, and now we have a whole lot of issues to deal with in New Zealand, which brings me to this guy, Shane Jones, Minister Shane Jones, the Honourable, don't know. I have to call him that because it's his title. The Honourable Shane Jones, Minister of Resources, Regional Development, Oceans and Fisheries. And if you can't see the hat, it says, "Make New Zealand great again, drill, baby, drill." Okay, he's our Trump. So I took this from his Facebook page, but I had to do some editing because there are some people who don't have much time for him. He's famous for a lot of things. One of them is that he would like to mine the seabed as well as start oil and gas drilling. And he doesn't have much time for biodiversity. So one of his famous quotes was in Parliament at question time. And he said, well, you don't know about this, but stewardship land is not DOC, Department of Conservation land, said Jones, to stay here. And if there is a mineral, if there is a mining opportunity and it's impeded by a blind frog, well, goodbye, Freddie. He doesn't care if he has to put any species into extinction as long as we get to drill and get some minerals out of the ground. So that is the context. On top of that context, I have the theory about how to determine if a particular law will bring about, let's say, economic development. So what I'm trying to do in my paper is to apply the second part of this theory to this particular scenario and see whether we are going to get the economic growth that we are desiring from it. So you may be familiar with this. I'm probably telling you something you already know. But in Lee's General Theory of Law and Development, there's part one, which is just defining what law and development is all about. And then part two is what I'm interested in. It's the causal relationship between law and development through regulatory impact mechanisms, which he shortens to RIMS. So RIMS are defined on the next slide here. There are three of them, three parts to it, essentially. And correct me if I'm wrong, just step right in here if I'm going straight. It's like delivering a lecture to your professor, you know, it's quite intimidating. So there's regulatory design, which is all about how optimally law is designed to achieve its regulatory objectives. And then that's split into three subparts. Then there's regulatory compliance, which is all about the conduct of the general public in complying with the law. Then you've got the general regulatory compliance, like how well does your population comply with the law in general? And then specifically, how well is it going to comply with this particular law? And then quality of implementation, which is about the degree to which a state meets the requirements of law and undertakes the mandates under the latter to fulfill its objectives. In a nutshell, what I tried to do is go through all of that and apply it to my facts. So yes, and then I added in a few other laws as well, the Regulatory Standards Bill, which is now an act as well. In essence, this is what I'm doing. I should let you read that for a second. What I'm trying to say is that when I use his framework, I figure out, or I come to the conclusion that I do not think that the law that has been passed, which is called the Fast Track Approvals Act, which has allowed a fast track application for 2 seabed mining projects. I do not think that that law is fit for purpose, and I do not think it is going to achieve economic growth. I do think it's going to deepen tensions between property rights, environmental stewardship, and Indigenous guardianship in Aotearoa in New Zealand. So this is our Prime Minister, meet Prime Minister Chris Luxon. He may not be the Prime Minister for too much longer. There's a lot of rumours he's about to be rolled. He's not very popular. But he's very big on mining too. And he has been pushing since January the growth strategy. The growth narrative, too fast. The growth narrative is all about increasing productivity and addressing our infrastructure deficit. And these two things are tied together. So in New Zealand, we do have a couple of problems. We have a problem with lack of productivity, and we also have underinvested in infrastructure for decades. We have a massive problem with infrastructure, mainly because, not always, but mainly because we have 3-term elections, and it's really not that popular to go and invest in something that takes 10 years to build and nobody sees it within 3 years. So we have this problem, which we're trying to solve. But the growth thing comes in here because the current government wants to use oil and gas and mining to help produce productivity, increase productivity, and produce money so we can build infrastructure, which all sounds quite good, right? There's nothing wrong with that in theory. So far, it's not going that well. Because this is, the government came in here, 2021, they came in here in 2023, and this has been the growth is not happening right now. In fact, in the year to June 2025, we were in a 0.9% reduction, so lack of growth. So the growth is not happening yet, which is one of the things perhaps you need to be patient about when you're examining whether a law has had a good effect or not. But in any case, we do have an infrastructure deficit, and the idea is you pass this act, the Fast Track Approvals Act, the FFTA, which allows anybody to put in an application for a project to get to what's called resource consent. So you can go and do stuff and build stuff without going through the really slow, rigorous process, careful process that we had in place under something called the RMA, or Resource Management Act. So it speeds everything up, and you get spades in the ground, and you get minerals out of the ground, and oil and gas start, flying into the air much quicker than would normally happen. So what has happened is that we have just some key features here. It's a one-stop approval shop, this Fast Track Act. So when the government was campaigning for election, they said, we're going to do this, we're going to pass this Fast Track Approvals Act to get things moving in New Zealand and to stop this no mentality of slowing things down. But what has happened is that there are a lot of concerns about the process. Because when a party, for example, my application, I'm going to go along with my application in a second. When a company like, for example, Trans-Tasman Resources Limited, an Australian company, wants to mine the coast of New Zealand, called the, I think I've got a map of it. There we go. They want to mine a little area out here off the coast of Taranaki. They want to suck up about 50 million tonnes of seabed material a year, and they want to do that every year for 20 years. They want to suck up 50 million tonnes, and they want to take out this thing called vanadium-rich titanomagnetite concentrate. Catchy term. 2 minutes. Oh my God. And then they want to push back 45 million tonnes into the seabed. Suck out 50 million, push back 45, and they trot off with the 5 million in minerals, right? And so that's supposed to be a good thing for New Zealand. The thing is that nobody knows the environmental effect of doing that. So that is the issue. And they haven't been able to persuade anybody that this is a good thing. This is a list I've said here, who opposes Taranaki VTM's fast track application. It's actually really about who doesn't oppose it. Everybody opposes it. This is a short list of people who oppose it. Even other commercial people, commercial fishermen, recreational fishermen, about 7 different local councils oppose it, economists oppose it, the iwi oppose it, so that's the local tribes, they all harshly oppose it. Everybody opposes it except for big Australian mining company, very keen on it. And also the Taranaki Council would like to see seabed mining banned in New Zealand. So I'm going to skip through here. We have another one. We have 2 cases. We have that one in oh my God, Taranaki. He's making this up. Bream Bay. It's a beautiful bay right up at the top of Northland, golden sands. We have another company called McCullough Brothers. They want to suck up the seabed to make concrete for roads in Auckland. Also not popular. Okay, so what I did in my paper is I went through and I used Lee's framework, which I'm not going to get to do. I'm really sorry. But you can buy the book to learn about the framework. And you can read my paper to learn about how I got there. And now I'm going to go to the conclusion. Oh, this is the opposition. Opposition from Greenpeace, opposition from locals up in Bream Bay. The Hawaii connection. So one of the things I really like about this is that the state of Hawaii has banned seabed mining in its state waters. Yes, go Hawaii. And one of my conclusions is that New Zealand needs to follow the Hawaiian lead. We need to do the same. And if we get to change the government in November 2026, then hopefully we will do that too. So I'm going to press on right here. That's a horrible thing showing you some potential seabed mining in the international waters, the Clarion-Clipperton Zone. And he's cutting me. Okay, findings, conclusions, final thoughts. Mahalo.
Our next speaker is Elizabeth Bakaminga.
Greetings to the Law and Development fraternity. I'm happy to see colleagues I also in Cape Town. Thank you, Professor Lee, and thank you all for listening to me. Today, I'm here to tell the story of the Ugandan woman, a migrant worker, women who leave their countries to go to other countries to conduct, paid employment. And the story is that the legal and policy frameworks are not sufficient to protect the property rights of such women and the case study is Uganda.
Oh, is it the arrow? Oh, okay.
Yeah, so the summary for my paper, first of all, it's grounded in Agenda 2030. We are not supposed to leave anyone behind. The focus on the people as one of the P's that Agenda 2030 is based on. SDG goals are poverty, goal 1 for poverty, 5 for gender equality, 8 work, 10 reduced inequalities, and goal 16 rule of law and institutions. So that shapes the discussion today. 48% of migrant workers globally are women. That's 150 million women. And of these, a number of millions are Ugandan, but around 500,000 are documented under the labor externalization project of the government. The majority of Ugandan migrant women workers are undocumented. They go out and overstay tourist visas, and this exposes them to a lot of trouble. So the focus of my presentation is on the Gulf Cooperation Council states, that's Bahrain, Kuwait, Saudi Arabia, and the others, as well as Jordan and the Republic of Lebanon, where these Ugandan women go to work. And the property rights I'll focus on are real estate and also the remittances, as well as money that is held in their mobile money wallets. As previous speakers have spoken about the legal pluralism that affects parts of Africa, this also applies to the rights of women migrant workers, the Ugandan ones, the patriarchal system, the triple shift where women conduct paid work, unpaid work, and emotional labor to support families and communities. I'll talk about Ubuntu. That's the principle of, the collective principle of humanity. I am because we are. And the downside is that in South Africa, they refer to it as the black tax. I prefer to refer to it as a social tax. The social tax, where if you do well as a professional, you're expected to contribute to society, to take care of everybody else in the extended family. And I say that the legal, policy, and institutional frameworks are not adequate. So what's the state of Ugandan women workers in the study area? As I said before, majority are undocumented. The government can only account for about 50%. And this exposes the undocumented workers to all sorts of problems. They are not covered under the bilateral labor agreements, and also they don't access consular services unless there's an outcry on social media that one has been tortured to death or one is held in captivity. And the considerable number of migrant women workers are low skilled. So it increases their vulnerability. They do not know when they have rights. They do not know when rights have been violated. And before they leave the country, they face high recruitment fees, which leads them to debt bondage because they're trying to pay their way to go out to work. They lose property. They're exposed to loan sharks, money lenders. People confiscate their passports, until they pay up, they cannot travel. Then there is a regime on registration of SIM cards because due to the anti-terrorism legislation, control of financial services or regulation of financial services is a requirement to register SIM cards. And the law in Uganda requires physical presence, to verify your identity. And when these women are in Jordan or Lebanon, they cannot do it. So they lose access to their mobile money wallets and they lose access to the money there. Then where they've trusted family, friends to conduct investments on their behalf, when they've sent in their money, their remittances and everything, sometimes the investments fail and sometimes the social tax takes care of the investment, because if they send in the money and one aunt is sick or a brother needs school, like tuition fees, that's the money that will be used. So the investment will not happen. Then there are issues, psychosocial issues, mental health issues. We have cases of women when they've returned and found out that investments did not work, they commit suicide. Some do not want to return to the country, they extend their stay so that they can recover what they lost. Others will simply just go back to the the destination country for labor to continue, you just work and try to make it in life. And then also there's domestic violence and economic abuse because of the money. Their status does not change, their vulnerability does not change. The money they bring in exposes them to economic abuse. So that is the state of some Ugandan women migrant workers in the study area. So some of the challenges at national level are that these women are not recognized as vulnerable. Under the National Development Plan, it's women with HIV, displaced women, the refugees, women in pastoral communities. Those have been identified in the National Development Plan as vulnerable. Migrant women workers are not recognized as vulnerable because everyone looks at the $1.4 billion that comes in as remittances in Uganda, and they think, well, they're doing well, they can afford to send this money. They do not see the vulnerability of these women. Then, as I said, that sending countries, I think, focus on the contribution of these workers to the economy and does not look at what happens. Okay, they've sent in their remittances, what happens to their property, to their investments, to their mental health and whatever. We do not have research on that. Actually, I found only one study that is one empirical study. So I believe that there is no visibility of what is happening to these women. The measures that are established by government cover the documented workers. They do not cover these women who go and are held in conditions of servitude, who lose property, who send money that is diverted and used for other means or other programs. And I say that the law is blind because we have legislation on communications, the legislation on property that requires possession, requires you have to occupy the property, the land, to use it and everything. So when these women are out of the country, minimum the contract is 2 years. So they are not around to protect their property. They are not around to use the property, and so they lose it to trespassers, to squatters, to relatives who sell it off, because most of the times this property is not titled. So it can easily be disposed of. And where they're in relationships, the law does not recognize a presumption of marriage, like cohabitation. So they do not even have that protection. Like there's a requirement in law that a spouse has to consent before property that is jointly held is transacted. But without the presumption of marriage and the opposition that is there to the Domestic Relations Bill that seeks to recognize cohabitation as a form of marriage, these women do not have that protection that a recognized spouse would have. And in terms, there's also ignorance of the law. For example, money that has been, when one loses their SIM card or their number, the money that was in the mobile money wallet is moved to the central bank and held for 7 years before it goes into the consolidated fund. Not many people know this. And especially these women who are not exposed to the law, who are not well educated, they would not know that they can claim their money from the central bank within a period of 7 years. So there's a bit of legislation. Uganda has ratified 32 ILO conventions, but it has not ratified Migration for Employment Convention, the Maintenance of Social Security, the Domestic Workers Convention. So this protection at international level is not available. You mentioned the Ubuntu, which is a double-edged sword. It's supposed to protect because we look out for each other, but then the social tax is the burden on the other side. I mentioned the legal pluralism, where we have the customary norms, which are respected even more than statutory law in some of our communities. And yeah, so the summary is that a good number of women migrant workers of Uganda have benefited, but some of them, it's a sad story. They've lost all their property. Some of them have lost their lives, mental health. And yeah, the study also showed that the law and policy exist to facilitate externalization of labor, ownership of property, but the law is blind to the vulnerability of these women, especially the ones who are low skilled, the ones who are not well educated, the ones who do not have access to legal aid, legal literacy, financial literacy, and others. There are limited studies, and there's prosecution. Some cases have been prosecuted, but they happen at a magistrate court level, and under the common law system, Uganda's common law system, it's only the High Court that is a court of record. So there is no evidence to show that in a given cycle of the judicial year, maybe 500 cases were prosecuted. Maybe that would help policy makers see that there's actually a problem. So that is a problem. And that's why I make the case for a need for more research and moving these significant issues to a place where they're documented and there's research and an evidence-based built. So my recommendations are review and reform of legal and policy frameworks. I call for a regulatory impact assessment to have policymakers look at who else is affected to avoid the unintended consequences of legislation, whether it's anti-terrorism, anti-money laundering, interception of Telecommunications Act, and all these other laws, the land laws that require physical presence all the time for one to safeguard their property. So I also call for more empirical studies and disaggregation of data to actually look at women migrant workers. I talk about legal and financial literacy, investments. So if these women can maybe invest in the diaspora bonds or other, instead of just sending the money, maybe it will make life easier. But all in all, my conclusion is that Ugandan women migrant workers contribute to national development, but they have not received the protection that they deserve. They are exposed to migration-specific vulnerability, which other women in Uganda are not necessarily exposed to, but this has not been documented or discussed broadly. And I say efforts must be made to address that if we are to ensure that no one is left behind the way Agenda 2030 proposes. Thank you.
Next speakers are Sheila Chen and Heidi.
Oh, you don't have to wear that close. Maybe this. Yeah, maybe it's not like it's not like that.
Let's start.
Okay. Yeah, that's good.
Good afternoon, everyone. I'm Shu Lun, and I wrote this paper with my friend and colleague Hai. We are all PhD students from the University of Hong Kong. Firstly, we would like to express our heartfelt thanks to Prof. Lee and Professor Chen and everyone who have ever contributed to this conference for organizing this wonderful conference, as well as bringing us to this beautiful place. Our last speaker has mentioned that how to protect the property rights of women. Actually, our research topic is quite similar because we all care about the vulnerable groups. We talk about the rights of nature and how to incorporate the protection of rights of nature in our property law system. So this is our research topic, which is asserting property law for sustainability, bridging the anthropocentric and the ecocentric paradigms. This paper has two aims. One is to propose our preliminary thoughts on our mitigated approach to reconcile human law for sustainability and especially property law. And the other is to present our.
Why just a little? It's yeah, just like that.
Okay. The other is to present a collective of our ideas which we have for now and await further exploration in the future. About like in February of this year, I came across a paragraph written by Jen Fernansky, who is a professor at the University of Toronto. She said that the idea that humans stand at the top of a hierarchy of values is still a deeply ingrained belief, even among those committed to trying to protect human well-being by combating climate change. I do not think that it can make the changes necessary to seriously mitigate the harms of climate change without challenging this hierarchy. And the hierarchy is so taken for granted that it really finds direct expression in the law. So having these thoughts in mind, I really wonder that to what extent can we incorporate the interests of nature into our private law system and especially property law system, and to what extent that hierarchy that we take for granted can be challenged or shaken. I will introduce the most of the parts of our presentation, but firstly, my co-author Hai will introduce this research background, then I will continue with the remaining parts.
First, I want to express a very quick but sincere thank you to Professor Chen and Professor Lee and everyone who organized this, all your efforts and organizing this event, and for everyone for your very insightful contributions to this conference. Me as an environmental law student, I feel really humbled to sit among these very established property law professors and practitioners. So let's see how much we can weigh in here. So basically what I'm going to give is a very brief introduction of the background that contextualize our research. So when we talked about sustainable development, can I have the next page, please? Thank you. When we talk about the sustainable development, what's inevitable to address is the conflict between environmental protection and economic development. The most common legal response to this conflict is environmental law, establishing standards of, for example, environmental impact assessment and permit issuance. But this public law approach has two main weaknesses. The first comes from how they understand the relationship between human and nature. And environmental law regulates how much pollution can we tolerate for the benefits of economic development. And for this, it normalizes environmental damage and deems it necessary to support development. And the second weakness has been discussed by many of the professors who presented yesterday, that these standards are not always consistent. For example, the courts may limit the applicability of environmental law, the government may roll back environmental policies, and the political environment may not always be supportive of environmental protection when they are in conflict, and so often is the case with
the economy. So the environmental standards are also highly susceptible to popular decisions that prioritize the economic interests of the present generation instead of the long-term environmental and ecological interest. So what can be a more sustainable means to address the relationship between human and the environment and the conflict between human development and environmental protection? In 1972, Professor Christopher Stone wrote on the right of nature theory. He envisions that slave women, children who we now recognize as equal human beings were all once understood as a property law. So he envisions why can't the same revolution be extended to nature so that the nature can be a legal person in a have a legal standing and claim their injuries in court. And this his theory, and I want to quote it very accurately, composed of three parts. The first is that the nature can institute legal actions at its behest. The second is that the nature's injuries are considered in deciding the legal relief. And the third part is that relief should benefit the nature. So this revolutionary theory has corresponded to many of the indigenous worldviews that respect nature as a deity, and also inspired the numerous rights of nature movement worldwide. So that basically is the background. And by the way, I should have talked more about the implementation problems of injecting this very ecocentric rights of nature theory into the very anthropocentric existing legal system. But for the interest of time and adherence to the focus of this panel, we will skim over that. So we will now take over here.
So I'll introduce the research gaps and our research scopes, how our research scopes will relevant to the research gaps. So the current literature on the intersection of property law and environmental protection touches upon some innovative use of property rights and development of new forms of property rights types, such as some tort-based litigations as well as protections based on constitutional rights and the public trust doctrine and other practice of rights of nature in different jurisdictions. And I summarize 4 research gaps now. The first one is the current literature didn't mention conflict resolution between human and nature rights. In other words, how can we deal with such conflicts? This is what exactly we are doing. We propose a mitigated approach in this research to reconcile human private law for environmental protections. And the second one is the current literature didn't design very content appropriate property rights regimes. This is what we are trying to do because we have generally pointed out some potential pathways, very detailed property institutions to protect the environment. The third one is the current literature didn't mention any empirical evaluations of enforcement mechanisms and what long-term ecological outcomes of those reforms may bring about. The fourth gaps is the current literature didn't incorporate indigenous perspectives to reform property law. Our research is basically based on the dichotomy of anthropocentrism and ecocentrism, which is essentially a philosophical debate. Anthropocentrism regards humans as the most important existence in this world and regards nature as only having instrumental values for humans. In the sphere of law, human interests are most important for legal considerations, for environmental for legal considerations, and natural objects such as trees and rivers are only objects of property as opposed to subject of property or any right holders in any sense. Even if people may design law for environmental protection. This is mostly out of public interest or social responsibilities of humans, as opposed to private rights of natural objects themselves. Rather, an ecocentric perspective acknowledges the intrinsic value of nature and regard nature as right holders, and they enjoy all kinds of rights similar to humans and legal standings to sue for the infringement of such rights. And just as I mentioned, the rights of nature theory, this theory is quite ecocentric and is situated as exactly the right extreme of this spectrum, because it calls for a recognition of the legal, for nature's legal standings. This is why we choose rights of nature theory as a theoretical lens to examine this issue. We can see that in the middle part of the spectrum lies in various property law mechanisms we have now in practice. And we propose this approach. This mitigated approach is inclusive from within and moderate, mainly through two directions. First is about why an uncompromising ecocentric approach is not ideal, or why a direct recognition of the legal personality of nature is not practical or not ideal. And the second one is why a complete anthropocentrism should be avoided, or put another way, why human rights should at least make some compromise to the rights of nature. For the first part, firstly, we have a comparative legal studies, which is in 3 jurisdictions. The first is the US, second is India, second is Ecuador. The second part is about private law theory. We examine the concept of autonomy, the autonomy of objects, natural objects such as rivers and trees, and draw a theoretical framework from Hagen, who is from the University of California, Berkeley, and the other is the philosopher Joseph Russ and his books The Variety of Freedom, because they all use autonomy as an building block and the basis for their theory. And for the second part, we briefly provide the novel fact-based justifications for this issue. I'll briefly talk about how we examine the natural objects autonomy. We draw concepts from Duggan's liberal theory of property and Joseph Russ' work, The Variety of Freedom, and argues that natural objects as a non-sentient existence, they do not have personal autonomy like humans, because for humans to have autonomy, humans to have efforts, which can be regarded, they do not have autonomy like that of humans, but only enjoy a certain degree of self-realization, which can be regarded as a form of quasi-autonomy and requires humans non-reciprocal duties to protect it, which means nature objects as themselves, they don't have duties but only have rights. And this right is similar to current practices in some jurisdictions, which allows the natural objects some rights to exist, flourish, and naturally evolve. We also analyze the commonalities and differences between natural objects and current different types of right holders in private law, such as companies, infants, and the disabled, to facilitate the discussion on whether natural objects should be or should not be granted with legal personalities. And we examined 3 jurisdictions and finally find that even though they adopt different forms of methods or recognize these rights, they face similar enforcement problems of this right, because they are ultimately conflict with our current legal systems. And as for fact-based justification, we proposed why we should protect the nature. First, because there is a limitation in human rationality, we cannot predict the outcome of destroying nature. Thus, we should respect and protect the nature purely out of the concern of the consequences. The second one is human and nature once coexisted historically and do not separate from each other. In this way, we should protect nature, respect nature just as the way we treat ourselves. And this is very briefly potential pathways. For example, we change the perspective to see our relationship of human and natural resources as a way of using as opposed to ownership. We use natural objects as opposed to owning them. And there are also differences between common law and civil law distinctions. And we also call for a status-based duty for the landowner, which means if you are a landowner, you will have some implicit duty to care for the land and not use it just as you wish to to destroy the land. Okay, I'll quickly give a conclusion. So this mitigates the perspective towards a paradigm shift from anthropocentrism to ecocentrism, coastal and inclusive from within, and moderate approach to reform property law system for sustainability. We do not call for recognition of legal personality, but nature is by no means as only means for humans to consume, and we call for reconsidered human nature. Thank you.
Our final speaker is Monica Ma.
I'm just gonna record myself so people don't think I'm slacking off in Hawaii.
You have pictures. Oh. Slide's better. Can't fake
Right,
it.
yeah, I'll scroll. I'll stay up here. Can you all see and hear? Does it really? Hey. Okay, well then, I'll still stay in. Okay, well first, I just wanted to thank the Lawn Development Institute and also the University of Hawaii. My father is from Hawaii, so I spent a lot of time here growing up, and it's really good to be back, especially at UH. So my presentation, my paper was on The Way of Water, which by the way, I did not watch the new Avatar movie. That is not where I got the title. Came out after I called dibs. So yeah, it's called The Way of Water, How the United States Can Learn from the Palauan System of Custom Deference. I'm basically going to be tackling a big topic at a very minute administrative level. So bear with me, a lot of mind mapping. And it touches on a lot of things that our other panelists have talked about. But it kind of looks at development from a quote unquote developing country and what we can learn as a quote unquote developed country. So I do this through two main case studies. The first one is the Red Hill fuel leak disaster. These are fuel tanks that were here in Hawaii, and they leaked. There were thousands of people affected, hospitalized from unclean water that leaked from these tanks. Later on, it came out that the military who were managing these tanks actually knew that there were issues in these tanks, that they were old, they needed replacements, updates, the whole pipeline or the whole pipe system needed a lot of help and maintenance, and they kind of pushed it on the rug. A lot of the reason for that is because there's a lot of paperwork involved, and there are other theories you can kind of guess from there. The second case study I look at is the Dakota Access Pipeline, which is in the continental United States, and specifically looking at the affected population, which is the Sioux tribe and their access to clean drinking water. And the reason why I bring in environmental protection is it's not just about the water, it's about a person's or the indigenous person's right to the water, not only as clean water for drinking and for sustainability, but also as a cultural and religious aspect, not only to water, but to land and the like. So one of the biggest hurdles, and I apologize if you know a little bit about the law here, because the state law in Hawaii is actually different than the federal law. So the state law, and you'll hear a little bit about it, kind of has my solution already, which is great, but I want to apply it to the federal level. So one of the biggest problems is when a where am I? Okay, so when a environmental project wants to be undertaken in the United States, there has to be something that's called an environmental assessment and then an environmental impact survey. So they basically just go through, look at what resources will be affected, who will be affected, and those stakeholders are then consulted. In Hawaii, it is a requirement that you meet with, for example, the Native Hawaiians to see if they are consulted and to see if their land is affected, how it's affected, et cetera, et cetera. In the federal system, that is not the case. It is a persuasive authority, but not a binding authority, and that becomes a problem later on. So here are a couple of hurdles that I'm aiming to tackle that I think this might help solve. First, in the state's federal Indian law, so that's what we call dealing with sovereign indigenous tribes. They're all treated separately as separate sovereign nations. So you can't really aggregate any administrative grievances or oversteps or the like. You can't really aggregate that into one blatant, oh, the US has a problem with doing this. It's kind of unknown, or it's kind of known, but it's not a quote, I don't know how to explain, a rap sheet of sorts. The other hurdles are that they're administrative recourse. So when you want to say, hey, you, as the government who is supposed to be managing this fuel tank, you overstepped. So what you do is you file an administrative grievance, and there's an administrative hearing, et cetera, et cetera. But these administrative hearings don't really tackle the constitutional issues of a right to clean water, a right to live and practice your religion, et cetera, et cetera. So I think one of the best ways to solve this is to implement this at a federal level, which is to say these stakeholders, these populations are not only consulted on an environmental level, how will it affect your environment, your resources, but also on a cultural level. How does it affect your population and your right to live, your right to practice your religion, to practice your culture? And how do we ensure that we are insulating your culture from future harms? So in Palau is a country, for those who don't know, I'm coming from Palau, is a country in Micronesia. It's an island country. We are about 20,000 people, so huge. Something that is enshrined in our constitution, and the first part you can read, but the second part, and I'll just read this from my little handy dandy mini constitution, is Section 2 of the traditional rights says statutes and traditional law shall be equally authoritative. In case of conflict between a statute and a traditional law, the statute shall prevail only to the extent it is not in conflict with the underlying principles of the traditional law. So what they say is, and this is how it's practiced, and I talk a little bit about it in my paper, custom, tradition, in whatever form it could be in property, it could be in wills and trusts, it could be in electing clan leaders, who is a strong member of a clan. All of these aspects of cultural law is recognized under law. We give it, it almost looks like statute, cultural law, custom. Or sorry, cultural law, what's the word for, I'm completely forgetting the word for
Constitution? Local law?
case law. It's like number one you learn in law school. And then case law.
Like an A now?
Yeah, you do. She's the only one. She gets an A. The rest of you failed. Sorry. So case law is at the bottom. And sorry, I should have prefaced. Palau has a legal system almost identical to the United States. The differences are written in their rules of procedure, in their constitution, in their case law, and it's very minute, and it's really to help solidify the custom in the way that implements or is implemented and interacts with the law. Okay. So economic impacts, that's why, the money, that's where it all is, right? How does this really affect money if you were to create more hurdles for example, building a pipeline? The requirement of compliance, it would increase production assessment and consultation costs. So it would delay the projects and increase the costs to building. It could deter investors in projects, and nobody wants that. But if you have clarity and continuity of court decisions, you really do see long-term gains through sustainable resource management and the preservation of land. And I'm kind of the opinion, yes, I understand that it will cost a little more, but really, what is the price to pay for people to have their rights? That's really it. So I will end by saying mahalo, sulan, and I have Micronesia stickers if anybody wants. So thank you.
Now we have time for questions. Absolutely.
Another very lively presentations.
Where are people getting stickers?
Oh,
we all got those stickers.
yes. You know what? I'll just put them down here.
Should we?
Oh, you can ask them. Oh,
Questions?
yeah.
The 20,000 people.
20,000.
All right, so it's a great presentation. Another sort of delightful cycle. I got a few comments. Mira, got a question, Sean. So every time it's kind of good to know that somebody actually buys my book. And I hope that's useful to explain the impact of law on institutions and development. That's the reasonable theory. And recently I got a message from somebody who says, look, finally USA learned what happened in Asia, East Asia. So, CHIPS Act, government pours billions of dollars on subsidizing manufacturing chips in the States. Isn't that what Korea did? Isn't that what China does? So finally we got it. And your theory examples, right? But instead of giving them validation, I should have said something like, it's like common sense. I example things that these countries could do better. So when Korea subsidized something back in the 60s, there was a high probability with hard work, this country can actually do better than the other countries. So does China, Taiwan. But are we going to be better manufacturing semiconductors, chips, competing with South Korea, Taiwan, and China? Or is American strength lying somewhere else, like research and design, right? Next level innovations, perhaps education, training. So I'm not sure at all if my theory of example, semiconductor chips are being an example of that impact of law on positive industrial promotion. Sure at all. I'm saying that. So perhaps that's something that to explore. Irrespective of Washington. And then question for Sean is this. So propertization is going around, essence with that. The cultural, we enjoy cultures, we enjoy inspirations, then so commercial space and the apartments. Question number one is, we know why they're doing it, to make money. And that's about economic development where massive industrialization is not the case. So when I planned out this conference in Hawaii 2 years ago, all about a panel on law and industrialization. Didn't get anything on that. And I looked into data and look, Hawaii is a great state. When it comes to industrialization, how much is it? So about it. That's reality. So I guess what you're saying, property price, cultural economy, and cultural assets kind of makes sense. So does it really help with long-term economic development? That's my question. And the second thing is that, you know, the impact it has not only on local residents, but tourists. So, you know, I was born and raised in South Korea and took my daughter in summer to experience traditional Korea, traditional Seoul. So Seoul is a huge city, as capital city of Korea, and there's a river. And River North is kind of traditional, River South is fun, a lot of young people are still there. I'm not young, so I take my daughter to North. Anything that looks like traditional Korean house, I wanted to check in there and stay a few days. I cannot afford with American economics. So, you know, very nice looking traditional Korean house will charge you about $800 at the US per night. It's possible it's a big house, so maybe more than one family check in there. But look, I mean, however hard I work in West Virginia, I'm not gonna make $800 per night. So, you know, it has some impact on travelers, that kind of price tag. I don't know what racial discrimination is going on in other economies, but this may help with economic development. What kind of impact does it have on tourists? That's my question for Sean.
So you're asking, yes, you're meaning. But it is, I just want to talk about the pronoun. It is property rights and intangible heritage.
Yeah,
Property rights.
so imposing, signing property rights to intangible cultural assets to be able to sold, right? That's the point.
Sure, okay. So let me take a stab at answering, I think the answer to both your questions is certainly related questions. And you're quite right. I don't think it's fair to say that money is the only thing driving the interest. For some indigenous communities, they don't want their, you know, some aspects of their culture, they don't see it as a commodity at all. It's something that's sacred, it should be not on the market. But for developing countries broadly, I think they do see this is something that they have a resource advantage and they want to make sure they're getting the money and not some foreign exploiter. And they see, you know, having these rights is the way to do that. The question is, and I think that's sort of implicit in your question, is sometimes it can be expensive to do things that traditional way, you know, sticking to it. That sometimes if you want to sell things widely, you have to make some compromises. Mass production or something, you outsource. There's stories about Aboriginal designs sent to Vietnam, and you know those. So there is always going to be trade-offs. People have to make these choices. Well, somebody's the choices are going to be made, whether somebody's making choices or not. So I think it's perfectly fine to say that you know, indigenous communities or developing countries should have a say in how their culture is used. But I'm not sure, and I guess my main point of my contribution is just that if you give them really strong property rights to veto it, there's a lot of questions of who's going to be using these rights, and you know how are they going to weigh all these balances and reach the right compromise. And you know, maybe in some cases they'll make the right decision, it'll be good, and long-term sustainability will be achieved. But there are a lot of unintended impacts, and it's hard to have. That's really, I'm just calling for epistemic humility, that I think sometimes there are other ways to achieve the goals of preserving the culture, that we can maybe accept a certain amount of commodification, but then invest in the authentic forms and realize there'll be a demand.
Thank you.
My comment on the comment? What you were saying sort of bring a bell with the part of your theory when you talk about adaptability to socioeconomic conditions. And I was thinking about that in the context of New Zealand too, because in the same place that they want to do the seabed mining, we were going to have a big wind farm and the wind farm can't go ahead if the seabed mining goes ahead. And I would agree that with your observation that New Zealand's strength does not lie in digging up the seabed for minerals. It lies in renewable energy, for example. That's on brand for us. And we have a strength with wind and sun and water. We should, lean into that instead of trying to pivot to something that just does not fit with our socio-economic conditions. And they will probably not be able to push it through, because even if the minister approves it, the local people will try to stop it. So I like your theory. I think your point can fit in with your theory about having a law that has to meet the socio-economic conditions that it's set within. That's my comment on the comment.
Thank you. So, Professor Page, I enjoyed hearing your thoughts and appreciated your analysis. I had a question regarding the practical implementation of your ideas. And part of it is focusing on kind of a negative example of that commodification with the Lakota Language Consortium, which is basically a group of criminals who convinced several tribal leaders to provide Lakota language materials and then copyrighted them and sold them back to them, despite the fact that those folks were not trying to commodify their language at all. And one of the questions I just had is I'm interested in hearing your thoughts on how to establish certain protections for members of these marginalized communities, many of whom lack substantial resources, when engaging with sophisticated, business savvy, and often predatory commercial operators.
Right. So I think actually this answer goes back to something that I was saying to Steve. If you have property rights, people can use them for all kinds of things. People in the community can be, seeing a profit motive themselves. It may not be the interest of the wider community. You can have other models in which property is owned collectively, and people in the community can use it. And there's all kinds of different things. I don't have time to talk about it. But I guess what I'm saying is maybe we should think about making sure everyone has access to it. Property may not be have to go up.
Please. This is a follow-on question. Mr. Peter, I'm DJ Graham, Haven Pronouns. I'm an assistant professor here, so born and raised here. Dance to love and community garden through graduation, including competition and style. Then when I worked here on my circuit, I picked up style that I can. So I loved reading about that in your paper. And I have some comments in the question and maybe some comments leading to the question. But I'll leave with a question which is maybe tied in here. Who benefits from corporatization and who benefits in your mind from modification? I think is perhaps my most helpful way of framing what I want to comment on. There's a huge research from ethnotourism that I think you could engage with. I was an anthropology undergrad, and you didn't use the word, but I think some of the concepts and some of the scholars who work in that area are cited, such as Edward Said. But I think right now, especially in the Pacific, ethnotourism is a tough area for the precise reasons you point to here. But with Hawaii specifically, I think bringing the Polynesian culture is much more interesting, for your point, than the Merry Monarch Festival. Because of course the Merry Monarch, in terms of who benefits, there is some commodification happening, but I don't think it's for the gaze of the outsider. I think it's for people who are there in their allow, actually buying from each other, buying for what they're going to create in their costumes. It's very much a local event, even tourists attend it, compared to something like the Cultural Center, which has this Mormon influence for those who don't know, and is very much for the tourists' gaze. So I think if you engage with the colonial gaze and who the consumers actually are, it might give even more layers to your analysis. And I think in complexifying modification, I'll accept because of the Merry Monarch that maybe it's not all negative, but I think that many Hawaiians are actually quite in opposition to business interests and tourism, that their voice seems missing here, and the piece that the paper seemed very much framed to this point, to the tourist's gaze and the colonial gaze. And I wonder if we bring in the local, what changes in your analysis that this.
Very busy. I agree with the comments, and this is something I want to reflect further. But you did mention, of course, the Merry Monarch tickets are a hot commodity that tourists do want. So there is this interest, and a lot of those dancers are able to dedicate themselves to that craft, partly by getting jobs in tourism. That that can pay for talents and really substantial investment they had in that tradition. So it's complicated. It's all there.
Four more questions at least, so please be direct if you can, because we have a certain amount of time. Albert.
Right, I've got two very quick questions, one for Elizabeth, one for Myra, and just a very quick comment to Shulun and I. You might want to look into some examples in New Zealand about legal personhood, because in 2014, I think we granted legal personality to forest and then later on to a mountain and a river. And there's a guardianship, which is mainly because of the Maori tribe and some government people. And I think it might be a good idea to see how we deal with preserving the rights of these natural features. Might be something to look into, to enlarge your research, because I think it's quite useful. The question for Elizabeth, just very briefly, is how do NGOs help these women in Uganda, or within the Ugandan context? And how can they play a major role, or are there sometimes limitations of the political context or other contexts? And the quick question for Myra is that I think you presented a very charitable view of the current government, not have been as polite, but in terms of if we go ahead with what is being proposed, even if there's a change of government, how easy will it be to turn back the clock with the rights that these companies will have acquired by exploiting these resources?
It's going to.
So, I understand it as a comment.
Yes,
yeah. So we can continue.
Okay. Yeah, there's definitely a role for NGOs, and in my paper, I make a recommendation on a multi-stakeholder approach. We do not have any evidence that there are NGOs taking it up, but we have individuals in the diaspora. Like, I consider myself a migrant worker, but not in that category because I work for international organizations, so I'm protected from those legal systems. But it's taken some individuals from the diaspora to speak up for these women. And so there's definitely a space for NGOs to speak up and address or try to engage on the issues that the migrant women workers face.
Thank you for the comments. I was thinking about the same thing, so it's good that you mentioned that. The Whanganui River has legal personhood, and so does a mountain in Taranaki. So that's a really good point. For me, my main concern really is that the Regulatory Standards Act and the Fast Track Act together are a really bad combination. Because if the minister goes ahead, if Shane Jones goes ahead and grants consent, and they get permission to start their mining, if you marry that up with the Regulatory Standards Act that says that if you infringe on property rights, you have to compensate, they could put the government on the hook for compensation when they really shouldn't have to compensate this horrible company that's been trying to do this for 14 years and has got knocked back at every level, including to the Supreme Court. You know, there's a Supreme Court case that knocked them back, and they have tried and tried and tried, and now they've got in through the back door, and it looks like Shane Jones is going to say yes to them. And I really do have a concern that even if we change the government will then have to compensate this horrible company if we stop them from digging up the seabed. So it could be a lose-lose situation. You lose if you let them dig it up, you lose if you have to compensate them. And it's a really big problem. And democracy, is probably the only answer, but we still might end up paying out. There's no good solution as far as I can tell. Yeah, this is what happens when you get rid of a Labour-led government and you see that segue? Did you see that? Yeah. Yeah, bad political choices. You've got to live with them. You've got to pay the price later on.
Is that it?
Vote Labour.
I'll go to politics.
He said it, not me. He said it first. I just repeated it. Thank you for the question, Albie.
Laura?
Yes, my question is for Elizabeth. So thank you very much for your paper. First a comment and then my main question. First, thank you very much for having presented such a case study. As a woman and an immigrant as well, I do feel very privileged in terms of the kind of rights, and it's something that we're not always aware of, and it makes me more appreciative of what all of the women immigrants in this room have achieved, and in what position, a good position we all are. And then my question to you is, where do you really think that the move for change is going to come from? Is it going to come just from the women in the diaspora? Is it going and like is it going to take them coming back and actually starting political action? Is it going to come from the elected politicians? Like, where do you foresee that if ever this move for the new framework that you're proposing is going to come from? And when it happens, do you think that it's going to be more of a progressive thing or more or a radical change of we have got to hear and know more and this has to change right now?
Yeah, thank you for that. I think I'll still say that it's a multi-stakeholder approach. And for the government, I think it's money. And you know, when you hear the politicians talk about the remittances and the 4% contribution to the gross, development project GDP, I think if we target the money, if we talk about how this affects it, because if the workers cannot concentrate, if they do not want to go back to do the work, or if they know that they will lose everything that they will have worked for, it affects the remittances. So the conversation has to basically be about the money. And I think that's the politicians, the Minister of Finance, the executive as a whole, but also in promoting a collective bargaining voice for the women to speak for themselves. Because where I got the evidence from is on social media. I'll go into the YouTube, the TikTok, and whatever. A good number of them are not literate. So ILO will not take those stories because they will not understand that language. But I understand the languages, so I'm able to pick the evidence. So it's to target the money, and that is for government. It's to target like the NGOs, there's some agencies coming up or organizations coming up that bring together the recruitment agencies to raise the awareness that if we don't get this right, they're going to lose their remittances and it's going to affect national development. So I see it as a broad multi-stakeholder approach from all angles.
Thank you.
Please.
Thank you. I have two questions. One for Elizabeth and stability. So, Elizabeth, I'm curious to know what's the role of the political class, especially the executive, has played in this discussion. And the reason is there's a lot of similarity between what is happening in Uganda and what is happening in Kenya. Recently, we had some shocking news exposed by the New York Times linking the president and his family, the ongoing, migrant labor migration and the violations of happening along. It comes to light that in fact the president has been doing, but he has been telling us that it is a way of reducing unemployment. Now, I'm curious to know what the role of political class in that respect. Then to Mr. David, would it be correct to say that the system in Tanzania helped to reduce fraud in land transactions, as it is, I think, during similarities again, Kenya, we are countries can say in Tanzania, that's right. It's similar to the useful system. Okay? But recently, again, we have had this recent decision by the Supreme Court, which has totally turned around the foreign system. Because it's now placing the responsibility of the investor or purchasers now, and a lot of this goes on to like investors. That if you did not do your due diligence enough, and then things started. So we had an instance where, say, this major developers have bought land, huge tracts of land, freehold maybe, even leasehold. Then years later, it is discovered that in fact that the first person who sold that land did not have a good title. And now it is on me as the investor, just just deal with it. That's essentially that's what the school is saying. But you go back as far as yes, the toilet system. We're supposed to rely on the title because it's coming from the government. So would you say the Tanzanian system helps protect future chasers of the business?
Yeah, thank you, Irene. Yeah, definitely there's been a linkage, and I think this applies to Uganda as well, that the majority of recruitment agencies or labor externalization agencies are actually owned or licensed by or through political figures, top, like First Family. The people who have access to the kind of capital required to meet the licensing requirements, and also who are able to negotiate or have access to the level where bilateral labor agreements are being negotiated. So we definitely have to engage with the political class. And how to do this, I believe, is to build the evidence, because if we conduct the studies and we have the evidence and it's out there, that will compare or makes a strong argument going against the political elite and the role they play in what happens to these migrant workers. And another angle, especially for the Ugandan case, I don't know about Kenya, but for the Ugandan case, because I follow the discussion on social media, majority of the migrant workers out there, they turn opposition. They do not want to hear anything from the incumbent, like government. They support the opposition. They claim all the unemployment, everything that happens to their property is because of bad governance in the country. So there is a very uneasy relationship between the ruling party or the government, the party in power, and the migrant workers who are considered opposition. And in the case of Uganda, I don't think they would even have a right to vote in the near future because of that very reason that they're opposition.
Just two quick thoughts. First, the statute in Tanzania requires a grantee acquiring a right from the government to register. So there is this built-in registration requirement. But I think the bigger problem is not so much with fraud, but the possibility of corruption. Because under the statute, if you want to sell your possessory right, you have to notify the government in advance. And for many granted rights, you have to get government approval. And the statute builds in a presumption that the government will approve a proposed sale, but then identifies circumstances in which that presumption will be rebutted. So for example, if the government feels like the purchase price is too high or too low, or if the grantee is viewed as already having too much land, the government can disapprove a proposed sale. And I think that administrative discretion for marketplace transactions injects a risk of corruption because that government discretion is in play. So that's how I would respond to the question.
And our final question, Thomas.
Professor Pager, just had a quick question. And I totally agree with what you said. I think it's super interesting, and as a South Korean national, and cultural power and modifying culture can not only be good for development, but also, insert pride in people, which, kind of stems the will to further their labor. And anyways, but I was really interested. So back a few years ago, I read this thing on copyright law, where this might be on the same page as what Turner asked. But for an example, like Jamaican traditional music or like Trinidad Tobago traditional music, a lot of these rhythms that are just kind of just shared among the communities of the people. A lot of the times what happens is those rhythms get incorporated into US or UK music, and then they get copyrighted, and then it just becomes their property. people or the local people don't really get to modify it or benefit off it. So like in order to kind of avoid those issues, would we need to like change the copyright laws and maybe or treaties and then allow, for an example, certain countries to claim that certain rhythms or certain, I don't know, you name them, certain like poetry, certain literature just be deemed in the public domain so that people can exploit them at the very least? Or would those countries be able to maybe implement a system where like there's a department that can say, hey, this copyright belongs to us, and if you guys are going to use it, then you have to pay us, and then society kind of like collectively enjoys the fruits of those uses. Like what would be the right approach?
Right. So first of all, I'm not sure you can copy a rhythm that's already been used. At most, you get a copyright on your particular derivative version of it, if copyright law is applied correctly. And this has been a perennial problem. You're right, Westerners come in and copyright or patent things they shouldn't get these rights to. And India even set up a whole database where they were taking the inventory of all their traditional medicines. No one can get a patent on it because the proof is already documented in this. So part of this problem is just establishing the proof. There are systems like public domain, some things public domain payant exist in some civil law systems, and that's what I believe certain African countries have this, in West Africa. Where so there are a number of different models that exist. Yeah, we talk more of it maybe at the end of our time. I'll leave it there.
Thank you. Well, join me in thanking our panel.
Wow, that was fair.
Ready to go? And then we'll go back.
We're fine.
Yeah.
Okay, well, welcome everybody to the last session and thanks for sticking around. So we have Laura.
So, Jen, it turns out I'm not the last one presenting, but I have included pictures nevertheless from the last panel, so that should help. Set up. Yes. So welcome to this presentation, which is going to cover the impact of economic preferences in public procurement. So today I'm going to do a critical assessment on the Cayman Islands as a case study. So as many of you would have heard throughout yesterday and today, I'm originally Spanish, but I am based in the Cayman Islands now. And I am going to aim at providing a locally informed and culturally sensitive presentation today. First and foremost, all of the views expressed here are only my own and they do not represent the official views of the Cayman Islands government. So in terms of the content today, I'm going to cover first the concept. I understand that even in the title, there's words that not all of you might be familiar with. Then my thesis, case study, the data, and finally leading on to the conclusions. So starting with the two main concepts of today, public procurement and also the economic preference. So public procurement is the area of the law that regulates the award of public contracts to the private sector. So this is a very touchy area for governments because all that those monies that are awarded to the private sector have to go to the best person for the job. So it cannot be your cousin just because you know your cousin and you know that he or she is going to do a very good job. It has to go to whoever can provide either value for money or the lowest price for a good service or work. And it has to comply with certain principles, namely those of accountability and transparency. Those have originally been Western principles of procurement, but today they're extended to the whole world and they have even reached the coast, the farland coasts of the Caribbean. So it's kind of giving a prize for your best student. All of the bidders out there take the exam, they show you what they can provide, how they can provide it, and at what price they can provide it, and then you award it to whoever has got the best mark with your pre-established criteria. Now here enters the economic preference. So economic preference means different things in different contexts. But in terms of procurement, it speaks to trying to award the public contracts to those bidders, those competitors that are based locally. This is made in an effort to keep the money of the contract on island and letting it circulate through the local economy so that it generates local jobs, it generates local profits, and that it stays on island and gets reinvested over and over again. So how do public procurement and the economic preference get together? Well, it means that when you defined your criteria for the award of the contract, you give a number of points to those that have got a local presence and or that conduct locally responsible, locally involved activities that benefit the local communities. So why is this important? Because we said yesterday that of course, for all of us, our topic of research is like the most important thing out there. So let me give you an insight of where I'm coming from. This has got like putting economic preferences in procurement. It represents a clash between the lowest price available out there against promoting local economies. So this is important because it has direct impact on population. It determines who gets hired for a project and who doesn't. The impact of this is actually exaggerated in small island states like Cayman or like Hawaii, for instance, and it does contribute somewhat to the Sustainable Development Goals, namely that the first one of no poverty, the 8th one on decent work and economic growth, sometimes, and to a lesser extent, industry, innovation, and infrastructure. So having said that, let's move on to my thesis. So what I'm asking is, the economic preference in public procurement actually promotes local development in Cayman? The turtles, not me, are going to provide us with the answer in a bit. So let's move on to the case study of today. So the Cayman Islands is a 3-island country based in the Caribbean. That's where this little pirate lives, and me. And essentially it's 3 tiny islands. The main one is Grand Cayman, which kind of has the shape of a hand, like so. And there is another 2, like back in the day, called lesser islands, today rebaptized as the sister islands. And they host a population of all of us all together. We're about 80,000, 82,000 or thereabouts, according to the latest census. So why do I bring this case to the forefront? Well, because I live there and I love the place, and also government is funding my presence here, so at least I have to do something to pay up for that. But also it is quite a peculiar case in terms of development because it is a British overseas territories. It runs itself pretty much on a day-to-day basis, administratively independent from the UK. Crucial point here, we do not depend financially from the UK. However, the sovereignty relies on the UK, meaning first and foremost that if Cayman does something that contravenes our international law obligations, the one in charge of addressing that, the one ultimately accountable for Cayman's compliance is the UK. So why is the economic preference in public procurement important, particularly in the Cayman Islands? Well, there's a full catalogue of reasons that justify it. So, for instance, the economic preference, when properly used, tackles socioeconomic inequality by allowing the capital to circulate on islands. Now, as you can see here, there's like, this is like a couple of pictures of what Cayman looks like. What it's most known about Cayman is the beauty of its environment, that's 7 Mile Beach out there. But also there is tremendous inequality in the islands. So there's places that look like this, and there's places that look like this. And obviously they are very different. This is not particularly representative because it's a shack, but it's actually a restaurant. That's very nice. But some houses actually do look like this, whereas some others look like this. So at least if you let the money from public contracts being recycled and recirculated on island, you do have some hope that eventually it's going to trickle down enough to bring the labor up. There is also a surprisingly amount of money on island for welfare, for basic needs from for the population that comes from charity, from volunteering, and for private sponsorships. And those are aspects that the economic preference in public procurement accounts for. So it's kind of rewarding those socially responsible conducts. In addition to that, like enacting the local preference or the economic preference in procurement can help build capacity within the islands. Cayman Islands is extremely dependent import-wise. We produce very little on island. We barely produce any food, not to the economies of scale that really makes sense. All of the construction materials have to be imported from abroad. So actually, if we leave the contracts on island, we do have some hope that there is going to be a business sector able to embrace those projects and grow from them, and then gather the experience that they need so that they can keep providing those good works and services on islands. And also, if all of this works well, it makes the Cayman Islands less dependent from other external countries and more resilient. We became very aware of this during COVID when we had our PPE imported via Miami, and well, your country, once the boat was departing with the PPE, said, no, this boat cannot leave because we need it as well. And thank God that boat had already been given clearance, and the UK actually helped us get it through. So we have learned that we have to be a bit more resilient in the long term for our own survival. So then, the next question is, how do we implement this economic development preference in Cayman? The Public Procurement Act has set up different ways of doing that. So it's kind of like a 2-tier system that at the same time contains a 3-tier system. So let me explain. There's an essential difference. One of the things you can do in order to implement a local preference in procurement is to restrict successful bids to those that hold a trade and business license. The trade and business license requires local presence on island, and there's implications for beneficiary ownership as well. That is contained in section 16.2 of the law, the one that you see here, subject to the requirement to adhere to the principles of procurement. An entity, the awarding body, shall give preference to suppliers or businesses operating in accordance with the Trade and Business Licensing Act. So it's kind of a pass and fail criteria. It's kind of a yes or no. If you're based on island, you do have a chance to be successful. If you're not based on island, not happening. Not today, boom. After that, if the entities or if the awarding entities choose not to be so radical, they can come up with a system that awards points as a function of their interactions with the islands. So the legal requirements are that how picky you are or how much information you have to ask for depends on how much quantity, how much money you are planning to award. So you'll see that the numbers look a bit funny because this is actually translated from Cayman dollars into US dollars so that it makes sense to you. So for, as you can see, for lower contract awards, there's no requirements, and the higher the amount, then the more intense information is required. All in all, we're looking at something that looks like what you have on screen, minus the pirate boat. That's my addition. So the way that they tend, like there's no official guidance, and that's actually part of the problem. But what tends to happen in most cases where awarding authorities tend to choose using the local economic preference is that they set up a system that awards either 5 or 10 points for local presence, meaning who owns the actual business, and the more percentage of Caymanians, then the more points. The economic impact, meaning in particular, where do you get your resources from? So if it's a majority of an island resources, it's 2 points. If it's a minority on an island resources because you're importing, it's 1 point. If there's no on-island resources, 0 points. And then the indirect positive impact, which in brief, it means whether you're sponsoring some activities or some people on island. So whether you're funding the activities that they want to do. So then, actually, thanks to one of my colleagues in the Central Procurement Office, he collected data that then I was able to process looking at the local economic preference. So we are looking at 53 projects over the 297,000 contract award threshold. And I'm looking at whether the economic preference actually has made any impact in Cayman. And now the journals are going to tell us, well, somewhat. Really? No, not really. Nah, it hasn't really made an impact. So what do I mean with this? In practice, the majority of the projects are awarded 5 points for economic preference. Only 5% of the projects awarded up to 10 points. So that's out of 100. It's somewhat important, but not really, as the journal was saying. And also, it didn't really make a difference for the purposes of the contract award. Price was found to be much more relevant in determining who was the winning bidder. So then, avenues to do in the future and how to improve this, it means that it does need a bit of fine tuning. Government, this is a political choice. Government needs to think about whether they want to push this forward or not. And they would need, under the auspices of the Central Procurement Office, they would need to think about who is responsible for taking decisions on whether it is used and how it is used, provide further guidance by publishing information such as the one that I presented to you today, and then considering the interactions with other laws, which, as we have run out of time, we'll leave it for another day. So on that note, thank you very much, and I welcome any questions and comments you might have.
Okay, next we go from Cayman Islands to South Korea. What did we say? Thank you so much. Well, using this.
All right, good afternoon, everyone. My name is Summer Kim, and I'm a professor of law at the University of California, Irvine. And I also direct the Korea Law Center at UCI.
Hello, my name is Thomas Chung. I'm a research associate at UCI KLC, the Korea Law Center. I'm also an associate attorney at a firm called Palmieri Tyler down in Southern California.
So we're very excited to present to you our paper titled The Unintended Consequences of South Korean Legal Education Reform. But before we do, we want to take a brief moment to thank our host and organizer, Professor Lee, Eugene Turner, and also Professor Chen for giving us this opportunity to share this work. We also want to thank all of you here. We feel like we're the last panel of the second day of a 2-day conference in beautiful Hawaii. I imagine the panel would have become a roundtable with just us talking amongst ourselves. So the fact that there is an audience, we're really, really excited and look forward to hearing the comments. Thomas is going to share with you the details of the reform, what its impetus was and what the aims were and how we fared. in light of those aims. I'll talk a little bit about evaluating the act through the lens of legal transplants, and then we'll say a little bit about the relationship between transplant and development. Yes. Sir.
So we've been talking a lot about law and development. Our theme is more so development and law. So we're looking at South Korea, which was obviously a very rapidly developing country and developed country now. And it really, there was this eye of the storm around the early 2000s when a lot of the free trade agreements were going around. And that sparked the need for a legal education reform. We'll figure out why. So first of all, there was an overemphasis on the exam-based education pre-reform. So how many of you had to take a bar exam in one form or another? Oh, wow. Okay. So most of us understand that bar exams are formatting. And I took the California bar exam with the 53% passage rate, and that, almost took the total. I'm not gonna lie. But South Korea took it to another level. Pre-reform in South Korea, the bar passage rate was on average about 5%, which was notoriously a low pass rate. And if you think the 5% is bad, on average, it took around 9 years to pass the bar exam, which meant that students, like this picture here, were spending their weekends, holidays, their mom's birthday, their birthday, in these cram schools, just studying for the bar exam. So this was also seen as a loss of intellectual capital because a lot of these students were highly able, well-educated, motivated young people who could have gone out and, help society. However, that was not the case. And also, there was another issue with an over-focus on theoretical learning in the institutional level rather than practical skills. So, to give you some context, in South Korea, pre-reform, this is how you became a lawyer. You took the bar exam, you passed, you went through the Judicial Training Institute, and then you became a lawyer, a judge, or a prosecutor. So that meant that before the bar exam, everything was theoretical. Just memorize the statute, understand the legal theories. So what that meant was for a lot of these students who didn't pass, they weren't getting any practical training. And the last one was that there was a lack of professional and educational diversity. So this is more so that the background of a lot of these lawyers were homogenous. So these were both institutional backgrounds and professional educational backgrounds. So the institutional backgrounds were usually a lot of the lawyers were from the top 3 universities, which itself is not a problem. But there was some concerns over the solidification of somewhat of a cartel in the legal industry. And also the professional and educational background, most students were law graduates because, this notoriously difficult bar exam, in order to do it, you might as well be a law major, right? So just to give you another kind of illustration here is, this is what's called a 고시촌. What that means is these are a bunch of these small studios, no bigger than a jail cell, maybe even only as big as this stand right here. And students would just cram into those places, sleep, study, eat, repeat for like 9 years. So that was obviously, causing issues. And this is a satirical illustration on a newspaper emphasizing the societal issues of just, these highly educated students just on the precipice of falling off the cliff of this big law book. So what did we do? We looked at what Uncle Sam was doing. And then we decided to implement a JD style system. And this was also possible because Japan went through a very similar transition a few years before South Korea, and they implemented somewhat of a hybrid JD system. So Korea said, okay, let's wrap up this whole exam-based system and let's try to implement something that the US is doing, which is a more practical approach. So came the reform. So the South Korean Law School Act tried to address a lot of things, but we try to boil it down to 3 main things. First of all, the South Korean Law School Act made changes to the bar exam. So in order to address the very low passage rate, what they did was they set a cap of 75% of total number of admitted students into law school that year to pass the bar exam, which was, 5 to 75, that's huge. Also, they capped the total number of attempts on the bar exam that a person can attempt. So they didn't want these repeat takers to take the bar exam 10 years, 20 years out, they said, okay, if you tried 5 times, like, try something else, you know? And the result, well, the pass rate is greater than 5%, obviously. Yeah, but it's less than 75% because obviously if you cap it at 75%, then repeat takers are going to come in, which means that there's going to be more people taking the bar exam. So right now it gradually declined to about 53%, which meant that now students are attempting to focus more on the bar exam again, rather than practical skills. And the law schools are now trying to require to provide practical courses such as clinics, mock trials, and also moot court courses. And how they're doing that is, this is also very interesting because the Law School Act itself set a quota for faculty who are practicing attorneys. And this is also a very Korean thing where a lot of the professors pre-reform were legal theorists with PhDs, not practitioners. So there was a clear divide between professors who are academics and then practicing attorneys. There weren't a lot of overlap, if any. And but you know, the Law School Act tried to address that. And as a result, yeah, there are more specialized and practical courses that are being offered in law schools. However, once again, due to the bar exam, the need to pass the bar exam, not a lot of students are taking it, unfortunately. And finally, they updated the admissions requirements and set mandatory scholarship allocations for certain schools and for certain students. And this was because a lot of the students who were lawyers had undergraduate degrees in law. They wanted to diversify that. So they said only 1/3 of the total admitted students per law school can be a law major in undergrad. And also the cap on students who receive undergraduate degrees from the same university that was hosting the law school. So they also had a cap on saying, hey, we don't want you guys to just admit students from your prestigious schools. We want you guys to, you know, really look outside the pool. And also a certain percentage of admissions fees had to be allocated towards scholarship awards because the Law School Act understood that, you know, law school is going to come with a cost and they didn't want to deter lower income students. Unfortunately, if we look at this graph here, obviously this isn't like a clear representation, but we can see that the cost of becoming a lawyer has increased compared to when the bar exam was at place. And also if you take a look at the total years that it takes to become a lawyer, we can also see that opportunity cost comes into play here. And you know, a lot of these lower income students have been deterred from entering the law field. And a lot of the students who do go to law school are from a very a selected set of universities. So you know, we're still looking into how this might develop. And now we'll talk about the transplant theory.
So as you might have taken from the tone of Thomas's presentation, high and then a little low, that was generally the reaction to the Law School Reform Acts, that it was at best a partial success and at worst an utter failure. We take a slightly different view, and we do this by examining the reforms through the lens of legal transplants. So many of you in this room are probably familiar, but this is work that's been developed by Alan Watson in the book of the same title, published in 1974. And legal transplants refer to the process of moving a rule or system from one country to another. And it is, in fact, the most common tool of development. And as Thomas described to you, in wanting to improve its legal education system, what the Korean legislature did was to take this organ from the US and to transplant it into Korean society with the hopes that we could alleviate some of the pressures of the exam, of this divide between theory and practice, and of the lack of diversity among the legal professions through this transplant. And of course, the benefits of legal transplant, I'll go very quickly, knowing that I only have a few minutes remaining, is that you can improve the quality of a previously underperforming or even non-performing organ. There's cost efficiency. You don't have to build from the ground up, but rather you can take something that already works elsewhere, make refinements. You can also implement a leapfrog strategy, right? You can learn from mistakes of the previous holder, carrier of that organ, and try to bypass some of the trial and error. You can also enjoy immediate impact, at least on the books, right? Of course, when it comes to challenges, there's a choice to be made and how and who you involved in that decision of which organ to transplant among many available options is certainly an area of contention. There's also issues of legitimacy depending on the source and the conditions under which the transplant occurred. To what extent is it voluntary? To what extent is it only one directional and not a collaborative process? And of course, there's cultural clashes and disruptions that can occur due to misfit between the chosen organ and the receiving country. I'll talk briefly about this last point. So to the extent that there's divergence, some rejection, or some development between the organ and its transplanted form and its received form and subsequent development, Watson himself saw that as a very natural process. He stated explicitly that the goal of transplant is not to create an exact replica. You're actually supposed to learn from what doesn't stick and what sticks. And we take that same view in analyzing the Korean Law School Reform Act. We see rejection, quote unquote rejection, of certain of the US elements as information rather than failure. And for those of us who teach here in the US, we know that the things that Korea was concerned about, right? Things like having to teach to a bar exam. These are concerns that the US law schools themselves are working on. So in fact, to have this collaborative process, I think is the important part of transplanting. I remember from the talk earlier today about the Vision 2030 in Saudi Arabia, the whole metric of success and codification was that there was this iterative process, right? You mentioned, company law was transformed 3 times in 6 years, and I think that is the goal here, to take what we think will do better than what currently exists and to make adaptations as we learn. So through that lens, we see the Korea Law School Act as a remarkable success. Professor Lee in his book writes about how notoriously difficult it is to implement legal education reform. That was done in South Korea in a short 2 minutes and in a short span of 2 years in Korea. And what we learned from, where there were some disappointments and some shortcomings is that there's one aspect of Korean regulatory process, which is very different from the US, which is that it is a very top-down process. Rather than self-regulate or to peer review, the Ministry of Justice, Ministry of Education has a very heavy hand in determining the number of entrants that come into the legal profession and the preconditions. But this is an essential part of Korean democracy. I had to miss a brief part of day one because there was a session at the Center of Korean Studies here at the University of Hawaii on K-democracy. And I borrowed this line from the slide of one of the speakers who said, a big part of Korean bureaucratic justice is this reliance on hierarchy and elite self-legitimacy. And so when Thomas says, we try to eliminate an elite tier to be met with only a creation of a new one, right? This is in fact a perpetuating norm in Korean society. Likewise, meritocracy is a persistent ideal of Korean society, and we rely on and trust exams to be a very objective measure of ability. And one thing that we take away is that inclusion and access have arisen as new developmental norms in Korean society. It's an evolution, moving beyond just the GDP and thinking about access, thinking about diversity, thinking about more inclusive provision of services. Lastly, I probably have a minute, if at all, the relationship between transplant and development, we see it as summarizing these bullet points here. Firstly, transplant is an important and effective tool of development. It's also an important milestone of development for both the donor country, who has something worthy of taking elsewhere, for the recipient, who's ready to receive, and who can then also take the organ and further develop it, and for the organ itself to go into this process of being transplanted in and out and to evolve accordingly. Lastly, we see transplant as an important metric of development. Seeing who gives, who receives, and how well they do in the receiving process, I think is an important takeaway as well. Thank you for your time and attention.
Okay, next from Korea, we hop over to China.
Oh, yes. Okay.
All right.
Hi everyone, my name is Louis, I'm from China, and you can call me Claudia. I was working for Peking University School of Transnational Law. This is why you see my institution on the brochure, but actually recently I moved to Turkey. Now I am assistant professor at Boğaziçi University Law School. So all of you are welcome to visit me in Istanbul. So today my topic is Chinese law and development. It's a concept introduced by Professor Matthew Arey in his 2021 article published in the Harvard International Law Journal. So my talk can address a fundamental question in the Chinese law and development scholarship, which is that how does China maintain effective governance in cross-border contexts where formal legal frameworks are weak or absent? So my argument, the argument I will develop is that non-legal norms such as diplomatic mediation, overseas Chinese networks, and technical standards are not peripheral tools, but actually strategic governance assets. So let me briefly outline what I will cover in the next 15 minutes. I will begin with the research problem and the gap I will identify in the existing Chinese law and development scholarship. Then I will present my theoretical framework centered on the normative synergy and the state, society, and technology triangle. Then the bulk of my talk will focus on 3 empirical cases demonstrating how non-legal norms operate in practice. Then I will conclude with theoretical implications and critical reflections on the framework's boundaries. So first, this slide frames a central puzzle in the traditional law and development theory. So how does China achieve governance coherence in cross-border settings when formal legal institutions are either weak or entirely absent? So this is a direct challenge to the conventional Western legal theories. So the slides identifies 3 phenomena that defy traditional law and development predictions. The first, China's remarkable growth occurred without wholesale adoption of the Western legal models, contradicting the rule of law first, orthodoxy promoted by institutions such as the World Bank. Second, the Belt and Road Initiative operates across jurisdictions with limited legal infrastructure. However, the projects proceed with reasonable coordination. Third, Chinese actors manage to organize complex cross-border activity even without the formal legal certainty that Western theory considers essential. So this slide targets 3 fundamental premises of the mainstream approach to the law and development theory. So autonomy of the law from policies, the necessity of legal transplantation for development, and idea that legality is synonymous with predictability and legitimacy. The argument is that the Western-centric assumptions cannot account for China's success. So this sets up what will likely be an alternative theoretical framework, perhaps examining relational governance, party-state coordination, or informal institutional mechanisms. So Matthew Arey's framework on the Chinese law and development focuses primarily on the defensive function of the non-legal norms. So he identified non-legal norms, but he just focused on the defensive function. So how they help China mitigate risks and circumvent the bad law. What remains underexplored is the constructive function. How do these non-legal norms transform into formal institutional effect? So my paper addressed this very issue by proposing a theoretical conversation mechanism across the three dimensions. These dimensions are first, relational capital, second, network capital, and then technical. I will present three examples of each. Despite their differences, all three pathways share a common logic, which is that normative authority derives from practice rather than legal mandate. So this framework extends the Chinese law and development scholarship from description to mechanisms, providing analytical vocabulary for understanding China's hybrid governance in the Belt and Road Initiative. So this brings me to my central argument. I argue that the non-legal norms, specifically diplomatic mediation, overseas Chinese networks, and technical standards, are not merely supplementary or gap-filling mechanisms. Instead, they function as strategic governance assets in their own right. So these mechanisms perform critical governance work in the following ways. First, they generate quasi-legal order to create predictable behavioral expectations and enforcement mechanisms that operate outside the formal legal channels but achieve similar coordination effects. Second, institutionalizing trust to build durable relational frameworks that's suitable for contractual certainty, particularly important in Belt and Road contexts, where counterparties may lack access to neutral adjudicatory forums. Third, constructing de facto regulatory frameworks. Establish operational rules and standards that govern conduct even without formal legislative or treaty-based authority. So my contribution is threefold. First, it expands the law and development scholarship beyond its traditional focus on formal law. Second, it challenges the assumption that state-based legal systems are the primary or necessary source of order, so legal centralism. And third, it offers a hybrid governance model that may have explanatory power beyond the Chinese context. So the key theoretical concept is normative synergy. So the definition emphasizes the interaction among multiple normative systems that together produce governance outcomes that are both stable, meaning providing predictability, and adaptable, meaning allowing flexibility in response to changing circumstances. So this captures the seemingly contradictory qualities that characterize China's governance approach. There are four core propositions here. First, the law acts as not center. So this directly challenges the legal centralism by positioning formal law as merely one element within a broader web of norms rather than the apex or foundation of the governance system. Second, dynamic equilibrium. So multiple normative orders such as legal, diplomatic, relational, and technical coexist without one necessarily dominating. The balance shifts contextually, so suggesting a fluid rather than hierarchical relationship. And third is a mutual reinforcement. So these different normative systems don't merely coexist. They actively strengthen each other's legitimacy and functional effectiveness. For example, diplomatic channels may enhance legal enforceability, and technical standards may acquire quasi-legal authority. So the fourth one is the governance and synthesis. The framework captures apparent paradox: centralized yet flexible, authoritative yet experimental. So this resonance with descriptions of Chinese adaptive authoritarianism. To sum up, I argue that development is understood as co-evolutionary, with the law demoted from primary driver to the ecosystem participant. To operationalize this theory, I introduce the state, society, and technology triangles. The state transforms political authority into quasi-legal power through diplomacy and policy guidance. Society, particularly the overseas Chinese networks, converts social capital into regulatory capacity through trust and reputation mechanisms. And technology embeds norms in global markets through standardization and creating de facto regulatory frameworks. All these three dimensions form a dynamic system where non-legal norms are generated, institutionalized, and globalized. So I'll give a few examples. The first one illustrates how diplomatic mediation transforms into quasi-legal order through the Malaysia East Coast Railway link case. In 2018, Malaysia's newly elected government suspended the $16 billion Chinese-financed railway project. So that rather than pursuing a costly litigation or arbitration, Malaysia appointed a council of eminent persons to conduct direct government-to-government negotiation with Beijing. So after 9 months of diplomatic engagement, the parties signed a supplemental agreement in 2019, reducing the project cost by 1/3 and establishing a 50-50 joint venture. So this demonstrates the power of normative synergy, what formal contract law could not achieve, namely the fundamental restructuring of the sovereign-backed infrastructure financing was achieved through diplomatic channels. The second case is Robert Koo. He is the some of you may know. He is the rich person in Malaysia, and he's originally from Fujian province in China, and he owns a huge empire spanning sugar, palm oil, Shangri-La hotels, and extensive Chinese investments. He's 102 years old this year, and he holds a net worth of 13.5 billion USD as updated today. So his success stems from dual embedding, so simultaneous roots in both Chinese culture networks and host country structures. He builds a Guanxi network across Hong Kong, mainland China, Taiwan, and Southeast Asia. So while strategically incorporating Malay elites into his company boards for political integration. So this validates my normative synergy framework, which is that trust capital accumulated through decades of cross-border business converts through normative effectiveness into institutional qualification. So informal social networks, once formally recognized, become strategic assets for state-level negotiations. The third example is Ethiopia Djibouti Railway. It demonstrates how technical standards function as de facto governance without legal mandate. So this 752 kilometer line opened in 2018 was the first overseas railway built with complete adoption of Chinese standards, including specifications and Chinese signaling system. So the governance mechanisms operate through a 3-stage sequence: first compliance, then interoperability, and then dependency. So critically, these standards are formally voluntary, but actually acquire quasi-legal force in practice. So it becomes the soft law regime with hard effects. And the regional implications are significant. Kenya's city railway system and Ethiopia's entire national railway networks now follow Chinese standards. What are the theoretical implications? First, this challenges the legal centralism. Second, it redefines legality as one normativity among many, with authority depending on coordination with political, social, and technological systems. Third, it introduces functional legality, which emphasizes outcomes over procedural formality. I would also like to be clear about the frameworks of boundaries on legitimacy. Is not guaranteed because parties may accept China's leadership pragmatically while remaining skeptical in the long run. And on accountability, flexibility may obscure the power distribution. And on transferability, these mechanisms depend on specific historical and cultural conditions. So at last, my conclusion is that normative synergy, the strategic interplay between legal and non-legal norms, constitutes both an under-theorized governance mechanism and a viable developmental pathway in the field of Chinese law and development study, provided the development remains subject to reflective legitimacy scrutiny. That concludes my presentation. Thank you very much.
Okay. Next we have across the Pacific, China to Brazil. So we have Professor Book here.
It's working. Thank you. Hello, everybody. I'm Gabriel. I'm a professor of economic and finance law at the University of São Paulo in Brazil. It's a pleasure to be here with you. I'd like to thank Professor Lee and Professor Chen for this beautifully organized conference and for choosing Hawaii as the place to host it. I think we all enjoyed it very much. And I'll talk to you about CBDC, central bank digital currencies. I'll try to make it less complicated than it sounds. But the reason I chose this topic is that whenever the Latin American Central Bank talks about policy innovation, we check if our wallets are still with us, right? So when governments started to study and to the ways to implement an innovative idea that's being discussed in every other country nowadays, right? So I decided to check what was happening in my country, in Brazil. And the plan is to use the methodologies employed in this paper to define a broader panorama and try to identify patterns in monetary policy. But first things first, I started with my country, right? And the main contribution that law and development theories can make to this kind of studies, that it gives us the methodological tools to identify institutional variations, right? And within those variations, the strategic and development goals that we can try to extract from that manifold institutional variation, right? So the complex landscape that we can identify in this in this confused and complicated field of monetary policies. And there's a second reason, right, for trying to identify patterns. And the reason is that if we read general papers and texts about CBDC, central bank digital currencies, sometimes we do not know if they are working with empirical realities or only theoretical models. So we should be very careful. Are they studying any earthly reality, or are they just describing technological possibilities, right? So legal approach, what a legal approach can give as an important contribution is to analyze how these policies are being effectively implemented, right? And not only talk about the general idea of what digital currency could be if all technology was employed to its full potential. But what is the CBDC? How many of you have heard of it, of this acronym, right? So, yeah, many countries, especially China and the European Union, the countries within the European Union, they are elaborating a policy for a digital currency. So national states have been conducting those studies and those plans to innovate in the way that they perform their monetary policies. Of course, there are other examples like the US with a different approach. So the Fed decided to stop any idea of implementing state-conducted CBDC. They decided to back private stablecoins, to use the dollar to back private stablecoins. But that's not what's happening in most countries, including mine, and including all Latin American countries. So state-conducted strategies, they are widespread nowadays. Basically, a CBDC is the digital version of the national currency, but saying that is not saying much, right? Because we could apply this definition to explain what electronic money is, what a credit card is, and there's hardly any innovation to the credit card, right? So, of course, a CBDC is much more than that. It's not just an electronic version of the national currency. There's something else with it. And what really differs the CBDC from older forms of electronic currency is that there is a direct legal claim against the central bank. So it is as if the central bank held our bank accounts. So as if we had direct deposits at the central bank. Nowadays, we have a legal claim against our banks, right? They owe us our money if we want to withdraw our cash. But within the CBDC world, no, the central bank would hold our accounts. It is feasible from a technological point of view, but then institutions matter, right? It's how political decisions are made that will define the process of implementation of this very innovative idea. And then we can start to see variations in the institutional landscape. Of course, there are the disruptive models and there are the conservative models of CBDCs. Let me go to the other slide, then I'll come back. When we see the CBDC types, we can verify the intermediated and the disintermediated version of the digital currency. The disintermediated version is we deposit our cash at the central bank. We have our accounts at the central bank. That implies the risk of disintermediating the whole economy. Banks would be no longer necessary. You can see how revolutionary this idea can be, right? People discuss, academics, politicians, they discuss if this is feasible. But I would say that the problem is not the feasibility. There is a great capacity of data processing nowadays, right? Central banks could deal with that. The problem, of course, is the very role of the regulator of the financial system, and if the regulator can work as a regulated entity, right? So the basic idea is that within constitutional regimes, the state and the central bank represents the state at the monetary field. The state cannot regulate and act as an economic player at the same time, right? It would play two conflicting roles. So the disintermediated version is a very interesting idea in the theory, but we don't see it very much in reality. When we come back to the earth, then the countries and the real central banks, they are studying intermediated or hybrid models of CBDCs. For final consumers of currency, of the state-issued money, it wouldn't change much in the sense that we would still have our regular bank accounts. When we wish to withdraw our cash, we go to a regular bank and we make our normal financial transfers using our bank. But the central bank is the owner of an abstract wallet that keeps track and makes compensations within the settlement system of the financial system, right? So the central bank would settle all payments and so on, but we would still have our private bank accounts. So this intermediate version is most widely accepted. But why are countries doing that, right? Is it just a wish to innovate? As I said before, central bankers are usually very conservative people. They're not. They put great value in being conservative, right? They think conservation is stability. So it's not the mere wish of innovation that is driving these changes. There are strategic goals, and that varies from country to country. In Europe, CBDCs are an answer to a rather stagnant financial structure. So with negative interest rates, you have to pay to your banks in Europe so that they keep your money, right? So you end up losing money if you are a normal investor or the holder of a normal account to open a bank account or to keep your money there. So if the central bank makes it possible to remunerate it to a certain amount, your deposits, then there would be an interesting competition. The central bank would stimulate a stagnant system. That happens in Europe. That doesn't happen in Latin America. That doesn't happen in China. When we come from Latin America, another thing we're very used to are high interest rates. So negative interest rates, it's not part of our reality. But CBDCs represent a very interesting alternative to an international payment system that uses the dollar. So if we can make cross-border payments, for example, from a Chinese bank account to a Brazilian bank account without resorting to the financial structure that we have today using the SWIFT system, for example, that would be a major innovation for cross-border payments. China started to study CBDCs in 26 or 29 cities, if I'm not mistaken. Let's not be misguided by the small number of cities, because the population at those cities represent the entire Brazilian population. So if it works in those 26 cities, it can work everywhere else. So they're trying to check if using the digital yuan is possible for direct payments. They were also concerned with private currencies, private digital currencies, and alternative payment systems like Alipay, and there are other systems that were employed there. So they tried to centralize the system. That's not the main concern for Brazil, but Brazil is also interested in checking if there are possibilities to the current cross-border payment systems. Let me go fast, right? So the Brazilian policy was to call for proposals, and most proposals that were tested came from regulated financial institutions. So there's nothing particularly subversive in proposals that came from regulated institutions, right? So they were part of the process. So I described in my paper what these proposals were, and we can see that CBDCs were in Brazil, they are rather toothless. They don't represent any risk to private banks. But the main strategic goal may be to foster alternatives to international payment systems, and also to increase efficiency in interbank settlements. So much so that there were declarations from the Chinese and the Brazilian government that the BRICS countries should try to find alternatives to the current system, right? Something happened after I sent my email to the conference. The Brazilian Central Bank suspended the DREX initiative. So I'll have to add this new information, but the main idea is still valid. So there are internal institutional reasons that determine the ongoing course of this politics, of this policy. It's not mere technological change that is driving it. Institutions and politics, they matter. And although our central bank was not particularly transparent about the reasons to suspend the DREX, which is the name for the Brazilian CBDC initiative, there is a remarkable coincidence that, well, Brazil started to negotiate with the Trump administration our tariffs, right? And after that, after the American government accepted some terms from the Brazilian government, the Brazilian central bank put the CBDC strategy to a halt. There might be something connecting these two dots, right? And this is very interesting. I'll have to adapt the paper, but this is the main idea, right? To explain how internal institutional variations are determinant for the course of this monetary policy innovation. Thank you very much for your attention.
So one more paper for today, and back to China with Dr. Bang.
Somehow I found myself as the last speaker of 2 days. So I'll try and keep it brief. So, first thing to say, thank you very much to the Law and Development Institute for their incredible organization of this conference. It's been a wonderful experience getting to listen to everybody, getting to know everybody here, and in such a beautiful location. So I really look forward to hopefully the next conference as well. So I'm presenting a paper today that I co-authored with my colleague, Professor Nandini Ramanujan at McGill University. Unfortunately, she couldn't be here, but she extends her best regards to everybody. And this paper is really looking at the impact of Chinese development financing on the rule of law in recipient states. And it's situated within the context of the dismantling and the restructuring of US aid and the concurrent retrenchment from development financing amongst OECD countries. So in 2024, development financing from OECD countries fell by 7.1% compared to the previous year. And this is coming at a time where we already have quite a significant gap in financing for the 2030 agenda. So we have an estimated, in 2022, we already had an estimated $4 trillion gap for financing the 2030 agenda. So it really couldn't come at a worse time that we're starting to see that we have this major funding gap. And this gap is being increasingly filled by China, who has recently become the world's largest creditor. It engages in overseas development financing through aid and through semi-concessional and non-concessional loans. And of course, there is also a lot of foreign direct investment by private firms. But for the purposes of our paper, we're really focused on this kind of official overseas development financing. So before I get into our main research question, I'm just going to give a little overview of China's approach to development financing with particular focus on the Belt and Road Initiative, the main criticisms, and then I'll walk you through what we found in terms of what's going on with the rule of law in recipient states. So I'm sure we've all heard over the last 2 days and within this panel, the Belt and Road Initiative. So China, like most countries, has for quite some time been engaged in overseas development financing, but it was really in 2013 when the Belt and Road Initiative was launched that we start to see this concerted attempt to export the Chinese development model abroad. And as our previous speaker noted, China has had incredible success in lifting people out of poverty. And they have done so in the absence of the formal Western notions of legality. So
it's quite an attractive model to states that don't necessarily subscribe to the liberal Western democracy or understanding of democracy. And so this Belt and Road Initiative is somewhat devoid of concerns about rule of law, governance, and legality, and is primarily focused on infrastructure. So telecommunications, digital connectivity, building roads, ports, and the like. And it's trying to revitalize the Silk Road and the Maritime Silk Road through these investments. And it is incredibly ambitious. We see over $70 billion invested by 2020, and over 147 countries have endorsed the Belt and Road Initiative. But it's also been the subject of a huge amount of criticism, mainly coming from Western skeptics. The primary criticism is really concerned with this idea of debt trap diplomacy, that China is financing development projects with the ultimate aim of trying to gain control over strategic assets. So this is one of the major criticisms. Secondly, that China's approach lacks transparency in lending practices, and that it is essentially designed to promote the interests of China as a nation and Chinese purpose. But for the purposes of our paper, we're particularly interested in this criticism that China, by being somewhat neutral as to political context, when they're just making funding decisions, that this could contribute to democratic backsliding by creating linkages between authoritarian regimes. So China, as I say, it's very attractive, the model, because of this kind of political neutrality. They are willing to lend to regimes that may struggle to find financing from traditional lenders. But there's this concern that arises from that in doing so, they might entrench these authoritarian regimes by providing them with funding they might not otherwise have access to. This is, of course, all criticisms that China denies. And there's actually quite mixed empirical evidence to support many of those criticisms, and particularly this criticism that the BRI is negatively impacting the rule of law and contributing to authoritarianism. So we have this kind of political rhetoric, politically charged rhetoric on both sides, which on the one side is denying any negative consequences for the rule of law, and on the other side is claiming that China is contributing to the rise of authoritarianism. So to try and kind of fill this gap, we wanted to look at what exactly is going on in the top recipients of Chinese development financing. So we relied on AidData's Global Chinese Development Financing Dataset, which collects data on Chinese development financing in 165 countries, worth 1.34 trillion between this period of 2000 and 2021. So during that time, the top recipients are Russia, Venezuela, and Pakistan. Notably, two of these are probably one of the most well-known authoritarian regimes in the world. So we can expect that we're going to find authoritarian legality there. The question is it worsening? Is it being entrenched further? So to measure what's going on with the rule of law, we disaggregated data from the World Justice Rule of Law Project Index, or World Justice Project Rule of Law Index, which spans 2015 to 2025. So kind of sitting quite nicely within that context of the BRI, with scope of the BRI. And the World Justice Project measures across 8 factors and 44 sub-factors. I won't bore you with going into all 44 sub-factors. You can check out the paper for that, but we'll look at these top level 8 factors. So constraints on government power, absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice, and criminal justice. And so what we would expect to see if there is indicators of authoritarian legality is a transition from rule of law to rule by law. And these are not really concepts that can be distinguished by type. It's really a matter of degree. So the rule of law is an ideal that exists across a spectrum. Rule by law of by law systems will exhibit some aspects of legality, but it won't approximate sufficiently the ideal of the rule of law. So rule of law systems are legal systems in which arbitrary power is effectively controlled. A rule by law system we could understand as a system that is susceptible to the abuse of power. So we would expect to see downward trends in constraints on government power and upward trends in the coercive power of the state. And that's essentially precisely what we saw. So there's an overall decline in the rule of law score in all three countries. And on its face, it can look quite marginal, this decline. But it's more interesting when we actually start to break down the factors and the sub-factors and we look at the locus of the decline. And the locus of the decline is found in factors 1, 2, 3, 4, and 7. And these are all measures of constraints on government power and the quality of justice. Okay, so these are our real strong indications of rule of law. On the other hand, we see that Russia and Venezuela performed best on factor 5, which is order and security. And that is essentially measuring the extent to which crime is effectively controlled and the extent to which law is effectively enforced. So it's measuring the coercive power of the state, the ability of the state to rule by law. Okay, so we're seeing that Russia and Venezuela outperform significantly on order and security relative to all other factors, even when Russia had a slight decline in the last year. Pakistan is a bit more of a complex picture because while they don't outperform on order and security, it is one of only 2 factors in which they improved. So in Pakistan, we are seeing downward trend in all of these constraints factors and an upward trend in order and security. And if we look at it together, relatively effective enforcement of law, but the quality of criminal and civil justice is poor. Okay, so what does that tell us? That the law is effectively enforced, crime is effectively controlled, but the procedures through which are happening are not transparent, they're not in accordance with due process. They essentially don't accord with the rule of law. So what this tells us is that there are subtle indications of a transition from rule of law to rule by law. We do see indications of a shift or consolidation of authoritarian legality in the 3 top recipients of Chinese development financing. But I've titled it Future Research, but really this is just the limitations of the paper. So this is correlation, not causation, right? It's much more qualitative analysis of this WJP data. And I think it has to be looked at in this granular sense because, as I said, transition from rule of law to rule by law is a matter of degree, right? It would be useful to look at other rule of law indexes. WJP is the easiest to use, but we could look at, say, the WJI or things like VDEM. Increase the number of countries that we're looking at. I think that's quite important to see if this trend is occurring across other countries. Because Russia and Venezuela are in there, it's going to, you're expecting immediately that you're going to see authoritarian legality. To monitor over time, so China started a new development initiative, the GDI, in 2022, which is really targeting poverty alleviation. So it'll be interesting to see if that's going to have an impact. And they've also started a more concerted attempt at legal development. I wouldn't call it rule of law promotion, but legal development. And more importantly, what does this mean for development organizations that are engaging in rule of law promotion in those same states? Now, Russia and Venezuela, they kind of shut off rule of law promotion in the last decade. But Pakistan, there has been a huge investment in rule of law promotion. So not by China, but by other funding bodies. So what is going wrong there that we aren't seeing gains in the rule of law over time? So I shall leave it there. And yes, thank you very much.
Finish early, so we have time for questions.
I just wanted to touch briefly on something, and Professor, I'm gonna butcher your name, Loka.
Gabriel.
Gabriel.
Yeah.
That I believe you touched on potentially the atomic bomb. That if central banks have a digital currency that can bypass the SWIFT system, that would essentially neuter all of America's sanctions. That first, and I'm wondering sort of how that has gotten into your research of sanctions.
Since I analyzed the Brazilian case, it didn't get into my paper yet because Brazil is very well integrated to the international system and is not a disruptive player. Right? Although it plays with the international diplomacy, and sometimes it works, like at the tariffs negotiation now, right? So not yet, but for many countries, all potentially disruptive effects of CBDCs, they're very significant, right? And not only regarding the international banking system, but also the existence of banks themselves. That's what happened in Nigeria, which is a very interesting case. And I was talking to Jennifer yesterday, and she confirmed some findings that we read in specialized literature. She said that there were very significant effects for Nigerian financial stability after the government tried to forcefully or immediately implement a transference from regular currencies to the digital currency. So, and there are also some good examples where the policy worked without damaging the whole economic environment, but in very small economies like the Bahamas or Jamaica, right? So they have different concerns. CBDCs, they're used for direct payments for services and not for complex economic activities, right? Not for the oil industry and so on. So exactly, but we should differentiate what kind of CBDC we're talking about, because if we take it to the extreme, it may be an atomic bomb, but this dramatic effect cannot block more specific discussions on potentially beneficial effects of a mitigated form of CBDC.
So, it was the last panel in the conference. Great presentations, also great audience. Staying through it, very impressive. So I had a comment on Korean legal education reform. I had a personal experience with it because I started teaching in law school as a assistant professor about 20 years ago. And by then, there were not that many. There are few. Number of Korean professors in the US at the time were very few. So I'm not going to name whom, but very progressive newspaper in Korea asked me to comment on it because I'm teaching in full time at US law school. So they thought that I would support this reform. And I did not. For two reasons. One, I of course knew that the hundreds of thousands of Korean youngsters studying bar exam. Some as long as you said 9 years, but if you're from elite school, usually they're smart, so they pass the bar like you. They pass the bar either during the school or just after. So actual period of bar preparation, elite schools are just 3, 4, 5 years. So it's not 9 years. So for them, it was okay system. Smartly passed the bar. And very prosperous because 5%. Come on, you're a lawyer, you said. Right. But the problem is not that. The problem was they thought by changing legal education, the Koreans will produce practice-ready lawyers on graduation. I mean, so we shown in post-graduate teaching in law school, others. Do you think there are 3L students be practice-ready after the bar? I mean, that's a scary thought, right? Yeah. So I knew that, and I asked around. I was teaching at St. John's at the time. I asked a faculty meeting, and there was not a single person who said that our graduates, St. John's is a good school, practice ready after graduation. It's not happening in the U.S. So that's the difference between institutional reality and ideal stay on the book. It's just not happening. It's not gonna happen. Second, diversity issue, right? By doing that, Korean legal practice is not dominated by Seoul National Korean University Yonsei instructor schools, but beyond, right? Well, it was a system, but at least for the first few years, you know what happened? A lot of those elite law schools would actually accept graduates from law majors. Exactly the opposite. I interviewed them and they're saying, look, I mean, you can't just leave, give opportunity for this valuable legal education for unqualified. Right? So the people who studied engineering, like social science, or from other schools than those top three, are seemingly unqualified. Those who have to take 10 years to pass the bar, we do it for 3 years. I think it's better now, but for years, there was a situation, there was a huge gap. And the second comment, I think, is on transplant. So one reason I developed the theory when I was 17 was to explain the gaps created by legal transplant. So whenever some countries try that, half the time we hear clear result failure. A lot of the cases mixed up. Again, I'm not going to explain my theory here. Solve that, but it might be going through that. And Korean legal education reform, I don't know how you guys see it. Now it's been like 20 years, right? So, it remains to be seen. Thank you.
Restaurants, people here.
I mean, in fact, you're very prescient, right? Because the things that you foresaw as being obstacles that were difficult to overcome indeed remain obstacles. But as Thomas mentioned in his portion of the presentation, I think incremental progress is what we are measuring. And to the extent that they are more practice ready than they previously were. For instance, in a week from now, UC Irvine and Seoul National University will be participating in a joint conference on pro bono and public interest in clinical legal education. I think that's a huge step forward. The agenda of that conference is, despite these reforms, we are still not there yet. But the fact that there is such a forum, that there is such interest and investment and desire to do better, I think is one indication of development and improvement. Yeah.
And it's surprising how everything that you addressed somewhat 20 years ago happened to become reality. A lot of those concerns were definitely shown, not in our studies, but also in my personal anecdotes with law school graduates in Korea. And yeah, I think the Korean Law School Act, we don't really have that in our paper, and I didn't mention it in our presentation because this was more of a floating idea, but a lot of people did think that it was a half measure to kind of allow the Lawyers Association and lawyers and the government kind of maintain their status and their prestige while more lawyers would start inundating the market. And I think those kind of concerns did create some barriers inside the act, which did kind of artificially tweak some of the intended consequences. But nonetheless, I think what you mentioned is kind of the overarching sense that a lot of people had when they were concerned about this act, because we have to think about the cultural implications. We also have to think about how Koreans view meritocracy as almost a religion. Like we think that, if a bar exam is only 5% passive, that means,
So it is 3.
Yeah. So a lot of those things, and also a lot of the myths that were created, because we had one president who only graduated from high school and then passed the bar exam and then became a lawyer and then a president, and those kind of myths of how this very poor person, had his fifth grit and hard studying and then became a lawyer and then became a president. Like those kind of stories were kind of seen as being swept away from lower income people.
Just one point if I may mention. So the lack of diversity, you mentioned that. Now, reducing diversity in academia is another thing. But once the law school itself, in the past, Korean, universities have legal philosophy, jurisprudence, international. Now, several major law schools, we are hearing that these courses have gone because they're not bar tested, right? Students are not taking it. So, friends of mine who are taking, teaching international law have 5 students, 6 students. And they're not going to hire anybody else doing that subject once my friends are gone. They're retiring in about less than 10 years. So that's another concern for academia.
Okay, we got some other people waiting to get in. Sorry.
Well, thank you. Actually, I have questions for both Laura and Summer and Thomas. So I don't know if there's extra time later, maybe. I will start with Laura. Okay. EU rules go in exactly the opposite direction and prevent clauses that award bonuses based on nationality and, of course, on any kind of localism. However, you said that only a very small number of contracts are awarded to locals, thanks to the application of those bonuses. If it were possible in Italy, I think that no one but locals would win anything. You know that I'll make you an offer that you can't refuse. Just kidding, obviously. But I wonder why such a provision in the Caymans does not bear for the hoped results. Is it because of a lack of entrepreneurship or resource or anything else?
Should I reply or
No,
would you like to formulate the next question? Right, that is indeed a very interesting question, and that opens avenues for the future. But before, let me just thank the conference organizers now that I do have the time for such a wonderful organization of the conference. You've worked extremely hard, and we all can tell the amount of hours that you must have dedicated. And thanks for the excellent location as well. That's always a plus.
Right.
So now to the question. Apologies if I didn't make it clear. Most of the contracts are still awarded to local companies because, particularly if you think about the bulk of it, which would be works, it just makes more sense to hire local people. It becomes very expensive to import workers, even from Florida, which is our closest location, so to speak. It becomes so expensive to import those workers so that they move for a couple of weeks even, that there's just an incentive to hire locally based people and then at most get the big foreman imported from Florida for a couple of days or just for the occasion. So most of the contracts still go to local companies. The added pressure becomes when it is something quite standard. For instance, pens like this, right? In which case it makes more sense economically to get a US-based contract because it's just going to be cheaper by the nature of it rather than awarding it to a local. So in those cases, it does make sense to try to promote the locals because at least that differential in price stays locally. Having said that, the point of the EU is a very, very interesting one. And that if that ever becomes a reality, which I would like to, but if that ever becomes a reality, I think that the framework for that analysis would not be Cayman only. It would be to try to replicate the EU model into a pan-Caribbean system where the jurisdictions would compete with each other. Now, I suspect that that's not going to happen anytime soon because the equivalent to the EU that we have in the Caribbean is the CARICOM, and the EU is based on integration. But CARICOM is pretty much intergovernmental cooperation where every member state would have a veto and there's actually very little areas for cooperation. There will also be, I foresee that there would also be a reluctance from the smaller Caribbean countries to participate because there would be countries like Jamaica or perhaps Cuba that just because of their size, they would tend to capture the market because they would have the resources, they would have the labor, and they would have the economies of scale as well. But it would be a very interesting exercise and definitely one that I personally would support. Thank you.
Yeah, in many ways, this is a finger comment. For Summer and Thomas. So I think it's a common question, but I'll try to. It seemed a little tautological to me to say that transplant is development and therefore in itself and therefore positive. But to Thomas's point for your portion, right, it didn't achieve its stated goals. But I don't even know if its stated goals are necessarily linked to economic development. I wonder if you could instead measure outcomes such as the cost to hire a lawyer for someone, or the number of cases with counsel which is pro se, number of cases that get appealed, right? Things that actually would perhaps go to quote-unquote economic development of a legislation, which seems different than economic development period. But I think basically trying to do that, to look at it that way, versus seeing law school as a market or law profession as a market, and then trying to see how it has developed that, which I think is the same. But it seems hard to know the quality of it. And especially if it's true that some are actually machine compared to none. I'm not sure how that metric really supports the argument pro the transplant. But yeah, I think that there's a little bit more to be done with the part 3 about saying how transplant treatment actually fit into that in itself. I'd love to hear what you think about that, or if there are any studies that do so.
No, this is a great question. Thank you, Dee. I think one of the things that you're getting to is what are the metrics of success, right? How are we going to be held accountable, right? Given that it creates lots of friction and disruption to take away what once existed and put something new in its place. And if what we are really aiming for is inclusion and diversity and access to justice, right? These are the kinds of metrics on which we should be measuring our success. I think one piece that might be missing from the Korean landscape is, and which is imperfect in the US as well, is the types of things that law schools are required to report on. And here there is a much more robust system, some of it driven by US News and other shadow ranking institutions and gatekeepers. But in the Korean market, it's similar to what Professor Lee mentioned, there's a very entrenched, embedded hierarchy of schools that are very difficult to change, right? In the same, and it may be because the small size of the country, but I think that aspect of competing on these metrics, D, which I think is an important incentive mechanism for schools to operate on those metrics or towards those metrics and to be prideful of those metrics. I think that might be the missing piece, but we do have about 2,500 more words that we need to write. So the suggestion of an additional part that incorporates this piece of, as you say, if we truly mean transplant is in itself development, can we unpack that further to say what we mean and what can we use to determine whether that development has moved forward versus remained stagnant? Yeah.
So just to give you like a dry answer to your briefly. Yes, briefly. I promise it will be brief. So yes, there are metrics that show that people are satisfied with the legal services, and that is mainly because there are more specialized lawyers. So, for an example, engineers go to law school, they become lawyers. Patent agents go to law school, they become lawyers. They do intellectual property law and provide good services. So that definitely does show in both quantitative and qualitative kind of surveys. And but we really appreciate your point on looking more into the actual outcomes rather than saying that here's the reality and then just trying to leaving people hanging. But yeah, thank you for your
comment. A question for you two as well. So it's fascinating that Korea adopted a JD plan with regard to open the legal profession, and the JD was created in the US to close the legal profession.
The irony, yeah.
Highly recommend if you haven't read George Shepard's The Innovation Racism in the ABA Standards, detailing how graduate legal education was designed to get the wrong people out of the legal profession. And also, and reform movement in the US is the opposite, which is to reduce attempts, like Sam Espenberg's Brandeis Cardozo plan said that you shouldn't have to graduate from law school to take the bar, you should require for 2 years of law school. As a way to reduce the costs. And so, which fits with Watson, right? Since he said transplants, you don't have to serve as any purpose. Like you thought about this dichotomy between the US reform movement pushing in the exact opposite direction ineffectually so far as the Korean reform movement pushed. And then for Gabriel, some similar spirit question. The whole point of digital currency is for many people is to get the hell away from central banks. And the idea that central banks are creating digital currency is kind of like, it's mind-blowing. I don't know if you have any comment on this junction between the original purpose of digital currencies, which was I don't want to be involved with central banks, because central banks now
Sure, I love this. Yeah, thank you so much. I think that it's important to recognize, right, that another irony is, the US is a common law system, Korea is a civil law system. And so to sort of think of it as the most viable or recommended organ to transplant in light of those distances there was some skepticism for these very reasons. And also the other missing piece, I think, in the Korean context is that in the US, there is this also 50 different states competing, right, for students. And there's a state involvement in thinking about who should be eligible to sit for the bar exam, right? And to what extent we can create some flexibility in different pathways. That just does not exist. As we mentioned, it's a very top-down hierarchical approach. So in some ways, I think that sense of control that the government had in being able to dictate who could come in and who would then remain outside. To Professor Lee's point, the whole idea of needing a quota for the number of people who were law graduates of certain schools was because of this very recognition that but for the quota, we would be perpetuating, right? This system of a very homogenous group of people entering the legal profession. That's all I'll say. I realize it's the two of us, so we double up and are eating away at the little time that we have remaining. So the next one, yeah, go ahead.
Yes. Thank you for your comment, Professor. I think that's fabulous because while I was taking the bar exam, everyone was saying that in the library. This is hazing. This is arbitrary gatekeeping. This is crazy. But I think in Korea, in some sense, it's interesting because the low passage rate was kind of a very strong attempt to keep the wrong people out. And now this is a less of a strong attempt to keep the wrong people out, but it's still an attempt to keep the wrong people out. So yeah, I think there's definitely more conversations needed.
Well, thank you for your remark. I think it corresponds to what many specialists think about CBDCs. The well-renowned journal, The Economist, for example, they call the CBDCs a solution without a problem, right? So why do we need it? But anyway, there are different types. We are here talking about retail CBDCs, digital currency directly available to the public. And many states started to think of it as an alternative to crypto assets, right? Private crypto assets, because they represent what many central banks fear the most, to lose control of the monopoly on currency. And that's what led to desperate measures of the Nigerian government. I mentioned them again, because they are a good case to forcefully implement the CBDC, because the national currency was being strongly developed by the public resorting to crypto assets. This is a very drastic case. This retail form of CBDCs, however, they are not the most common form. So the wholesale, so a digital currency used for interbank liquidations, this is, in my opinion, what we see and what we can expect from CBDCs at the real world. And there it can be useful somehow, right? But the retail form, I agree with you. I think sometimes too far-fetched, if not unconstitutional, when the central bank starts to remunerate deposits and compete directly with private institutions.
Sorry.
Thank you. Hi, so my name is Iris Tian. I'm assistant professor from Shanghai University of Finance and Economics. I also have a question for Professor Kim and Mr. Tan, if that's possible. So I currently teach, coach for our law school's Newport competitions. And your speech reminded me of my experience. I was coaching students. So for instance, what we typically do is that we select, we select the best students. Typically, if they're college freshmen and we're, junior, second year law students. By the way, the law schools in China are undergraduate. So we train them very well, and then they typically have very good English skills. So they keep participating in those type of competitions again and again because those are highly competitive. And because of language barriers, and also sometimes because they're younger, because they're undergraduate, so typically you have very few students keep participating in those type of programs, forever. Whereas it's not accessible to a lot of other students, So, but my gut feeling is that, because of this situation, there the Chinese law programs are undergraduate, and sometimes because of we want to emphasize the equality of college entrance examination because to keep the education fair, and that's the single most important thing in China, right? So basically the students have a very single purpose before the education, before the college entrance examination, just to excel. So after that, the students, the education is kind of like a continuation of the high school mode. So it's more like professors lecturing or students receiving in passing manner. But I feel like, the Newport competition is similar to, it's originated from the US apprenticeship. Try to train students in practical settings so that there is a smooth transition when they go to workforce. And I feel like this type of resources should be accessible by majority of the students, especially those students who need it the most. But in fact, we only select the students who are already good, with interpersonal skills, English speaking skills, that. So this brings about the question of, the collage between the meritocracy and also equality in education. That's something that I'm curious about all the time when I really coaching students, and I feel like I should be, we have the incentive to do well. The school has incentive to excel in those competitions, and it's also the same for the lecturers and also lecturers and students. But it's, if we keep this way, then students who need it the most will not be able to have that access to those real resources because that's not, it's very limited, right? We have to basically make a lot of efforts in time and put our time and efforts to educate students, sometimes in our spare time. So just curious, what is the Korean's approach to address that question? Thank you.
Yeah, so thank you for your question. And so in the Korean Law School Act, the legislator said that told the law schools, the 25 law schools, the selected law schools, that for the admissions fees, for all the admissions fees that you collect, at least 20% of that has to be allocated for scholarship. So that was concerns about higher education fees. And obviously, when we think about, I assume it's similar in China, but in Korea, when we talk about approaching higher education, it's not just about paying to go to college, it's the cram schools, the tutor fees, like buying all those books, buying an iPad, all those things are also, it's just before you go into law school, there's also so much cost that's associated with prepping for that process. So the legislators were aware of that. But like I said in the slide, it's not really materializing, unfortunately. So a lot of the law students as of last year are from upper kind of middle class family backgrounds. So it definitely shows that there is kind of the ladder being cut short. Yeah, and that's also something that the Korean law schools and the legislators should think about. I hope that answered the question.
Yeah, so just a one quick comment. So I think that's a little bit different in China. It's not like the US style. I don't think China is gonna introduce a US style education because it's we don't have as many lawyers as we want. And also because it's undergraduate level, it's not professional school, it's not graduate school. So the students are, the educations are relatively cheap. So but with it's not based on the I guess the finance and all that. And it's only one single metric is your score. So yeah.
Yeah, and I think the concern of the Korean legislators were like the score itself, yes, that is like a very dry cut showing of the merits, but also that may be associated with your financial backgrounds because if your parents are making a lot of money, you may have access to better tutors, better cram schools, more time to just focus on your studies. Whereas if you're from a lower income background, then you'll have to have a job. You might not have access to some of the books or the tutors or the cram schools. So I think like the score itself, obviously in Korea, we do have a strong belief that that is the most faithful metric of someone's merit. But there were concerns about how the financial backgrounds were also kind of asymmetric at the same time. That makes sense.
I see, Iris, your question as getting to, what is the professional responsibility of educators, right? Is it to take those who are already very qualified and make them even more so, that make our institution, right, a very competitive and outstanding institution? Or is it to take where we can make the most progress, right, and dedicate our limited resources to those can benefit the most, right, and grow the most? And I think that's a really important and cultural and social decision, which has its own trade-offs. I don't know that the law will change it. I think the non-legal norms is what then creates those motivations. It's people like you who think about that and struggle with that, right? And say, I don't want to just use one metric. I'd love to interview these students. I'd love to measure their post-grad, like some of the things that Dee was talking about in terms of how we want to think about success. I also think, there's a longer conversation that we can have, perhaps in the courtyard. Yeah, thank you.
Right, we have one more minute, so last question.
A question for Francesca. I was just wondering, when you were talking about this transition from rule of law to rule by law, I was thinking what impact can that have on sustainability, environmental protection? Is it something you're going to be looking at?
I don't think we're going to look at that directly in this paper, but I think this is a very important question. And it goes back to the idea of, is the rule of law an end in itself or a means? And I think, if you adopt the kind of Senian perspective, then the rule of law is an end that we should be pursuing for its overall good. But most people view it as a means to economic development, sustainable development, equal participation in these systems. So I think the next step would be to look at, are these countries becoming more economically developed, sustainably developed in the absence of rule of law? Because that is the Chinese experience. But the kind of premise of the paper itself is that the rule of law is something that we should be pursuing in and of itself. I think then the next step is to look at its relationship to other factors. And this relationship, when you see China, it's subtle shifts towards formal legality as the country develops, as it opens up. And I think, China shows there's not one pathway to development. So I think, the next step is I would like to see what is then going on in other metrics alongside the rule of law in those countries.
I don't agree that China does not follow the rule of law path. I just think the Chinese way is to make it more flexible to achieve the goal. So of course, we are steadily promoting our own rule of law scheme, but also we're we are facing some pressure from the Western world, so we are kind of circumventing that kind of norms. So trying to develop our own norms and to set up our own international order based on it's not to rebuild a brand new one, but to based on the current international consensus, and then to build up a Chinese way to approach this. So like for the Belt and Road Initiative, China have established the AIIB, Asian Infrastructure Investment Bank, which is total using the legal norms. This is international obligation, and it's all based on the member states' consensus. It's based on the international agreement. But beside that, China also has our own. It's called Import-Export Bank, which can sponsor the members from the BRI scheme to based on bilateral negotiation to negotiate what kind of loan interest you can get from China from this bank. So this is how China approached the international order with the Chinese characteristics. Not only the to recognize the existing the international order, but also have the Chinese way. But it's not that we are not having the rule of law at all. Just we are having more paths to achieve it. Just a clarification.
Okay, well, we can continue the discussion.
Richard.
Not too soon. Yes. Yeah, 2 times. Not the agenda. Yeah, expression. Yes.
Oh, yeah, I don't know what it's doing. Yeah, she wasn't. Weird.
All right, so it's almost done. A few more minutes. All right, so it's incredible, right? 2 days conference. I'm sure many of you are tired, but we're staying. So many of you have praised our conference, but I praise you back. I mean, this is an incredible audience. I could be more proud. So thank you. Okay, speakers. I think I've done like 13 conferences. Thought I've seen enough. But I'm learning from every new conference. Speakers always bring new perspective, new insights on it. So this time, I didn't imagine that Korean legal education reform would attract that much interest. And I will, announce our next conference and talking about the possible panels and local host in Sydney. So we should talk about, law and development education. I was thinking, okay, who's interested in that? But there might be some interest in it, right? So again, thank you for the speakers, audience. Also, I mean, it's great questions coming from you. And I started doing this in 2010 to spread the awareness of law and development. It's about a scholarship and practice that can actually utilize laws and legal institutions. Including the possibility of broadening the approach, as Lewis said. And it's taken its results now. So I'm seeing that people are getting understanding. And every conference I concluded with a sense of gratitude. And this conference as well. And location help. And I'm so grateful to our co-host. So a lot of credit should be given to Professor Richard Chen. He's been doing this for now 2 years and finally got to it. So thank you again.